Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland Assembly Plenary, Programme Sound. This is the Northern Ireland
Members, before we move on to the first item on the order paper this morning, just want to make the point that Standing Order 18A2 requires written copies of statements to be made available at least half an hour before the statement is delivered in the chamber. Obviously, the statement arrived in this morning at 11:37, so being a little bit late and given the topicality of the issue and the fact that it's the first item on the agenda, I propose to suspend the House for 10 minutes to give people extra few minutes to read, I think, what is a 10-page statement. So the House is suspended for 10 minutes. Thank you. Before we resume business on the first item on the order paper, I just want to point of order, Colm Gildernew.
Gorma Agat, Ceann Corlia. I would like to draw your attention to an issue that arose in this chamber last Tuesday. Mr Allister made assertions about me which were completely unfounded and untrue. When he realised that I had not attended the Thomas Clark's game, he then made further assertions that were equally unfounded and untrue, that I had attended a public gathering. I would like to ask that these assertions be withdrawn and apologise for unequivocally in the same manner in which they were made, and I would like to ask the Speaker to rule on that issue.
Okay, thank you, Mr Gildernew, for that point of order. I will consider that later today, and then I'll come back to you, and or Mr Allister if needs be. Okay, and just a point of order, Mr Allister.
I understood I had apologised to Mr Gildernew for the false allegation.
I've just said
the record will show that I withdrew it and apologised.
I've just said I will consider the matter and return to it later. Thank you. In terms of Speaker's business, just want to make a point that the First Minister and the First Minister will take the oral questions today on behalf of the Executive. The Deputy First Minister is unwell and unavailable to attend, and I'd like to extend our greetings and best wishes to the Deputy First Minister. On that note, I have received notice from the Minister of Justice that she wishes to make a statement. Before I call the Minister, I remind members that in light of social distancing being observed by parties, the Speaker's ruling that members must be in the chamber to hear a statement if they wish to ask a question has been relaxed. Members do still have to make sure their name is on the speaking list if they wish to be called, but they can do this by rising in their places, as well as notifying the Business Office or the Speaker's table directly. I remind members to be concise in asking their question, and this is not an opportunity for a full debate, and long introductions will not be accepted. Minister.
Thank you, Mr Speaker, and can I apologise to yourself and to members that the statement was late in being issued to you this morning. There was no discourtesy intended, but there was a drafting issue at our end for which I wish to apologise. Members will be aware that on the 22nd of September, the Public Prosecution Service announced that the convictions of 15 individuals for certain sexual offences prosecuted between 2009 and 2017 are to be set aside as a result of an historical legislative error which caused them to be invalid. Before I set out how this occurred, first and foremost, on behalf of my department and the criminal justice system, I want to express my deep regret that this has happened and to apologise to the victims who are at the heart of all of this. Since taking up my post as Justice Minister, I have endeavoured to improve the experience of victims and witnesses in the criminal justice system. This motivation is at the core of the changes I am driving in the department. I am acutely aware that because of this error, some victims are receiving news, bringing them to revisit past issues which are painful and personal. That, Mr Speaker, is a matter of profound regret. I know that they are being assisted through this difficult time by Victim Support and by Nexus. I am grateful to both of those organisations for working closely with the Public Prosecution Service in supporting them. The individuals whose convictions are being set aside were tried and convicted in the Magistrates' Court. However, a technical change in the law, made in error and prior to the devolution of justice, meant that a small number of sexual offences could only be prosecuted in the higher Crown Court. The removal of certain sexual offences from a schedule to the Magistrates' Court Northern Ireland Order 1981 by the Sexual Offences Northern Ireland Order 2008 and earlier legislation in 2003 meant the Magistrates' Court lost the legal power to try those cases. Since 2009, 15 prosecutions resulting in convictions covering affected sex offences committed between 1973 and 2009 were sent to the Magistrates' Court in error. All were convicted without the necessary authority. As a result, the Public Prosecution Service will be making an application shortly to the courts to have those convictions rescinded. In effect, it will be as if the conviction never happened. There were 17 victims of these offences. 14 are victims of indecent assault on a female, contrary to Section 52 of the Offences Against the Person Act 1861. One is a victim of indecent assault on a male, contrary to Section 62 of the Offences Against the Person Act 1861, and 2 are victims of the offence of unlawful carnal knowledge, contrary to Section 5(1) of the Criminal Law Amendment Act 1885. Each and every one of these victims had the right to expect better from our criminal justice system. Those convicted received sentences which stretched from fines and community service orders to suspended sentences and probation orders, with one receiving a custodial sentence. I should stress at this point that there is no question of any of these cases resulting in a miscarriage of justice. Article 45 of the Magistrates' Court Northern Ireland Order 1981 permits the summary trial of a small number of indictable offences with the consent of the accused. In other words, selected offences can be sent to the lower magistrates' courts, which have lesser sentencing powers and do not involve juries. The offences which can be dealt with in this way are listed in Schedule 2 to the 1981 order. Members will be aware that these issues relate to legislative changes which predate the devolution of justice matters. Consequently, it is not possible to be certain of all of the circumstances. As I understand it, in 2007, Northern Ireland Office Ministers wished to consolidate sexual offences law into one statute and align offences and penalties with England and Wales. This resulted in the Sexual Offences Northern Ireland Order 2008, which was prepared over a 7-month period between October 2007 and April 2008. During the preparation of the order, a number of sexual offences were replaced and consequently the pre-existing offence was repealed. One such offence was the Section 52 offence of indecent assault on a female. The repealed offences were removed from the list of offences contained in Schedule 2 of the Magistrates' Court's Northern Ireland Order 1981 as a consequential amendment in the 2008 order. This meant offences committed prior to the 2nd of February 2009 could no longer be tried in the Magistrates' Court. Normally, draft legislation includes supplementary, consequential, transitional and saving provisions. All but a saving provision was included in the 2008 order. This removal of Section 52 from the 1981 order without provision for summary prosecution for historical offences appears to have been an unintended drafting error. There is no recorded discussion or correspondence specifically on the subject of removal from Schedule 2 of the Magistrates' Court order of these old or repealed offences. There is very limited record which indicates forewarning was given to police and the prosecution service of the policy intent to repeal all existing sexual offences, apart from the trafficking offences which were to remain in the Sexual Offences Act 2003. A record exists of an inquiry made in December 2007 at the request of a legislative draftsperson, specifically asking whether either organisation perceived or identified a reason not to proceed in that way. On the limited records available, nothing was received indicating or highlighting the need for a saving provision to retain summary prosecution as an option for offending conduct covered by the repealed offences, but which occurred before the proposed order came into force. All new legislation goes through a process whereby ministers set the policy direction, policy officials draft instructions to Council, which are then checked by legal advisers, and Legislative Council then prepares the actual legislation. The legislature which scrutinised the legislation prior to becoming law was the Westminster Parliament. In this case, it is clear that the consequences of the changes made to the 1981 order were not identified by any of these people or organisations. The draft order was made in Parliament on the 9th of July 2008 and the relevant parts of the order were commenced on the 2nd of February 2009. After the legislation was passed, the PPS, relevant judiciary and legal representatives all proceeded in the belief that the Magistrates' Court option was available for suitable cases. Normally those of a less serious or grave nature and where the more limited sentencing powers of the Magistrates' Court were deemed appropriate. The issue was raised in 2012 when it was concluded that a saving could be implied. However, that approach was reviewed in 2018 and following further legal advice, it was determined that this was not the case. PPS contacted DOJ officials in early 2019 to say they had identified that there was a potential problem with the removal of Section 52. At this point, it was unclear whether there was a significant problem or not, and PPS sought the advice of Council. The focus of PPS at that time was on whether future proceedings for offences contrary to Section 52 could be brought in the Magistrates' Court. Following receipt of this advice, it was concluded that the Magistrates' Court did not have the legal power to try historic indecent assault offences committed prior to February 2009, the date of the commencement of the 2008 order, and that all future prosecutions for indecent assault could only proceed in the Crown Court. The PPS subsequently sought further advice from Council in relation to the validity of the convictions obtained in the Magistrates' Court after the Section 52 had been removed from Schedule 2. It was, having received and considered that subsequent advice, that the PPS concluded the convictions could not stand and steps then had to be taken to set them aside. PPS also carried out an exercise to identify all of those cases where it had prosecuted Section 52 offences since 2009. An initial search of its database produced a large number of cases that were potentially affected, and these then had to be reviewed manually in order to confirm the correct position in respect of each of them. My department was informed by the PPS at the end of February 2020 that the further work done had both clarified that there was a definite problem and identified the cases affected by the removal of Section 52. They also noted the need to explore whether any of the other offences removed from the schedule had prosecutions undertaken since 2009. PPS also explained that it had instructed staff not to issue any new prosecutions summarily for the affected offence. Senior management in the department were alerted to the issue in early March 2020 and engaged with PPS about the steps that needed to be taken as a result. At that point, the plan was to take all necessary steps by the end of June 2020, but the lockdown for COVID-19 led to some delays. The department's legal advisers carefully considered whether any other offences were similarly affected, and further offences were indeed identified. This in turn led to a further scoping exercise by the PPS to establish if summary prosecutions had occurred, and this identified one conviction under Section 62 of the Offences Against the Person Act 1861 and two convictions under Section 5.1 of the Criminal Law Amendment Act 1885. The PPS also carried out an initial evidential review of the cases identified, as it was recognised that fresh prosecutions could still be brought by the Crown Court. Any fresh prosecution will be made in line with the PPS test for prosecution, which involves an assessment of the prospects of a conviction and also the public interest in bringing the offence and offender before a court. An important aspect of that will be the views of the victims themselves on what should happen next. The initial review was commenced by a senior prosecutor within PPS and will be completed when all relevant information, including the views of victims, is available. It would be inappropriate for the PPS to conclude the review of the cases without having taken the views of the victims or before the existing convictions have been set aside. In advance of contacting the victims, PPS asked for PSNI's assistance in establishing the current addresses for victims and defendants so the victims could be contacted to confirm their up-to-date details and to take their views as to how they wish to be contacted, including whether by letter, in person or email. PPS recognised the sensitivities involved in this initial contact, particularly with victims. Clearly, it is critical in a situation like this to have the full picture of all the potential difficulties. Both my department and PPS were concerned that the removal of repealed offences from Schedule 2 of the 1981 order without a saving provision may have occurred for other offences, and consequently the department commissioned a legal audit to identify other similar problems. The audit identified a further 11 offences that had been repealed and removed from the schedule, including a further 2 offences removed as a consequence of repeals in the 2008 order. Some offences were removed as a consequence of repeals dating back a number of years. Only one other offence was removed from the relevant schedule of Magistrates' Court order without policy intent, and that occurred in 2003. The list of offences identified was forwarded to PPS at the end of April 2020. In May, a search of the PPS database was conducted for prosecutions under the additional repealed offences. At the end of May, PPS informed the department that it had completed the analysis of the number of cases which had been inappropriately prosecuted in the Magistrates' Court and would further review the case files to confirm where action was required. 2 additional Section 5.1 offences were identified and are included in the total of 15 affected cases. I was first alerted to the issue on the 16th of June. I was advised of the current position, that PPS had confirmed there was a problem regarding prosecution of a number of historical cases, and it was reviewing case files and considering options on the best way forward. In August, my officials met with PPS, who advised that while the review of case files was still continuing, they were developing plans to inform victims. PPS indicated its intention to engage with Victim Support NI and Nexus NI to gain their advice on how best to engage with victims and to ensure that those affected could be given effective support and counselling throughout the process. Their overriding aim was to minimise any distress or re-traumatisation of the victims. PPS also indicated that it would seek the views of victims before undertaking the public interest test. No decisions on re-prosecution of the defendants would therefore be taken until some time after it had informed victims and given them time to digest what has happened. Following an update in the meeting, I spoke to the Director of Public Prosecutions on the 20th of September. Like PPS, my main priority was and is to ensure that victims should be protected. I'm very grateful to Victim Support and Nexus for supporting this work. They have been most helpful in assisting with the communications that issue to victims and stand ready to support any victims who need advice, support and counselling through these difficult times. Shortly after my conversation, PPS confirmed that its final review of cases had confirmed there were 15 cases involving 17 victims. Once confident that all relevant convictions had been identified, PPS began the process of notifying victims and defendants last week. The senior prosecutor responsible for reviewing the cases personally telephoned the victims to advise them that the convictions of those who had committed the offences against them were no longer valid and that a letter would be delivered by courier the next day, setting out the circumstances in greater detail. Whilst he was not able to reach all of the victims to speak to each one of them, letters were delivered to 15 out of the 17 victims the next day. Efforts to contact the remaining 2 victims are continuing. He advised those victims he spoke to that he was happy to meet them and discuss the situation and its implications once they had time to consider the letter in detail. Some of these meetings are already arranged and it is expected that more will follow. Victims were also advised that Victim Support and Nexus were available to help and named contacts were provided. I appreciate what a shock it must have been for the victims of these offences to receive this news, and I sincerely regret that they have had to go through this process. I realise there has been some criticism of the delay in addressing the error once it had been recognised. Once the error was identified as a potentially serious problem, there were a series of steps to be gone through to assess the situation. I have already set these out in the statement. It was critical that at the point of announcement, the full extent of the problem was established and that the PPS had identified precisely which cases and which victims were affected. A premature statement could have created unnecessary concern and distress for a wider group of victims who ultimately would not have been affected. As I have said, my first concern is the victims affected by this error. I'm assured that mechanisms which PPS has put in place will support them, and I have asked one of my senior officials to keep a watching brief on developments and to keep me fully informed. The Department has also instructed the Office of Legislative Counsel to prepare a clause in the forthcoming Justice Miscellaneous Provisions Bill to reinstate the relevant sexual offences to Schedule 2 of the 1981 order, where the offending conduct occurred before the 2nd of February 2009. This error is most unusual. I have therefore also asked one of the Department's senior lawyers to prepare an analysis of the factors which may have contributed to it, and to develop a quality assurance check mechanism which can be built into our policy and bill development processes covering all future legislation. I will provide that analysis to the Justice Committee when it has been concluded. I understand that the PPS is also reviewing its practices and procedures in relation to the introduction of the 2008 order and what followed, and will bring a briefing on this in due course. The cases which I have referred to today are, to the very best of our knowledge and after considerable research, all of those which are affected by the error relating to pre-2009 cases left off Schedule 2 without the saving clause. I started this statement by emphasising that my primary concern was for the well-being and protection of victims affected by this error. I trust that the efforts of the PPS and my department have made to support and assist them in these difficult circumstances have assured members that we are taking their welfare very seriously. It was right that we worked through this matter carefully to ensure that we established the full facts, and the PPS was able to engage with victims when it could provide them with detailed information and answers to their concerns. Thank you, Mr. Speaker.
Okay, I'd like to thank the Minister, and I call Paul Gibbon.
Mr. Speaker, my concerns, obviously, first and foremost, are with the victims who will undoubtedly have been re-traumatised as a result of this failure that has taken place. I want to put on record my appreciation for the Minister coming today and also acknowledge her apology. The Minister was not responsible for this error, but she is responsible for how it is addressed. And I am disappointed that the Public Prosecution Service were the ones first out on this issue rather than the Minister last week, as I believe, as head of the criminal justice system, it should have been the case last week that it was the department fronting up on this, particularly in light of the PPS's statement, which indicated a failure on departmental officials as a result of the failure. That said, this statement raises even more questions. An issue first raised in 2012, then again in 2018, this issue is raised. Then it is confirmed as a definite problem in February of 2020 this year. Senior management only told in March of this year, and the Minister then told in June. I am shocked that it only got elevated to the Minister's desk until June of this year, and therefore the announcement that a departmental lawyer is to carry out an analysis of the factors and to look at quality assuring this going forward, I don't believe cuts it. And at a minimum, we need to have an independent investigation and accountability clearly taking place. The Criminal Justice Inspectorate should be called in by the Minister to investigate her department on this issue, because public confidence has been undermined and needs to be restored. And I would ask the Minister to reflect on that request for the CJI to be brought in.
Well, Mr. Speaker, there are a number of issues that we need to unpick. First of all, as people will be well aware, it is not as simple as me taking control of these issues. The Public Prosecution Service is entirely independent of the Department of Justice. We have absolutely no locus or vares to speak on their behalf on any matter, and therefore it was entirely appropriate that they should have been the people to raise this, because the error was a prosecutorial error. And whether or not that prosecutorial error could be traced back to an omission in the legislation is a separate and different point. But the error in itself was about prosecutorial decisions, and the decisions that will be taken from here forward will also be decisions that will be taken by the PPS and not by my department. I would also gently remind the member that it did not just not happen on my watch, but it did not happen during devolution of policing and justice. So it is not as simple as saying that my department should have lost confidence from the general public. That is an unfair representation of the facts. The Northern Ireland office made these changes to the law. They would have, like any other order in council, be scrutinised in Westminster, and many other parties in this chamber will have had MPs at that time who would have an opportunity to take part in that scrutinising process. Indeed, this legislation would have been formulated at Privy Council, and some parties may well have had members of Privy Council at that time who failed to pick up on this process. So I think it is a bit much to say that confidence will be lost in the department. We take this entirely seriously and appropriately, and we have handled it in the proper way. However, for us to speak before we knew all of the facts would have placed more victims in danger of being distressed than was absolutely necessary, and that for me had to be the primary concern in all of this.
Again, I call Linda Dillon.
Can I just, like the members before me, first of all thank the Minister for coming to the House with this. I had an urgent oral in, but I'm grateful that the statement was made. Obviously, we did get it a bit late, which made it difficult for us, I suppose, in terms of asking questions. But I also want to place on record the fact that our deepest thoughts today are with the victims. And this will no doubt have had a devastating impact, not only on them, but on their families. Because when something like this happens, it doesn't just impact one person, it impacts everyone around them. So our thoughts are with them, and I'm glad that they are getting support, and I hope that that support will continue and that they will get all and any support that they need during this process. Can the Minister just outline for us how she will ensure that excuse me, justice is upheld in those cases where it is decided not to pursue fresh prosecutions, and how we can lessen the impact or minimise the impact on the victims of those cases where there are new prosecutions? Thank you.
Well, as I made clear in the statement, it is unfortunate that the convictions in question are to be set aside. However, those convictions themselves are not in question in terms of their veracity, which obviously creates a significant issue for the victims of those crimes. We are currently trying to support victims in terms of the work that we are doing to support them with the trauma of this decision, but their views will be taken into account by PPS when it comes to the point of deciding whether or not these offences should be re-prosecuted. Many of the offences, people will have served, if you like, their complete sentence for those offences already. That will also have to be taken into consideration when a decision is made whether to re-prosecute or not. So there are a number of complex decisions that need to be taken, but those decisions will be decisions solely for the Public Prosecution Service, and they are not decisions that I can be involved in, because that would bring a political element to the prosecution which would be entirely unacceptable. We have discussed with the Public Prosecution Service some of the issues, if you like, that flow on from this with respect to other elements of public protection, and we have worked through those as well so that we can provide reassurance that public protection is not being compromised in these cases. But nevertheless, it is correct to say that if victims decide that they wish to go forward in terms of re-prosecution, and if that is the final decision of the PPS, they will need all of the support of Victim Support and the other agencies in order to support them through that period.
Bradley.
Speaker, thank the Minister for coming here today making the statement, and I would also like to go on record to thank Victim Support and Nexus who are stepping up in this regard. I do note the timeline, and I notice that the change happened in 2009. The issue was raised first in 2012. It isn't clear who or how the issue was raised in 2012. Was that at departmental level at that stage? It was further raised in 2018, and alarmingly it took until 2020 before it arrived at the Minister's desk. If the Minister does not intend to include CJI in an investigation, can she tell me what level of investigation she does intend to seek at this time?
I think that there are a number of issues that we need to address. First and foremost, an error was found in 2018 when a court official undertaking routine work with ICOS, the court record system, came across an anomaly. So that's when it was established in 2018. A record was labelled as hybrid, that it could be tried either summarily or on indictment, where it should only have been triable on indictment according to the ICOS schedule. Court Service raised this with PPS, and the error was then identified, albeit that it was not immediately clear whether or not this was a significant issue. With respect to how it was found in 2012, I don't know, is the honest answer. We don't know. But we do know that PPS at that time were advised that this was not a significant issue that would cause any concern, which is why it was then in abeyance until it was rediscovered in 2018. In terms of the length of time that it came to take to me, I've set out in detail the amount of work that had to be undertaken and also the responsibilities for that work. Because the issue here is that it wasn't brought to my attention until if you like, the views of the department were integral to being able to move this forward. We then worked quickly in terms of actually identifying if there were any other potential issues around that particular section and indeed other parts of that Act to ensure that we weren't going to go public with something which would then have a drip, drip, drip effect with more cases coming forward over a period of time. I understand that it is very difficult, and I'm giving as full and frank an account as I can. You've asked in terms of inquiry into the issue and how that will be handled. We have conducted a full inquiry into this. My focus is now on ensuring that we will be able to prevent that reoccurring again. The problem is, of course, that I'm given as full a frank an account as I can of what happened in 2007, 2008, 2009. Many of the individuals who were involved in these original decisions are no longer available. The Northern Ireland Office no longer has responsibility for justice. We now have a new department, and many of the individuals who would have been there originally doing the scrutiny are no longer in politics. So it is actually quite difficult to establish with any more certainty than we already have. And I don't believe that further inquiry into the matter would necessarily yield additional information. I'm very clear, and we're very clear what happened. We're not clear why, but we are clear what happened, and we are also now acting to ensure that that cannot happen again and that we minimise the risk of any repetition. So I think that those are the two most important things we can do at this state of remove from the original events.
I call Doug Beattie.
Thank you, Mr. Speaker, and I thank the Minister for coming and giving us this statement. This is as bad as it gets. Without a doubt, our thoughts have to be with the victims who will have been re-traumatised again by this serious error, and the statement is littered with victims being first. But the reality is PPS knew about this in early 2019. Your department knew in February 2020. You were told in June 2020, and yet victims were not told until September, and only days before the media were told. We're not even giving them the opportunity to be able to come to terms with what had happened. These delays are due to a slow labouring justice system which is not fit for purpose. So can I ask the Minister, is the reality not that the PPS and the DOJ ensured that they had minimised reputational damage before releasing it and putting victims first?
Mr. Speaker, I really fail to understand the tone of the question that has just been put. I have explained in detail why this took so long to reach the public domain. It was clear once we spoke to some victims that there would be a risk of it going straight to the press, and therefore it was important that we spoke to all victims simultaneously, so that no victim would find out via the press what they should be told individually and privately and have time to digest. So the reason that it was not spoken of publicly had nothing to do with reputational damage to my department. Let's be clear, my department was not involved in this incident. And the suggestion that we would put reputational damage to the department ahead of the victims, I think, is a scurrilous thing to say in terms of my approach to this. It took time because this was a novel error. It was not clear whether that error would actually affect the virus of the Magistrates' Court in these cases. They had to seek senior Crown Counsel in PPS to ensure that it would. There was then a complex process required to identify those cases where there may be an unsafe conviction and to make sure that no other similar errors had occurred. So any suggestion that there was undue delay, I think, is genuinely unfair, both on the PPS and, I would have to say, on my own officials and my department. In terms of the justice system, for any member of this Assembly to stand and say that based on 17 convictions, however serious, having to be set aside, that of all the thousands of convictions, that the justice system is simply no longer fit for purpose, I think is really an unhelpful public message to be giving. This is a very limited and a very clear error that happened. We are accountable and we are being held to account for it, and that is right. We are also informing the public of it, which I think shows that the justice system is fit for purpose, because there can be no better test of the justice system than admitting its mistakes when it gets it wrong.
Again, I call John Blair.
Thank you, Mr. Speaker. And can I also take the opportunity to thank the Minister for the statement, which I think deals ably with the seriousness of these problems, but also addresses the fact that they originate from a time prior to the devolution of justice. Can I ask the Minister, in relation to actions that the Department of Justice might be able to take now, what considerations are being given to whether or not offenders can seek compensation for being convicted in the wrong court, and if they can, would that be fair?
Well, I thank the member for his question. It would be my intention, were any of those who were convicted correctly by the Magistrates' Court, but in the wrong court. If they were to try to seek in any way to be compensated for loss, we would resist that compensation claim. We do not believe that this is a case that these offences were not committed, or that there was a miscarriage of justice where people were found guilty who were not guilty. We simply believe that people were found guilty in the wrong court, and therefore we will be resisting robustly any attempt by those who were involved in this incident to seek compensation in future.
I call Paul Fruit.
And thoughts and prayers must go to the victims of these crimes today. And it's no surprise to us, any of us in this House, about the failures of the NIO, past and present in that regard. But we're here about the here and now, Minister. And it's very clear from your statement that you were first alerted on this issue on the 16th of June, even though department officials knew as early as 2019, and PPS contacted DOJ officials again in March 2020. 3 months later, you were informed as Minister. Now, was that because it was convenient for the Justice Minister not to know this? And if so, what does that say about transparency and accountability of this place to Northern Ireland? And then it takes the Minister, the Justice Minister, having been fully informed, a further 3 months to address this issue in this House. What does that say about her failure to provide this House with the transparency and the accountability that is so badly needed and so badly needed in reform?
With respect to the second part of the question, I make no apology for not bringing this to the House before today. I respect this House, I respect its members, but my first priority was the victims. So with all due respect to the member, I believe that they had the right to know before he had the right to know, and it was on that basis that I brought the statement today. With respect to how long it took for it to be brought to my attention, remember that in 2019 it was identified that there may be an issue. And if you read the statement carefully, I was notified when there was an issue, and we were clear that there was an issue. So the investigatory work was undertaken, but I was notified at the point where we knew that there was an actual problem. Because remember this previously, in terms of the advice that had been given, was that it was not a problem. So further senior counsel advice was sought. When I was made aware of it, the reason that it took me 3 months to come here was all set out in the statement. It was important that we knew exactly how many victims were affected, that we knew that we had checked for other similar errors, and that we were able to say with confidence that we were able to contact all of the victims affected. I think that that is the correct way, Mr Speaker, for us to handle these issues. The Assembly has a crucial role in terms of scrutiny and accountability, but the justice system is ultimately accountable to those who pass through the courts. It is accountable first and foremost to the victims and to the perpetrators, and to ensuring that we deliver justice. And that had to be the first priority. As soon as those were indicated and dealt with, then I was in a position to come to this House and to make the statement and answer questions today. To have done so preemptively would have meant victims potentially being in anguish, not knowing if their case was affected or not, or alternatively hearing in this House through broadcast media that their case had been affected. And I'm sure that the member on reflection will agree with me that would have been an absolute travesty.
I call Emma Rogan.
When does the Minister intend to have discussions with victims to assess whether they want to go through the stress of fresh prosecution proceedings?
Because of the nature of these offences, I am not aware of the victims' names, I am not aware of the victims' details, and it would not be appropriate for me to be so. The Public Prosecution Service, along with Nexus and with Victims Support, will have those discussions with individual victims about their individual cases. Public Prosecution Service will weigh the views of victims against all of the other prosecutorial tests that they need to make before they decide whether or not these prosecutions will be taken forward again. But it will be with the consent of victims that they will be discussing their views and taking and giving appropriate weight to that as they move forward. I will not, to be clear, be part of those discussions, nor would it be appropriate for me to be so.
I call Gordon Dunn.
I too thank the Minister for coming here to make this statement today. Can the Minister give us an assurance that proper processes and procedures will be put in place to stop recurrence of this critical breakdown within the legal system? A proper equality management system would have stopped this failure and reduced the risk of such a major incident.
Member for his question, and I absolutely believe that it is vital that we have a system in place which checks for these things. I don't think there's a single person in this House who would demur from the truth of the fact that during periods where we have no devolution, there is less opportunity for scrutiny. There is less clause-by-clause consideration of bills. I mean, to put it in context, most orders in Council in Westminster are dealt with as secondary legislation in Westminster. At most, they'll get an hour and a half on the floor of the Chamber, and it will be simply yes or no to the order in Council. It won't go through a committee stage. It won't go through the kind of scrutiny to which we would give that order. But that will become primary legislation in Northern Ireland. So there is an issue, and it is one of the reasons why I am so reluctant, even where it may speed things up, to ask Westminster to legislate on our behalf. Because by bringing the legislation here, by bringing it to the Assembly and through the committees, there is clause-by-clause consideration. That is not to say that it is impossible that such an error could ever happen again, because of course human error can happen. But I think both the PPS, in terms of the work that they are doing to review their procedures and practices, and also the work that the Department are doing in terms of looking particularly where we are rescinding pieces of legislation or replacing pieces of legislation, that we have a continuing clause in terms of historic offences. All of that work is being undertaken. I'm at a loss, Mr. Speaker, to recall any similar error getting through the system since the devolution of justice, but I am absolutely determined that lessons will be learned.
Again, I call Gemma Dolan.
Good, Corlia, and I too thank the Minister for coming here today. Can I ask the Minister, is it true that one convicted sex offender has been removed from the sex offenders register as a result of this error? And if so, can you indicate what steps are being taken to mitigate any potential risk to the public as a result?
In terms of risk to the public, this is clearly the first question that was on my mind when we had discussed about the number of victims and what was going to happen, and it is very important that we look at this carefully. As you're aware, in terms of the cases in question, there remain 2 individuals on the sex offenders register. I think the rest, to the best of my knowledge, have been removed because their time on that register, there was only one other person, I think, and it was their time, but I will confirm that with officials. There are, I suppose, a number of safeguards, and so I want to run through those safeguards. These will be removed from the National Police Computer Database and therefore would no longer be disclosed automatically on an Access NI check. There are 2 further safeguards that are available in those circumstances. Firstly, if the individual was barred from working with vulnerable groups as a result of that conviction, the bar will still stand and would be disclosed by Access NI checks. And secondly, the Police Intelligence Database, searched by Access NI, would highlight information was available about these individuals. Access NI would then refer the application to the police, who have the statutory authority to release information for inclusion in the certificate, even where a conviction has been set aside. The Chief Police Officer of the police must reasonably believe that information to be relevant to be included in the certificate. And so there are checks and balances in place to ensure that as a result of this, the public will be protected. The PPS has also carefully reviewed all of the cases, which are historic, dating back to offences between 1973 and 2010. The question of risk is also one of the factors which PPS will have to consider when making decisions about further prosecutions. 2 of the offenders are still on the sex offenders register and will go off it when the prosecutions are rescinded, around a year or so before they otherwise would have done so.
I call Alan Chambers.
Thank you, Mr. Speaker. Certainly, I concur with the Minister's remarks in her statement that our first concern is for the victims. Can I ask the Minister, have her departmental officials been able to establish an estimated cost to the public purse of potential compensation claims from offenders perhaps exploiting unlawful detention claims and the cost of a package of retrials. Now, I appreciate in an earlier answer to Mr Blair, she gave us an assurance, and I welcome it, that the Department will robustly resist any such claims. But the fact is that these claims from offenders will probably end up being financed and funded by the public purse. So it's and it would appear on the surface that they would have quite a strong case, but I hope that it is resisted. And also, just do any of these cases fall outside the statute of limitation for retrial? Thank you, Mr Speaker.
Well, starting first with the final question, it is not my understanding that that would be the case, but we can certainly confirm that in writing to the member if that would be helpful. The 17 offences which on conviction resulted in penalties ranging from a £250 fine to 1 custodial sentence will be rescinded in due course, and as a consequence any of the offenders could seek the return of fines or any compensation ordered to be paid to victims, and they may use the courts to seek compensation for their conviction. I can say, as I did in response to John Blair's question, my department will robustly resist any such compensation claims and will indemnify victims returning any compensation awarded. I'm conscious the error which led to these convictions being rescinded was a technical one and did not affect the conduct of the cases themselves. I understand that more than half of those convicted actually pleaded guilty. With the cases rescinded, the convictions will be struck down and the offence removed from the offender's criminal record. It's then a matter for the PPS, as would always be the case, to apply the prosecutorial test to determine whether there should be further prosecutions. The consideration of cost will not form part of that determination.
Thank you,
Mr Speaker. Thank the Minister for coming to the House, albeit I think it's regrettable that there was no indication on Friday that the Minister was coming to this House in regards to this particular matter, and it may have been as a result of urgent orals that have been submitted that has actually meant that the Minister has come. However, could the Minister confirm if her officials or PPS officials have been in discussion with the PSNI to establish whether there are any risks for offences currently being investigated or indeed being prepared for submission to the PPS?
My understanding is that there are no such cases because the particular issue with these offences were around historic offences that predated this, and I'm also intending through the Miscellaneous Provisions Bill to add back in that historic issue. So were any historic convictions to come forward, they would now know to prosecute them in the Crown Court, so there wouldn't be the same issue.
Call Philip McGuigan.
Can Collier, and I, like everybody else, thank the Minister for coming before the Chamber today, and I note her determination that lessons will be learned. I also note in her statement that she has asked a senior lawyer within the Department to prepare an analysis of the factors that may have contributed to this for future legislation. Can I just ask, are there any remaining legislative problems as a result of the changes which led to these convictions being rescinded, and how, if there are, will these problems be resolved?
As part of the work that the PPS are doing at the moment, they are looking at their policy and practice around the implementation of this piece of legislation and also other pieces of legislation to ensure that there are no other errors that have been missed in this way. Because these are prosecutorial decisions, the Department would not have sight of that, though we would be aware where pieces of legislation have been rescinded. And that's one of the reasons why I have asked someone in the Department to look at providing a mechanism going forward that will prevent similar changes being made without the appropriate alerts being sent to those who are actually responsible for the prosecutions. As of today, we are confident, as much as anyone can be, that we have identified all of the cases affected by this particular issue. And obviously there will be, as I say, a review in PPS and a review in the Department to ensure that there is no repeat. But also, on the very slim chance that there may be other similar cases, we will look at that, but it would not be in relation to this particular issue.
Paula Bradshaw.
Mr Speaker, Minister, how will the rescinding of these cases affect the Access NI records relating to these offenders, and will possible future employers be told?
In respect of Access NI checks, it is obviously going to have an impact in the sense that the convictions will no longer be on record. However, as I explained, there will be the opportunity they won't be on the National Police National Computer Database, so they won't be automatically disclosed. However, if the individual was barred from working with vulnerable groups, that barring will still stand. And secondly, the police intelligence database search by Access NI would flag up if there was information about an individual in addition to a conviction that needed to be considered, and that would allow the Chief Constable in question to make that information available to Access NI if someone were applying for a job with those checks. So we believe that there are protections there. Obviously, we would prefer that those convictions did not have to be set aside, but unfortunately in this case we believe that they will have to be set aside, and in that case my concern is that we don't have any risk to public safety created as a result of that choice.
I call Roy Beggs.
Thank you, Mr. Speaker. And the Justice Department seems to be problematic. They can't even deliver a written statement here on time, and we're having to disrupt. So I welcome your decision to allow more time for us to read the statement before asking questions. But this debacle has resulted in 17 victims being re-traumatised. Our actions should be focused on the victims and also protecting the public. The Minister has indicated that she's bringing forward a new Justice Miscellaneous Provisions Bill. Can I ask the Minister, will she be bringing it forth so that it will act retrospectively and not only correct this action for future cases, but can it apply retrospectively to put this right, to protect re-traumatising victims, to protect the public, and to avoid considerable cost to the public purse in running additional court cases once more?
Well, I thank the member for his question, and I can reassure him that the Justice Department doesn't have particular problems. This problem doesn't stem back to the Department for Justice, and so I hope the member will be reassured by that. I can confirm my department did look into the possibility and sought legal advice on a retrospective fix to this particular issue. While there is a presumption against retrospective legislation, it can be achieved by deliberate legislative action through primary legislation. However, such a course would have to be assessed for its fairness, and any such legislative change would not be deliverable before 2022. It would have been unconscionable to sit on the issue for a further 18 to 24 months, and the PPS had a responsibility to advise defendants and victims of the situation and move quickly to resolve it. Consequently, a respective amendment would not have helped. However, it is our intention to reinstate these matters back into the system, as it was never intended that these offences would not be able in future to be tried in the Magistrates' Court. In the interim, offences will be able to be still tried in the Crown Court.
I call Steve Egan.
Thank you very much indeed, Mr. Speaker. And may I thank the Minister for her comments so far. I was struck just to the comment she just made there about Access NI. And she said, believed, I think, they would provide a degree of protection. But there are no sort of safeguards or guarantees within this, in particular since it's out with the normal legislative process. So will the Minister take full accountability and responsibility in the event that the safeguarding is not provided, despite what she believes?
Well, to be clear to the member, we have checked, and I'm stating clearly there are two safeguards available. First, if the individual was barred from working with vulnerable groups as a result of their previous conviction, that bar would stand and would be disclosed by an Access NI check. So that is the first safeguard. Secondly, the police intelligence database searched by Access NI would highlight that information was available about these individuals. Access NI would refer the application to the police, who have the statutory authority to release information for inclusion in the certificate, even where a conviction has been set aside. The Chief Officer of Police must reasonably believe that the information is relevant and ought to be included in the certificate. So the member is asking me to take responsibility, first of all, for a decision made by a Chief Constable, over whom I have no authority on operational matters, to take responsibility for a decision taken by Access NI in terms of the screening process. So what I can say is what is the factual situation with respect to what's in place. But what I can't do is tell the Chief Constable of the day how they would proceed and whether or not they would judge those issues to be pertinent. However, I would find it hard to believe, as I am sure would the member, that they would not find these issues pertinent in the context of someone applying for a job, particularly if that job involved access to vulnerable individuals.
I call Rachel Woods.
Speaker, and I thank the Minister for coming here today, and I would also like to express my thoughts with the victims of crimes affected by this error. And I hope the Minister agrees with me that this will come as a further blow to trust and confidence in the system on the part of victims and wider society, and we must accelerate the Gillen Review recommendations as part of this. But Minister, with regard to the safeguards in place for those who have maybe been on a register, as you discussed earlier, have victims been assured on this, and what conversations have you had with the Chief Constable on this matter?
I have had no conversations with the Chief Constable on this matter because it isn't a matter for the Chief Constable. I have had conversations with the PPS in order to determine that we are giving victims all of the information that is required. I had a lengthy conversation with him about the need to protect victims from additional distress, and also the need for, where it was necessary, when the prosecutorial test had been undertaken, for these decisions to be re-prosecuted where that was in the best interests of the victims. I think it is important that you recognise the limitations of the Justice Ministry. I can't direct the Public Prosecution Service. There may be those who wish I could, but I can't. Neither can I direct the Chief Constable. Again, there may be those who wish I could, but I can't. So what I can do is have discussions with them and put victims at the heart of what has to be done in this, and that is what I've sought to do. With respect to Gillen, I absolutely concur that we need to move forward on Gillen, and that is why we have an implementation plan which has been shared by the committee, and that is why, as part of the miscellaneous provisions bill that is due to come to the committee hopefully in the new year, we will be focusing very much on taking forward the Gillen recommendations, because I recognise that of all of the offences, sexual offences are some of the most sensitive and difficult cases that we will ever have to deal with in the system. They are also complex and often take a long time to resolve, and that in itself can be traumatising to victims. But when we end up in a situation like this, where people have been through this process and then find that those convictions are overturned, that is yet another reason for people to be anxious about bringing forward their case. I want to reassure victims that of all of the cases that have been tried, this is a very unique and specific error, and I would ask members to caution themselves before they try to make this sound as though the whole justice system is in disarray. You do victims a disservice when you go down that road. This is a very specific and narrow issue that occurred before the devolution of justice. There is no evidence that a similar issue has occurred since the devolution of justice, and I think that people need to take some degree of balance and perspective for the sake of victims, if for no one else.
I call Jim Allister.
Minister, you say the department has conducted a full inquiry, and in your statement you say the issue was raised in 2012, but you've told the House you cannot tell us by whom or with whom it was raised in 2012. If you know it was raised in 2012, surely you must know who raised it and with whom and with what consequences. And secondly, is there any DNA which will have to be removed from databases as a result of this?
Well, with respect to 2012, the issue was first raised within the PPS, so not with the department. So it was first raised within the PPS. I don't know who within the PPS raised it or with whom they raised it in the PPS. I suspect that at this stage many of those individuals are no longer there. But that is my understanding. The review that my department has undertaken is of legislation, because that is where we can undertake a review and do have the information available to us to be able to feed back into this and make sure that, for example, when the PPS were notifying victims, that they had considered all the potential other offences that might have been caught up in this error. So with respect to 2012, I don't have that information. in terms of who said what to whom at that time. Information before that period is even more scarce because it would be held by, I suspect, the NIO, if it is even held at all. With respect to DNA on the database, that will have to be reviewed, but no DNA would be removed before decisions are taken whether or not these cases are to be re-prosecuted, and that is something that will have to be looked at in the round.
Call Claire Sugden.
Thank you, Mr Speaker, and I thank the Minister for coming to the House. This is a grave error. We pursue criminal justice not least to provide closure for victims of crime, and unfortunately this has opened up a very sore wound for them. And I would ask the Minister to consider compensating their loss from the pain they have suffered now and in the future with the conclusion of this process. Can I ask the Minister to clarify the purpose of the clause in the forthcoming Justice Provisions Bill? Is she concerned that there is a vulnerability within the system and this is to protect from any future grievance or mistakes?
Well, first of all, if a victim decides that they want to pursue compensation as a result of this, they will, of course, be free to do so, and the normal processes will apply, and they will have the support of Victim Service NI to be able to pursue that option. With respect to why we are adding it back in, actually, the reason that we are doing it is because there are good grounds why some offences which attract lesser sentences may want to be tried in the Magistrates' Court because it is a quicker route to sentencing. So it isn't that we believe that we're closing down a potential for further error. It is simply that we believe that that particular route may be a swifter way to access justice for victims, and therefore it was never intended that it should be removed from the PPS to be able to do that, and it would be better if we put it back in place in terms of swift administration of justice.
There are no other members indicating to ask questions. Then I say that that concludes questions on this statement. Thank you very much. Members, just take a raise for a few moments, please.
Order, members. The Speaker has received notice from the Minister of Finance that he wishes to make a statement. Minister.
I wish to update the House on the latest set of allocations aimed at addressing the evolving COVID-19 situation and the need for economic recovery. Since my statement to the Assembly on June, monitoring further funding of £762.2 million has been made available to the Executive from Treasury. Funding has also become available as a result of revised assessments of earlier COVID-19 allocations. The Department for Communities has surrendered £4 million of funding in relation to its COVID-19 Supporting People programme response due to the use of existing funding to provide this support and lower than anticipated PPE costs. The Executive have previously held £2.2 million for its contribution to a ferry operator scheme run by the Department of Transport in England. Latest indications are that the cost will be £0.35 million, thereby releasing £1.85 million for reallocation. In addition, as a result of recent departmental assessments, some £30.9 million of capital DEL has been made available for reallocation. Last Concordia, I want to provide an update to the House on allocations made over the summer period. Due to the evolving situation and the need to provide support as expediently as possible, the Executive allocated £123 million of funding on the 13th of August. This set of allocations enabled schools and further education facilities to safely reopen, provided apprenticeship places and supported social enterprises. 2 limited allocations were made on the 11th of September, reflecting the urgency of additional higher education places and PPE for the education sector as schools reopened. Last Concordia, following a meeting of the Executive last Thursday, further allocations totalling £165.2 million have now been agreed. Given the concerns around waste management and the need to meet pressures resulting from increased landfill and waste management costs, DAERA have been allocated £11.4 million to support these key services. Local councils have been at the forefront of vital recovery services, despite experiencing a reduction in their income. Councils will also play a key role in economic recovery and in recognition of that, £40 million has been allocated to the Department of Communities to support councils. Given the severe impact of COVID on the arts sector and the need to support the reopening of venues, £29 million has been allocated to the Department of Communities for cultural recovery. This is in addition to the £4 million which was previously allocated for the Cultural Resilience Fund and means that the Executive has provided £33 million to support this sector. The Executive recognises the need for further support for businesses, and in recognition of the ongoing hardships faced, the Department for Economy has been funded to support a number of initiatives. £8.5 million for assistance to business to encourage new businesses, help retain employees, attract FDI and boost the screen industry and games sector. £8.4 million for skills and youth training to ensure young people can continue learning and employers have access to people with the skills and qualifications needed to recover and grow their businesses. £9.9 million for tourism to support tour operators, promote the North as a tourism destination and assist businesses to adapt to changed market conditions. £5.8 million for university R&D to protect jobs, help universities focus on the research needed to fight the outbreak and support economic recovery. £1.9 million for air route support to develop air routes that are critical to economic development, and £1.4 million for energy. And this funding will implement a demonstrator project to kick-start the hydrogen economy. These allocations should all help spur economic recovery. The Executive has allocated £8 million to maintain a safe environment for schools through to March 2021, with a further £1 million to help preschools meet the additional costs of reopening. Young people's education has been affected by COVID-19 and an allocation of £0.2 million has been made to support children with additional and special educational needs. £1.6 million has been allocated to the Department of Health in relation to the Track, Trace and Protect app. The mobile app was launched on the 30th of July to support PHA contact tracing programme and will help minimise the spread of COVID-19. Given the winter pressures identified by the Department for Infrastructure and the need to ensure that key transport corridors are accessible during the winter months, the Executive has allocated £5 million for road service to provide vital gritting and gully cleaning services. The £14.8 million capital allocated to the A6 demonstrates the Executive's commitment to delivering this vital dual carriageway between Belfast and Derry. This allocation will ensure that delays in construction caused by the COVID-19 lockdown earlier in the year will now be made good. Members will also be aware of the limitations to development being caused by many areas of historical underinvestment in our wastewater infrastructure. And £15 million capital allocation to Northern Ireland Water will provide investment to upgrade sewers, wastewater treatment works and pumping stations. Full details of all allocations in August are set out in the tables that accompany this statement. Last Concordia, following the latest round of allocations, the Executive retained a central fund of £55.2 million to be held for further sectoral support, including airports, travel agents and a scheme developed by the Department of Infrastructure targeting taxi and coach sectors. £600 million also continues to be held centrally, pending the Department of Health's assessment of costs for 2020-21. Further decisions on funding will be made following the Department of Health assessment of need and proposals from departments on further sectoral support. The Executive continues to respond to the changing environment that COVID-19 brings, and the allocations I have set out today will contribute to our aims of supporting businesses, protecting the vulnerable and ensuring the continuation of key public services. I commend this statement to the House.
I call the Chairperson of the Finance Committee, Steve Aiken.
Thank you very much indeed, Mr Deputy Speaker, and may I thank the Minister for his statement and indeed for meeting with me earlier today, and thank you very much indeed for keeping me informed of the information so far. I think, as an Assembly, we can all welcome the £2.2 billion we have received from the rest of our nation, and indeed it underlines the benefits of being part of our precious union. I expect a bit more than that. Here. Right, thank you very much indeed. But, Minister, I'm pleased to see particularly the allocations and resources. However, one of the things that noting the statement is, and I don't believe this is a criticism of the Finance Department, but there's issues particularly around the excluded, issues for taxi drivers, for the haulage industry, and for details on the Kickstart scheme. And maybe the Minister could allude to whether he's received any bids from the Department of the Economy or indeed the Department of Infrastructure for these things that have had at least 6 months in their gestation to try and get forward to this point as well. I would also I note, of course, that we've got £55 million in reserve. But I also note, indeed, as my honourable friend from South Belfast continuously talked about, the issue of £2.2 million in APD that we keep on giving back to the Treasury, in the fact that some of our airports need vital resource to keep going for a period of time, and particularly to keep going with 24-hour operations at Belfast International Airport. And there is a real need for financial support to be able to do that, particularly when of the importance it has to do with our freight issues, to be able to do that as well. And I also note there's and again, we as the Ulster Unionists, as myself as Chair of the Finance Committee, and also as my position as Chair of the as Leader of the Ulster Unionist Party, we welcome the additional money for the A6, and we also welcome the additional money for Northern Ireland Water. But the issue is, bearing in mind that this money has to be spent but this money needs to be spent by the end of the financial year. Can the Finance Minister brief us, and could he explain to us how this money is going to be actually spent by the end of this financial year period, bearing in mind the difficulties of writing contracts and getting suitable business cases put forward? Thank you.
I thank the committee chair for his questions and his commentary in relation to the statement and the allocations to date. It has been frustrating that it has taken some period of time that certain sectors who were left out to try and find, if you like, a solution between departments. A number of these sectors fell, if you like, in terms of responsibility between departments, and it has taken some time. And I think an intervention from the First and Deputy First Minister to try and get departments and some additional support and power being given to some of the departments to make sure that they could deal with this issue. So, in relation to the coaches and taxis, that work has been done. I haven't yet received a bid. But as he has quite rightly identified, we have held aside £55 million to allow that and a number of other perhaps bids involving different sectors, and we know there are going to be further airport costs as well, so to try and cover those things. And of course, that, as with all of the COVID money, he's correctly identified, has to be spent within the financial year, so we need to make sure that that work is done quickly and those costings are brought forward as quickly as we can, so the Executive can, if it supports whatever bid is made, bring forward further allocations. I get the point, and others have raised it in relation to APD. The Economy Department still feel it's an important tool in order to try and support connectivity, air connectivity. If they change their view in relation to that, I'll quite happily consider that in the future. And in relation to Northern Ireland Water, my understanding is it's obviously a matter for the Department for Infrastructure to ensure that it's spent, but there's somewhere in the region of 11 schemes that NIW have identified that they want to get on with. So departments know when they bid for this, and we've had long conversations with them. This is COVID money, it has to be spent within this financial year, and so those who are bidding for capital know the constraints in relation to that, and I assume that they have made those bids in the full expectation that they could spend the money in the time available.
As members will be aware, some discretion is shown to committee chairs in asking a question, so we'd ask all members to have a brief introduction and then come to their question. I call Paul Free.
Thank you very much, Mr. Speaker. And again, can I welcome here and now and put it on record the funding towards the energy and the hydrogen economy project, because I believe that will help and assist not only in the recovery but also in the coming years with regards to the climate emergency and the recovery of industry, both in my constituency and wider afield in Northern Ireland. But is it not frustration, Minister, being outlined today, when we do have a large pot of money, £55 million worth, sitting at the centre that could be used to help alleviate the pain and suffering of some of our industries that have carried on throughout this COVID emergency, not least the haulage company and the taxi and coach sectors, who have been penalised further by the Infrastructure Minister with regards to her slowness on MOTs, PSVs and licence requirements for drivers?
Well, I mean, I can't answer for the Infrastructure Minister in relation to those other matters, and I'm sure those are issues that you'll raise directly with her. I do know that there was an issue between the Economy Department and the Infrastructure Department in relation to supporting those sectors that you have outlined, and it was quite clear that for infrastructure to accept that, they needed to have some additional powers conferred on them, so it wasn't just a straightforward who wants to take this case and who's going to run with it. So it did take some time to resolve that. That is frustrating, particularly if you're a sector that is waiting on support and in very challenging economic times. And so I'm glad that that has been resolved, and I look forward to an allocation or a submission being brought along so that the Executive can consider an allocation to a number of those sectors. And in relation to the hydrogen scheme that he mentions, yes, of course there is funding in there to have, if you like, a test project in relation to that. I am due to have a cross-departmental discussion with a number of other ministers in the near future to get further information in relation to that, and I know it's something that people have been advocating very strongly.
I call Melissa McHugh.
Minister, have you received bids from any of the groups? And there are many of them, some from my own constituency, who are excluded from previous schemes.
Order. Could I urge members to stand adjacent to a microphone? Is where everyone should be standing to get appropriate distancing so that everyone can hear the record for the record. Thank you.
Asking Charlotte. Minister Rees, same question again. Have you received bids from any of the groups? And there are many, as I say, within my own constituency, who are excluded from previous schemes, and what arrangements are being made to accommodate those people?
Yes, I'm sure we've all been receiving representation from various sectors who have, for one reason or another, fallen through the gaps in relation to that, to the supports that have been made available to date, and we've talked about the coaches and taxis. I know the travel agent sector, newspapers, other sectors have been making cases. Self-employed, newly self-employed people have been making a case. There are difficulties with some of those, particularly in relation to self-employed, would involve the assistance or certainly the oversight of HMRC, which may not be available to us. So there have been challenges, some of them because they kind of fall between departments and getting people to accept responsibility for that, but also the challenges in terms of verifying some of the sectors and how you would give support and how we could verify that that support was going correctly to the right people. So there are a number of challenges around all of that, and I feel very much for those who are continuing to struggle and feel that they've been left out, and I know that the Executive is keen to try and get support as quickly as they can to them. That's why I have kept in reserve a pot of money so we can do that as quickly as possible.
I call Matthew Toole.
Mr Deputy Speaker, I think it's just worth saying up front that I don't think there was any legal doubt over whether it was the Infrastructure Economy Minister's legal via-res to support certain sectors. It was the Economy Minister's. And on that note, Mr Deputy Speaker, can I just make the point, I used to in a previous life do improvisational comedy when I was much younger, but unfortunately there does seem to be a high degree of improvisation around business support. We've got 40 million here allocated to business support, including a 8.5 million, which is just called assistance to business. This seems very whack-a-mole, it seems very improvised. Why hasn't the Economy Minister worked with the Finance Minister to produce a joined-up economic recovery plan which explains exactly where this money is going and why it's going to particular places? And further to that, just at the bottom of the table...
Order. I've been flexible with the individual. I'll give him a long introduction. This is an opportunity to ask a question to the Minister. Minister.
Well, can I say that I mean everybody will have their version of where the issues lay between economy and infrastructure in terms of assisting some sectors, and I'm just pleased that it's been resolved. I'm pleased that infrastructure have undertaken to do it, and I look forward to working with the Infrastructure Minister to try and identify how we get support to those sectors. Can I say in relation to I mean, in giving a statement like this, obviously you have to condense or I could speak here for 2 or 3 hours, and I'm sure the Speaker might take issue with that. But so the 8.5 million for assistance to businesses to encourage new businesses, help retain employees, attract FDI and boost the screen industry in the games sector. I'm sure the member can get much more detail on that from the Department of Economy should he choose to engage with them. The issue about economic recovery plan, the Department of Economy produced its own economic recovery document. The Executive produced a framework for economic recovery against which these allocations were set, and that took a little bit of time over the summer to get that together, and that's why we waited until that was available to us. So it wasn't a question of myself and the Economy Minister. These allocations are made by the Executive, and it's against its own framework.
I call Andrew Muir.
Thank you very much, Mr Deputy Speaker, and I thank the Minister for his statement. I am disappointed that there is no inclusion of funds for those who have been excluded from any support, nor hauliers. In relation to hauliers, I note the powers that have been passed, or meant to be passed, to the Infrastructure Minister in relation to that, but I note that hasn't occurred yet. One of the issues of concern is that there has been a significant number of Barnett consequentials coming to Northern Ireland, but yet there still hasn't been, for example, a bid for funding and a scheme rolled out for the Kickstart scheme, even though that was announced across in Great Britain back in July. What measures has the Minister taken to ensure that the monies are actually spent in this financial year and we're not going to surrender any monies at the end of the financial year?
Well, the member will know that because something comes across as a Barnett consequential, it doesn't automatically go to the same issue. It's up to the Executive to decide how to use that money. And clearly, the Executive, having ensured that the health system has enough to cope with the pandemic, wanted to turn its mind to economic recovery because the economy has suffered greatly as a consequence of the pandemic and the lockdowns and restrictions associated with it. So it was to try and ensure that we targeted the limited resource, and it is a limited resource we have, to the best effect in terms of economic recovery. All of the departments, I say, there is a significant amount of work done between officials at the departments. Are very clear that this COVID allocations are for within this financial year, that money bid for and schemes put forward have to be spent out within this financial year, and we will continue to monitor that. And as I announced at the start of my statement, there have been a number of surrenders which added to the pot where people were very early on identifying that they couldn't or didn't need the money that had previously been allocated and was returned to us. So we will keep a close eye on departments to make sure that that happens over the next number of weeks and months.
I call Pam Cameron.
Thank you, Mr Deputy Speaker, and thank the Minister for his statement to the House today. And given the need to change how we operate in a pandemic, and in particular with regard to the health service, could I ask the Minister if any of the monies being held centrally will be ring-fenced for the much-needed health service transformation going forward?
Well, as I said in my statement, the member will know we have £600 million has been left held centrally, and the Minister for Health is bringing forward an assessment because, again, COVID money has to be spent in this year. It's a substantial amount of money, although obviously the health service can use a substantial amount of money and can make use of a substantial amount of money. So he is going to bring forward some detail on that, because we want to be clear, firstly, that there is enough to cope with what's coming at us, and it's quite clear there's going to be another surge in relation to COVID, and that's going to coincide with winter flus to create significant difficulty for our health service to cope with that. So we need to make sure it's properly resourced. And then I think he is looking at recovery in terms of the health system itself as well in those costs. So he will bring forward to us an assessment of what he needs and can spend within this financial year, and as I say, £600 million is a lot of money to cover that. If he doesn't require it all, then that will be put back into the pot and reallocated in other areas. But I know recovery and assistance for the health service generally is part of his thinking in terms of spending that money.
I call Gemma Dolan.
Good last Concordia, and I thank the Minister for his statement. Minister, will you join with me in encouraging Minister Mallon to use some of the £15 million allocated to NI Water for the residents of Gallia-Shorn and Enniskillen?
Well, I'm sure, like probably other members, we have received correspondence and from people involved. It seems to be an appalling situation, and a very, very strong sympathy for residents there who have found themselves, through no fault of their own, in a situation where the services in terms of sewage and wastewater to their houses have not been finished, and don't seem to be any route to getting that finished. We have, as I said in my statement, allocated £15 million capital in the statement I've announced today for Northern Ireland Water, specifically for schemes. We recently provided additional funding to Northern Ireland Water with £27 million worth of resource as well. So I'm hoping that the Infrastructure Department can, now that it has sufficient resource, can engage with the residents in that Gallia Shore scheme and see can they find a resolution to what are unacceptable problems for them.
I call Paul Given.
Thank you, Deputy Speaker. Can I ask the Minister how much to date has been allocated to TransLink? I note in the statement £20 million in this most recent allocation, and it has appeared in every statement so far. So what is the total that TransLink has been in receipt of? And was there a missed opportunity for TransLink to have availed of additional support through the furlough scheme, which would have allowed executive funding to have went into other schemes?
Well, I don't have the figures, but as I have dealt with this quite a number of times over the last number of months, I think, and if I need to correct this, I'll come back and correct it, but I think given the additional £20 million that we give TransLink in the budget in March, above and beyond what the Department of Infrastructure had, I think a further £70 million has been allocated over the COVID allocations to TransLink. So my guess on that is that about £90 million since March has been given to TransLink. The question in relation to furlough, I know that the Infrastructure Minister looked at that, and I gave advice in relation, because initially people considered furlough was only for private sector, and we then were aware that the public sector could avail of it in certain circumstances, and TransLink were, I think, eligible to avail of certainly some of the workers there were, and the Department of Infrastructure looked at that, and TransLink obviously looked at it and decided not to go that route. I don't know why. That's a matter for the Minister for Infrastructure or the CEO of TransLink to answer, but I think it's in the region of £90 million additionally since the start of the financial year.
I call Kiva Archibald.
And thank the Minister for his statement. And Minister, the £52 million that has been held centrally, you've outlined for sectoral supports, including airports, travel agents and taxis and coaches. Can you give us an update on the planned financial supports for airports, please?
Yes, we have provided some COVID support to some of the airports, those who had made a case and needed that, and I think business has begun to pick up again, which is good news for our 3 airports. And there is a consideration, I think, in terms of security and safety costs to the airports, that we will attempt to provide some further support in relation to that. Now, obviously, that discussion is going to have to be had with each of the 3 airports, and we'd see what level of assistance might be required, and we also have to match that against what level of resource we have to give them. But there is, the Executive has, in the pot of £55 million we held back, agreed that some of that will be allocated towards airports. So we need to have that discussion with them fairly soon to see what is required.
I call Pat Catney.
Thank you, Mr Deputy Speaker. I thank the Minister for his statement, and I welcome the further allocated support, particularly for our arts sector. Would the Minister agree with me that all signs seem to be pointing towards a further lockdown? That being the case, what planning has his department done in putting support in place when this inevitably happens?
Well, I'm not sure that it's inevitable, and I suppose we can all look at how things are developing and make our own guess on that. We have not received any advice at the Executive that a further lockdown is required. There are restrictions in place, obviously, in terms of the home setting, but a further lockdown which would directly impact on businesses. So we haven't received that advice. As I say, there is a pot set aside for a number of interventions. Should there be money left on the other, when those interventions are made, then I will come back to the Executive to ask whether they want to reallocate what's left or to keep, in case we do get to the type of lockdown scenario he's talking about, some money continue to be set aside until into the new year. Bearing in mind it has to be spent by the end of the financial year, just to see what the pandemic might throw at us in the time ahead. But I think it would be prudent to keep some pot of money available for emergency assistance should that be required.
I call Mike Nesbitt.
Deputy Speaker, thank you very much. I want to acknowledge the Minister faces 2 massive challenges: protecting public services and trying to preserve the fabric of society. And on the latter, I very much welcome the money for the arts now being released. My question today is about sport. The Chief Executive of the IRFU has posed an existential threat to the future of professional rugby in the island, including Ulster. And the All-Party Group on Sport last week heard a common theme from governing bodies. Gate receipts are drying up, Sponsors are either withdrawing or seeking to renegotiate. Money is very tight. Can the Minister give clarity to sport as to where they stand in terms of the Executive's priorities, please?
I mean, I can speak personally, as somebody who's involved with sport and continues to be involved with sport. The benefit to society generally is just immeasurable. I was fortunate enough to attend a hurling final yesterday in Armagh, and the organisation on a voluntary basis that goes into that to ensure people are safe, that they're socially distanced, that the crowds are controlled by people who are volunteers, who are going out and putting their own health at risk by undertaking to do that, and to allow people to get the enjoyment and the value of you have from attending a live sports event, which for me is a huge benefit, and the contribution then in terms that makes to society when they're engaging with young people and giving young people direction and support and positivity in their lives is huge. So by all means we're trying to support sport as much as we can, recognise very clearly because of the limitations on crowds, and bear in mind in this part of the island we're fortunate at least we can get some attendance at games, whereas in the southern part we can't. But there's a huge challenge for rugby, for Gaelic, for soccer, for all sports, and I think we have to keep engaging with them to see how best we can help. I noticed the government in Dublin did make some intervention with the GAA in terms of carrying out the All-Ireland Championships, the county championships, and I'm sure that's very welcome. That will apply in the 6 counties here as well. But we have to continue that engagement with sport to see what we can provide to support them, because, as I say, the work that sports people do, the vast bulk of it voluntarily for us, is immeasurable in terms of its benefit.
I call Karen Mullen.
Minister, also welcome this statement today, in particular the additional funding for the A6 development and your ongoing commitment to addressing regional inequalities. These allocations were made alongside the announcement of a jobs support scheme, which is also critical to economic recovery. Minister, what is your initial assessment of this new scheme?
Well, there was a very clear demand from employers that we spoke to, and we've been articulating that to the Treasury for some months now, that the idea of a cliff edge in October to the furlough scheme, as it's sort of more popularly known, was disastrous for businesses here, for employers here, and for employees, and would see very large-scale redundancy. So I am pleased that some form of scheme has continued on. However, it is nowhere near as generous, and it will present significant challenges, I think particularly to low-paid and part-time employees, and I think it will present challenges, but nonetheless I have to say the idea of no scheme or one which is much reduced in terms of the level of support from the job retention scheme that was previously there, there's a vast difference between the two, but I have to say that it is better than none, but it is going to present some significant challenges, and I don't doubt that we will see an increase in redundancies as a consequence of it.
I call Kelly Armstrong.
Thank you very much, Deputy Speaker, and thank you very much to the Minister. I'm delighted to say that there's a kickstart to hydrogen. We actually have the opportunity now of resolving the Northern Ireland Water's problems if only we made it produce hydrogen, but don't get my geek up on that one. But I wanted to ask the Minister, when you get to this stage in questions, and the Deputy Speaker has been very kind, all the questions can be asked, but I want to ask you one about joined up working, and this is about yourselves in the Treasury. Is this it? Is this the last of the money that we're going to see this year? Because we know, and it's mentioned in your piece about councils, councils are vital to delivering on the ground. Solus told us the 40 million is what they needed, but that was just to break even. Will there be any more money coming from Treasury, or do we need to send out a clear message to say that's it from big government, the rest has to be brought in with income? Thank you.
I have to say that we have no indication that there's anything more coming. As a matter of fact, when we did receive the significant allocation, particularly for health, which we set aside, we were told very clearly that was the last COVID money from Treasury. Now, whether that changes will not very much be determined by what goes on here, but more than likely what goes on in England and the southern part of England, whether there's a change to that. We had very clear advice, as we raised, for instance, in relation to the last question, the furlough scheme, that was it, but now they've come forward with some form of a job retention scheme, albeit much reduced. So whether we will get further allocations or not, we don't know. Other pressures might come to bear on the government in London and might force them to change their mind. But we have to operate on the basis of what we know we have, and that's why we're saying to people, apart from the money which is set aside for health, which may well all be used by health, and the 55 million we've set aside for other sectors, then as far as the Executive is concerned, we have no further COVID allocations to make.
call Sinead McLaughlin.
Thank you, Minister, for your statement this afternoon to the House. Can I ask the Minister to give me a bit more detail about the 80 million FTC from to Ulster University? This comes on top of a switch earlier this year from the FTC to cash allowance. And can I also ask why this is coming from the Executive Office?
Thank the member for a question. Yes, you're right that the FTC for 80 million has been agreed for the Ulster University Belfast campus project. It's not a COVID recovery specific allocation, but a previously planned allocation as part of this project, which needs to be agreed now to allow the project to access the required funding. And the conditional approval has already been given by the Department for Economy and Department of Finance for the loan to Ulster University in respect of its Belfast project, and due diligence has been undertaken by Economy in relation to the stability of the project and the capability of the university. I know in relation to these matters that the Executive Office had opted in to play a role in trying to hugely critical project, not just for Belfast, but also by knock-on effect by implication for Magee as well, that the University of Ulster are able to complete these very significant capital projects. And so I know the Executive Office have become involved in that to ensure that this project, which has a much bigger significance than just Belfast or indeed just the Economy Department, is delivered and is delivered properly.
I call Rachel Woods.
Speaker, and thank you, Minister, for your statement. These allocations for some will be a plug to a gap, but not for all, as we have still so many excluded. What is missing here, and Mr O'Toole touched on it previously, is funding for a long-term coherent green plan for economic recovery. So can I ask what discussions have been had across the Executive and your department on funding this, and when we will see it come forward?
The process we're dealing with here is COVID allocation money. And that is money which we've received this year from Treasury, which wouldn't have been in the plans last February, March when we were setting the budget, or even when we were discussing the idea of a revamped programme for government. So this money has come in to us. It has to be allocated within this year. So you're not talking about long-term plans attached to this. You're talking about economic recovery, meeting the challenges of the pandemic, economic recovery in the here and now, trying to assist businesses through this crisis. That doesn't set aside the fact that the Executive will be setting a budget now coming into the autumn, which we'll be going out consulting on and agreeing that budget in early spring, which I'm hoping will be a multi-annual budget if we can get that clarity from Treasury. And then that, and in the programme for government which accompanies that, I think that's where the discussion in relation to long-term and green recovery planning and green economy planning should be had.
I call Jim Allister.
I'm assuming that all the money announced today isn't COVID money. The capital money, for example, seems to be reallocation of money that's been surrendered. But in terms of the COVID money, can the Minister give us any indication of how far there's been departure under Barnett from the pigeonholes in respect of which it was allocated as to how it has been spent? What is there some picture of the disaggregation?
I can get you that detail. I don't have it to hand. I mean, from my own memory, and from obviously we've made a number over the last 6 months or so, a number of COVID allocations. They have generally come in a fairly broad category. We got a significant amount of money for health, which we're still sitting on until health decides what it needs. And we had a significant amount of money came across for PPE, which we have used some of it. And use that to purchase PPE for health and also for other departments. But I can get you the detail on that. I don't see a huge amount of departure. There was, broadly speaking, economic recovery money, health, resilience money, if you like, for the health department. But I can certainly get those figures and will supply them to you.
I call Jerry Carroll.
Thank you, Minister, for a statement, and most of this money will obviously be welcome, but won't address some of the longer-term issues, refunding and funding and lack of funding for our services. The Minister will obviously be aware Rishi Sunak has indicated his preference for corporation tax to increase by 5%. Has the Minister any views on this, and if he would like it to increase by 5% or more, and if so, how much extra money would that bring into for public services here?
There's been no discussion on corporation tax increase or decrease. As a matter of fact, both myself and the Minister of Economy said it's not something we're considering at this time.
I call Claire Sugden.
Thank you, Deputy Speaker, and thank you, Minister. Minister, forgive me, but this statement, aside from its title, doesn't really feel that it's for COVID-related allocations. Indeed, a lot of the allocations you have made could be argued were gaps that existed before the pandemic. Will the Minister's department therefore be auditing how it is spent, for example, within councils, within the university, so that it does directly relate to the difficulties related to COVID-19?
Yes, of course we will continue to engage. The department's put forward bids and obviously in detail which isn't available in the statement, but certainly in questioning any of the departments about the money they received, you're more than free to put those questions to them and get that information. The councils have been at the forefront of assisting in fighting this pandemic, not just in terms of the services they provide, but also how they harness the public, the voluntary spirit that is out there in the country and assisted in food parcels. Things like services like that I don't think the executive could have been able to deliver itself, and the council suffered a significant loss in income as well as many businesses did. So, I mean, they are a critical part of joined-up government, and we have to ensure that the bid for councils was more than we were able to give. But I think it was important to give support to councils, and I've had engagements with NILGA and with other council representatives as well to hear firsthand the problems they're continuing to have. And so I think it is important to give council support, because I think as we head towards what looks like another increase and possibly another surge in relation to the virus, the role of councils will be critical at that stage too. But we do engage. The department's put in detailed bids. They are interrogated. We asked them to rank the bids in order of importance, and they were set against that framework recovery document as well, to make sure that they had a contribution to economic recovery.
I call John Stewart.
Deputy Speaker. Minister, there's been a great deal of responsibility tennis being played by various ministers in terms of who's responsible for providing additional support for businesses that have to date have not been able to avail of support or intervention from the executive. There was a motion passed unanimously in here 2 weeks ago to that effect. Have you had a bid yet from the Minister for the Economy? In the absence of one, are you in a position with your executive colleagues to create a package of support for those SMEs that have to date missed out?
No, not as yet, and I mean, we can debate all day about whose responsibility these things are, and it's been back and forward, but I mean, to be quite honest, I can only allocate or make a recommendation for allocations, is what I do, and bring it to the executive on the basis of a bid made from a department. I've been very clear about that. I don't have the authority or the responsibility to put together packages of support from the finance department. We assess what's brought to us and then make a recommendation to the executive in terms of the funding available to us. And so, to be quite honest, I'm more interested in people getting on together and working on these things and starting to get support out there where it's needed. We have done that very, very well, and that's, you know, I'm sure, like many other members, you engage with people in business and other areas, and they have greatly appreciated the support, the rates reliefs, all of that support that has been given to the public to assist in fighting the pandemic. But there are sectors who are still understandably annoyed at being left out, and the sooner we can get that put together and get support to them, then the better.
Members, the next item of business on the order paper is question time, which is 2 o'clock, and I can thank all members for asking questions. All members have been taken. I therefore propose, by leave of the Assembly, with question time coming up at 2 o'clock, that we would suspend the sitting briefly until then. The sitting is, by leave, suspended.
Okay, members, it is time for questions to the Executive Office. As I informed members at the start of the sitting, the First Minister will be responding today. We will now start with the listed questions, and I call on Paula Bradshaw to ask the first question. Paula Bradshaw.
Thank you. Question 1, please.
Minister.
The Department of Health leads the work on mother and baby homes and Magdalen laundries, while the Executive Office leads the work on historical clerical child abuse. Ministers are aware of the impact that clerical abuse has had on the lives of many individuals and the importance of progressing this work. The working group intends to commission a research project on clerical child abuse later on in this year. And whilst terms of reference will be formally agreed later, it is intended that it will cover opportunities to improve existing safeguarding practice, as well as how best to engage with victims and survivors.
Paula Bradshaw, supplementary.
First Minister, Minister, I met with Executive Office officials probably 3 years ago when they were talking about the terms of reference for this research. I'm just wondering, is there any way you could push this forward? Obviously, a lot of the victims are very distressed at this delay. Thank you.
I want to thank the member for her question, and indeed it's something that I know many of the victims have been lobbying very hard upon, and I very much would like to see this work being taken forward in a more timely fashion. As she will know, the Department of Health appointed Judith Gillespie to take forward some of the work in relation to the mother and baby homes, and as part of that she has been widely engaging. She was succeeded by Peter McBride, as the member probably knows as well. But all of this was happening during suspension, and then Ms Gillespie was appointed by the Department of Health just recently. So it's important that we do take these issues forward. There's a lot to be done in relation to this matter. It obviously, in some ways, also goes alongside the COSIGA appointment, which I will address later on in questions, but it is important that we move all of these issues forward so that people can get closure and can get the restitution and justice that they so rightly deserve.
I call Colin McGrath, supplementary.
Mr Speaker, do our joint First Ministers think that the compensation levels that were offered for the data breach by the Interim Advocate's Office was suitable to the trauma that some of the people experienced?
The Chair, better than most, will realise that this is a legal process, and therefore we are dealing with our lawyers at present, and they are dealing with all of these matters. And I think that it would be wrong of me to intervene on all of those matters, because some of them will end up in court, Mr Speaker, and therefore it's important that we reference that and respect that.
I call Linda Dillon.
Thank you, Minister, for your questions thus far. Can the Minister outline, just in relation to clerical abuse, is it intended that there will be a similar type redress scheme as there is currently in place in relation to HIA?
Well, in terms of the mother and baby homes, if people were in institutions such as those up until the age of 18, they can apply for redress through the current scheme that is there. And so we will have to see, after the piece of work that is done by Judith Gillespie at present, and indeed in terms of the wider terms of reference for clerical abuse, if there are any gaps remaining there. But I should say very clearly that those who were in mother and baby homes up to the age of 18 can seek redress through the Historical Institutional Abuse Inquiry.
Call Jerry Carroll.
I want to ask the Minister how her office will ensure that the voices of victims are heard who feel let down and excluded so far will be heard during, throughout and at the end of this process, how the voice of victims be heard. Thank you.
Well, I think we have made good strides in terms of listening to the voices of victims. As I say, I'll answer in relation to the Commissioner appointment later on in questions, but it is important that we also reference the fact that Judith Gillespie is proceeding with her piece of work and is working with victims and survivors as well. I think that is important. This is a very difficult piece of work that she's taking forward, but an important piece of work, and we wish her well and look forward to what she has to say after she's finished it.
Next question, I call William Humphrey.
Thank you, Mr Speaker. Question number 2.
Mr Speaker, with your permission, I will answer questions 2 and 9 together. Whilst COVID-19 is primarily a health pandemic, it is also causing significant societal and economic impacts. The Executive's response therefore aims to deliver a balanced package of measures across all these areas that will target support where it is needed most. The Executive's approach continues to be flexible in responding to the emerging situation. Most recently, this has included the introduction of restrictions in domestic settings, initially on a postcode basis and then extended to all households, given the concerning levels of transmission across the community. The focus of these restrictions on household settings is informed by the evidence we have from the Test, Trace, Protect programme, which tells us that household transmission and informal interactions in the community are playing a role in increased positive case numbers. We continue to keep the situation under very close review and are prepared to respond as necessary to flatten the rate of infection and ultimately save lives. These have been the most challenging of times for people, and we understand that people are weary of COVID-19. But it is crucial that everyone continues to follow the consistent public health messaging. The Executive's high-impact cross-platform public information campaign continuously reinforces message around social distancing, maintaining good hand and respiratory hygiene, wearing face coverings and downloading the Stop COVID NI app. We want to ensure this information is communicated to all as wide an audience as possible, and last week the Deputy First Minister and I made a public address to update everyone in the community on the current situation and reinforce those crucial messages. This was broadcast live on a number of platforms, and the viewing figures for the BBC alone were over 230,000.
William Humphrey, supplementary.
Minister for her answer so far. And can I take this opportunity on this, the 28th of September, to wish the First Minister a very happy Ulster Day. Many of the members in this House will have been contacted by constituents concerned about cancer care for their loved ones or indeed for themselves. Can I ask the First Minister, is she satisfied that progress is being made on access to non-COVID treatments in our health service?
Well, I thank the member and wish him a happy Ulster Day as well, and say to him in relation to the non-COVID healthcare that this is a matter that does actually concern the Executive greatly. I was pleased that the Health Minister brought forward his new cancer strategy paper to the Executive last week and then has informed this House through a written statement around all of that. It's very important that we look at the short and medium-term plan to rebuild and indeed to stabilise our cancer, oncology and haematology services, because that rebuilding plan is critical to trying to deal with all of those very difficult diagnoses that are out there, and we very much want to focus on this, as well as, of course, dealing with COVID. We do want to make sure that the trusts have their plans in place to deal with all of the non-COVID healthcare as well.
I call Steve Aiken. Your supplementary to question 9 was grouped with 2.
Oh, sorry. Sorry, my apologies. I withdraw the question.
I call Pat Cadney.
Thank you, Mr. Speaker. Joint First Minister, I was going to ask, has the Department reviewed the communication strategy about the COVID response?
Well, as I indicated in my substantive answer, we did make a communication directly to the people of Northern Ireland last Tuesday, but I think one of the issues that we have been concerned about over this past number of days and weeks is the messaging for our young people and the ability to get the message to our young people, and it's important that everyone hears and understands and acts upon key messages, and we have now put in place a digital campaign which is targeted specifically at our young people, working in partnership with organisations like Cool FM and obviously using social media, and indeed something called Mobsta, which the member might be able to tell me what it is, but I'm not quite sure what it is. I'm sure many of our young people would be able to tell me, but apparently we're going to use Mobsta to do some digital advertising which will target 16 to 25-year-olds, including students, based on their location data. So obviously if they're in Queen's, if they're in the University of Ulster or whatever, then we're able to get some messages to them. So we are very much proactively looking at our messaging and making sure that we get messages out as wide as we possibly can.
Call Doug Beattie.
Mr Speaker and Minister, I often travel under these electronic road signs on the motorway which say a speed limit is not a target. In other words, just because you can doesn't mean you should. Therefore, can I ask the Minister if she believes the other executive party leaders undermined the executive's healthcare message by travelling down to Dublin to do a meeting that could have been done on Zoom?
Matter that I'm sure my colleagues will be able to answer for themselves. It is important that we do give leadership in these issues and that we set forth what we would expect other people to do as well. I happen to think that advertisement of the speed limit not being a target is a very effective advertisement, and I hope that we can use more of those sort of quirky advertisements to get out our COVID message as well, because it is important, as I say, that we reach as many people as possible.
Next question, call Jerry Kelly.
Question 3, please.
Mr Speaker, with your permission, I'll ask Junior Minister Kearney to answer this question.
Ministers in the Executive have a shared commitment to ending sectarianism. Positive work is ongoing across the Together Building a United Community strategy to tackle sectarianism and other forms of intolerance in our society. In May, the Department of Justice appointed Judge Desmond Marrinan to carry out an independent review of hate crime legislation here. Judge Marrinan is due to provide his final report to the Minister of Justice for consideration by the end of this November, and it's necessary to wait the outcome of that review before further decisions can be taken on a way forward.
Jerry Kelly, supplementary.
Thank you, Minister, for his answer up till now. But in terms of the NDNA commitment, will the Minister confirm his commitment that the Executive will bring forward concrete proposals, and I quote, to formulate and require all public representatives to commit to an anti-sectarian pledge?
Well, go on Moehas, Leishan Coltas, Octan Keshan occur. A whole society approach is required to tackle the scourge of sectarianism in all of its manifestations in our society, and I'm very mindful and indeed fully supportive of the commitments which are contained in the New Decade New Approach to anti-sectarianism, which include an enhanced strategic focus within the programme for government on anti-sectarianism, a reaffirmation of support for the right to freedom from sectarianism, sectarian harassment and intimidation, and a wish to see sectarianism given legal expression as hate crime, and also a commitment that the Executive should formulate and require all public representatives to commit an anti-sectarian pledge. There is, however, a particular responsibility on all public representatives to lead by example, and I'm committed to working with Executive colleagues to bring forward practical proposals on an anti-sectarian pledge for all public representatives in a manner that delivers and is consistent with our NDNA commitments. Indeed, I am committed to engaging and working with all Assembly colleagues who are committed to exploring how we may collectively make a stand against sectarianism as the basis of building an inclusive, shared and better united future for all of us.
I call Jonathan Buckley.
Thank you, Mr Speaker. You'll forgive me for nearly choking on the words anti-sectarian pledge from the member. Does the junior minister recognise the crass hypocrisy involved by Mr Kelly and indeed his own response to this question, given that over the course of the weekend, Mr Kelly not only glorified but gloated in a terror escape at the maze which resulted in the murder of a prison officer and resulted in the injury of another? And does he accept that this stands in stark contrast towards building a united community? This is shameful actions from a member of the Northern Ireland Policing Board.
Sectarianism is accepted as a form of racial abuse. After over 10 years of a DUP Sinn Féin duopoly here, can the Office of the Joint First Ministers tell me at what stage is their department at with the long overdue implementation of a racial equality strategy?
Well, my way has done colta socht and cast shun occur. The member, of course, will be aware that we have a 5-party power sharing coalition. His own party is an integral part of that coalition. We have commitments which rest at the very heart of the restoration of power sharing in relation to taking forward NDNA. We have a racial equality strategy from 2015 through until 2025, and the work involved in relation to addressing racism within our society must be seen as part of the overall package of how we eradicate intolerance and all forms of bigotry in our society, regardless of the source or against which section of society that is targeted towards. And the work that we have in hand in the context of that strategy continues apace, and it's my firm view that all ministers, and I hope all parties who are members of our power sharing executive, will share the common ambition of taking forward and implementing that strategy successfully, so that we can in fact build a genuine, shared, inclusive and united society.
Call Jim Allister.
Does the Minister think it would help towards a shared, inclusive society if his party, not least the questioner in this case, put an end to tweeting the glorification of terrorism, which in many cases was crassly sectarian in itself in the choice of victims by the IRA? Would he like to give a lead by indicating that his party will now eschew such glorification of terrorism, or will we be subject to more of the same?
I thank the member for that question. And the reality, as the member well knows, is that we all have narratives around our past, the conflict that we've lived through, the last 100 years. Those narratives are in conflict with each other. But we need, particularly in the context of this mandate of renewed power sharing, to come together on the basis of respecting different narratives, to agree to disagree. We will not agree on the past, but we can do our level best collectively, inclusively, to try and build a united future for everyone in this society. And next year marks the centenary of partition in our island. And next year can throw up the prospect of a very, very contested year where we disagree vehemently in relation to what happened in the past. But perhaps one of the considerations, and I invite the member to take this point on board for some further reflection, one of the things that we should actually try and do next year is, rather than descend into the vortex of continuing and relentlessly fighting over issues of the past, that we look towards the centenary of partition as an opportunity to develop a new dialogue and discourse within our society about how, in fact, we can build for the future.
Next question, I call Melissa McHugh.
The North West Development Fund has approved funding in place until December of 2021. This includes an extension of the funding period to take account of COVID pressures on projects. The total committed investment by the Executive is approximately £2.15 million. This commitment is match funded by the Republic of Ireland's Government, as agreed in the Fresh Start Agreement of 2015. The North West Development Fund has delivered a number of successful projects across 3 regional development pillars. Some examples are developing economic growth through trade and investment missions, developing the physical environment by contributing to the Interreg Greenways project, and through the North West Sports Development, strengthening community cohesion and well-being.
Melissa McHugh, supplementary.
Thank you, Minister. Supplementary, just will you provide an assurance to work with the Dublin Government to deliver the NDNA commitments to provide further financial support to the fund.
Thank the member for his supplementary. The reference in the New Decade New Approach at page 60 states that the Republic of Ireland's government is committed to exploring opportunities for investment that will further support opportunities to bring greater economic prosperity and social benefits to the wider region, and in principle provide further funding to the North West Development Fund in collaboration with the Northern Ireland Executive. I understand that the North West Regional Development Group has recently written to us seeking a continuation of the fund beyond the current arrangements, which, as I say, is up until the end of 2021, Mr. Speaker. So we will be looking at that in the future to see what is possible, and also looking at how broad the fund can be right across the North West, because we think it is important that there is equity in how the fund is distributed.
Thomas Buchanan.
Does the First Minister accept that there is much more to the North West than the maiden city? And are ministers open to the wider hinterland and the areas extending out further than the maiden city, that they can also benefit from this particular funding?
Well, yes, I do accept that the North West is greater than the maiden city, and it is important that that is recognised, I think, by the Council in Derry and Strabane, but also in Causeway Coast and Glens as well, that is taken into account, because the North West does go across a number of regions, and it's important that that is reflected in the work going forward.
Next question, called Gemma Dolan.
Question 5.
Mr. Speaker, with your permission, Junior Minister Kearney will answer this question.
There are several potential amendments to the Fair Employment and Treatment Order 1998 being considered by various business areas within the Executive Office. These extend to the inclusion of monitoring information as regards nationality and ethnic origin, the repeal or amendment of the teacher's exception in Article 71, created in 1976, to address the imbalance in employment opportunities for teachers, and also an amendment of Article 24 to reflect the changed circumstances of a post-conflict society, enabling ex-prisoners and their families to transition into making a positive contribution to society.
Gemma Dolan, supplementary.
Thank you, and I thank the Minister for his answer. Could the Minister outline the progress made to implement the employer's guidance in respect of public sector recruitment and vetting?
Yes, I can. The employer's guidance was designed to assist employers to follow best practice, and it is aimed at reducing barriers to employment and enhancing the reintegration of those with conflict-related convictions. This week, Junior Minister Lyons and I met with members of the review panel for an update on their work. We had a very positive and informative discussion with panel members, and we recognise that a lot of good work has been taken forward and continues to be so. However, whilst there has been a number of areas where key success and progress have been made to date, including intervention on individual cases, several issues still remain to be addressed, and progressing this work and continuing to engage with the review panel will be a priority in the period ahead.
I call Chris Little.
Mr. Speaker, does the Minister agree that the exemption of teachers from the Fair Employment and Treatment Order is archaic, and will the Executive Office bring forward legislation to repeal this exemption of teachers from legal protection from employment discrimination on the grounds of religious belief and political opinion?
Well, Moe has done called that Sochtan and Keshin occur. The member will be aware that Article 71 has been enshrined in legislation with a view to effectively providing for lawful discrimination for the employment of teachers in both the controlled and the maintained sectors. The Department, TEO, does have responsibility for bringing forward the relevant legislation for amendment, but clearly the Department for Education will have a significant input and opinion in relation to what those kind of amendments could or should look like in the future. And I can advise the member that a meeting is scheduled for next week where officials from TEO will be engaging with officials from the Department for Education to take forward that discussion among officials at this stage.
Next question, Colm Gildernew.
Question number 6, please.
The selection process for the Commissioner for Survivors of Institutional Childhood Abuse was launched in June, with interviews taking place in mid-August. Those candidates assessed as appointable by the selection panel give a presentation to the Deputy First Minister and myself on the 9th of September. We are currently in the final stages of the appointment process, and once the requisite pre-appointment checks are completed, the Deputy First Minister and I will make a formal announcement regarding the Commissioner's appointment.
Colm Gildernew, supplementary.
And I thank the Minister for her answer. Does the Minister agree that the appointment of the new Commissioner presents a renewed opportunity to progress all the HEART recommendations, in particular with a focus on the apology?
I thank the member for his supplementary, and to say to him, just to remind members that the HEART report recommended to ourselves that those who were responsible for each of the institutions investigated by the inquiry, where it found systematic failings, should make a public apology as a wholehearted and unconditional recognition of the failures of the past. And very much this is something that the new Commissioner will take forward, as well as the memorial, which I think we would want to see progressed as well. Obviously, the Commissioner will need to do that in conjunction with the victims and survivors to make sure that it is an appropriate apology and an appropriate memorial, but certainly that is something that the new Commissioner should take upon herself or himself very quickly.
Call Paula Bradshaw.
Mr Speaker, Minister, thank you for that response. I've heard you mention that several times in the Chamber around how you'll be working once the new Commissioner is in place, but it's 45 months now since the HEART recommendations were made, and what is preventing you and the Deputy First Minister from making a joint apology in this Chamber?
Well, because I think it's important that all of the institutions who have been named in that report should make the appropriate apology. It's one thing for me to stand here and make the apology, but I think very much the victims and survivors would want to hear it directly from the institutions involved as well, and that's why we have someone to work with the victims and survivors. And look, I accept that whilst the interim advocate has been employed in some of that business, that there has been some difficulties around that. We would have wished it were otherwise, but that's where we are at present. However, I am hopeful that we'll have the new Commissioner in place very shortly, because we're in the midst now of just pre-security checks and all of those sorts of things, so that we can take the matter forward and that they can deal with it very quickly.
Call Colin McGrath.
I congratulate the Department on coming to the end of a process of appointing somebody. Does the First Minister not think that this House deserved a verbal update today about the appointment of the Head of Civil Service, rather than us having to find most of the information out from the press?
Well, as the member is aware, at least I hope he's aware, there was a written statement placed with your office, Mr Speaker, over the weekend, because we knew that this was a matter of some note, and therefore that written statement is available to all.
Paul Gordon Dunn.
Thank you, Mr Speaker, and I thank the First Minister for her answers. In relation to the payment of compensation to the innocent victims and their families, what progress has been made in recovering some funding from the clerical orders and other institutions who ran these deplorable homes?
Well, the cost estimates for financial redress range from £149 million at the lower end to £402 million as a central estimate, up to £668 million at the upper end. And contributions from the institutions that I've already referenced would help to defray some of those costs. A potential meeting was discussed with the two archbishops, that's the Archbishop of the Church of Ireland and the Archbishop of the Roman Catholic Church, and we will shortly be writing to both archbishops and to the institutions seeking to hold a round-table meeting to emphasise the seriousness of these negotiations and the urgency of making progress and to seek to agree principles which would govern those negotiations. I think, of course, it is a moral imperative, and I think it would be very warmly welcomed by the victims and survivors if the institutions stepped up in that way.
And that ends the period for listed questions. We now move on to 15 minutes of topical questions, and I call Gordon Dunn.
Again, thank the Minister for coming today. In relation to the protest that was held at the Maze at the weekend, I understand it was facilitated within the grounds of the prison, something which is a deplorable and unacceptable act. Can the First Minister give us assurance that she will follow up with the responsible authorities, including the Justice Minister, on this issue?
Well, thank the member for his question. The Justice Minister did alert her executive colleagues to the fact that this protest was taking place at the weekend. However, I note what the member has said in relation to where the protest took place, and we'll certainly be looking for an update from her in relation to that matter.
Gordon Dunn, supplementary.
Mr. Speaker, can the First Minister give us an assurance that this will not reoccur? And I must say that the matter, I was in the Justice Committee when the matter was raised by the Chairman with the Chief Constable, made it very clear that such a protest was not welcome in the area and that the Chief Constable should take some action relating to it. The Chairman made that very clear at the time, and I think we're extremely disappointed with the outcome.
Say this to the member, I'm sure the Policing Board will address this matter in due course. Of course, operational decisions by the Chief Constable should be reported there and accountable to the Policing Board. However, I will take the matter up that he has raised with the Justice Minister in relation to where the protest actually took place at the prison.
I'm going to call Tom Buchanan.
Thank you, Mr. Speaker. Minister, can I ask you, have you any discussions or have you any plans for any discussions with the US envoy, Mike Mulvaney, over the course of his visit to Northern Ireland?
Yes, I thank the member for his question. Mr Mulvaney has been appointed by the Trump administration to be an envoy to Northern Ireland, principally around economic development. So we very much look forward to speaking to him around his ideas around economic development. And the Deputy First Minister and I were due to meet Mr Mulvaney tomorrow morning, early on. I think he's also due to speak to the other executive ministers as well at that stage.
Tom Buchanan.
Thank you, Minister, for that answer. And what role does she believe the US can usefully play in helping to build sustainability, again, within Northern Ireland?
Well, the member is probably aware the US is our biggest international investor in Northern Ireland. Many firms are US based, and then they come and they invest here in Northern Ireland. And they do that because of the strength of our people here and the skills that they have. And we very much want to develop with Mr Mulvaney where he sees the upcoming opportunities for trade and investment in particular. I understand that he has a particular interest around financial technology and cybersecurity. So those are areas that we are very strong upon. So I'm looking forward to having that conversation with him tomorrow, and I hope that we can further drive economic investment into Northern Ireland, as I say, based on our people, based on our skills and our ability to do business.
I call Claire Sugden.
Thank you, Mr Speaker. The First Minister has publicly voiced her support for what could be called Charlotte's Law in Northern Ireland. Now, I appreciate that that would fall to the remit of the Minister of Justice, but how is the First Minister, as the Chair of the Executive Committee, influencing this piece of legislation?
Well, I thank the member for her question, and I understand that this matter is to be debated in this House later on today. I have met with both families who are campaigning around this. I think it is completely inhumane that the person who commits murder then does not tell the family where the body is to allow closure. And I think it is right that that should be reflected in the justice system. And I hope that this House will have its say today. And I do hope that they back this campaign, the campaigns of two families who no doubt will be watching very closely what we have to say on this matter.
Claire Sugden, supplementary.
Thank the First Minister for her comments, and I share her comments entirely. How does the First Minister feel that with less than 2 years left of this particular mandate, that it is unlikely that we're going to get this onto the statute before the next election in 22? Would there be another opportunity, perhaps through an LCM of the Westminster legislation that's currently passing through the Commons?
I think that's something that we should discuss. If we get the House to back this motion today, then we should look at the next stage as to how we can progress the issue, whether it's through this House or through an LCM. Dealing through the Westminster piece. Obviously, we would always much prefer to have our own legislation here in Northern Ireland, but if we're unable to do that, then the possibility of an LCM with Westminster should certainly be looked at, because it's about bringing closure to a family who's grieving greatly and trying to find a way to deal with that grief.
Call Jonathan Buckley.
First Minister, yesterday marked National Police Memorial Day, where we as a nation rightly paused to reflect on those gallant police officers who have lost their lives while on duty throughout the United Kingdom. A day which is particularly poignant in Northern Ireland, where since 1969 over 300 officers have been killed and many thousands injured. Will the First Minister join with me in ensuring that the police officers who gave their all are never forgotten and always remembered for their commitment and ultimate sacrifice and commitment?
Yes, I do thank the member for his question, and ordinarily I would have been attending National Police Memorial Day yesterday. It happens on a UK basis, and the 4 nations take it in turn to host that memorial service, of course, made all the more poignant yesterday by the killing on Friday of Sergeant Ratanen in Croydon Police Station, and we do send our sincere sympathies to his family and his colleagues at this time. We unfortunately know too well here in Northern Ireland what it is to have police officers killed and murdered, and therefore it is important that our public servants are remembered in this way. And I was particularly pleased to see the family of David Johnson meet with our own Chief Constable, because of course David Johnson, along with his colleague John Graham, were murdered in the streets of Lurgan in 1997, and it is important and right that we remember their sacrifice.
Supplementary, Jonathan Buckley.
Thank the First Minister, and I know she knows full well the threat to those who serve in our police office today is still something that's very real and brought into sharp focus, as she has mentioned, by the tragic murder of Sergeant Matt Ratna of the Met Police. Would she agree with me that as a matter of urgency, we must legislate for tougher sentencing for those who attack our emergency services, and indeed support mandatory life sentencing for those who callously murder them?
Yes, I mean, the subject matter of sentencing is something that I think this House will come back to in the near future, because as I understand it, the Justice Minister has a consultation before in relation to sentencing matters. We in Northern Ireland have the lowest sentence in relation to murders of police officers. When I look south of the border and I look to the Republic of Ireland, and I see that they have a mandatory 40-year sentence for capital murder of police officers without any discretion for judges. In England it's 30 years, in Scotland it's 20 years. So there is a need for us to step up and to look at sentencing as punishment, of course, but also as a deterrent to those who would seek to murder our public servants.
And I call Martina Anderson.
Margaret, First Minister, could I ask you, if you can, could you outline the total investment that has been made by the Executive Office to the Ebrington site in Derry, please?
I thank the member for her question, and to date the Executive Office has invested £38 million in regeneration of Ebrington, 15 million from 2016 when we took responsibility over for the regeneration of the site. And we've had quite significant investment in the site, as she will well know. And it's important that we continue with that development. We've been able to attract in private sector investment as well, which we very much welcome. And 23 of the 24 site buildings have an expression of interest, an agreement of lease or a lease in place. So that's very good progress on the Ebrington site, and we will continue to work with our partners in the North West in relation to the development of Ebrington.
Supplementary, Martina Anderson.
Thank you for that information. That will be much appreciated, I think, for the people of Derry to hear that. Also, Minister, there's been lots of engagements going on between the Executive Office and the Council with regards to the transfer of some of the buildings to Council, maybe on a phased basis, with the view of ultimately it all being held with Council. Could you give us an outline as to kind of the nature of the discussions that are taking place between the Executive Office and Council?
So the Council is very much a key partner with us in Ebrington, and they, like us, want to see the site up to its full potential. The transfer of the site is being progressed on a phased approach. She's absolutely correct in that. And the first phase of the transfer process relates to the delivery of the Maritime Museum on Ebrington, and the Council is developing a business case for the project and has identified funders, and we're committed in the Executive Office to providing £3.3 million towards what I think is 11.5 million of a project. So it's a very significant project for the North West. It's actually quite an exciting project in the Maritime Museum, and I hope it will realise its potential. As I say, we're working with the Council and will continue to do so.
Liz Kim is not on her seat. I move on to Paula Bradshaw.
Minister, the NHS COVID-19 app was relaunched last week in GB, and it included the option for Welsh. I'm just wondering, is any consideration given to our app here in Northern Ireland being put into Irish as well?
I don't think there has been consideration of that, but that would be a matter for the Department of Health to come forward, probably based on need, and if people have been asking for that in the Irish language. I'm not sure that that has been the case. There's certainly been no discussion around it.
Paula Bradshaw, supplementary.
Thank you for your response. I'm just wondering then, in the spirit of the new decade, new approach and the moves to take forward legislation around Irish language and other minority languages, would it not be a good idea in the spirit of moving forward?
I think the primary purpose of the Stop COVID NI app is to protect and save lives, and I think that has always been the focus. It's been about saving lives and saving livelihoods. That has been certainly the collective focus of everyone in the Executive. Our five-party coalition, not a duopoly, as one of the members, I think, said earlier on. I'm always amazed, Mr Speaker, how it's a duopoly when some people don't like what we're doing, and it's a five-party coalition when we want to take credit. But in any event, it is a five-party coalition, and people should remember that, and therefore we will work together to save lives and protect livelihoods.
And I call Pam Cameron.
Speaker, can I ask the First Minister for an update on the enforcement group which is being headed up by the junior ministers?
So the enforcement group that has been headed up, as she rightly says, by the junior ministers has been set up. Primarily it was focused on the Holy Land and the difficulties that were there in relation to the restrictions. It is much wider than that now, and we are continuing to work with our partners, the PSNI, local government, and indeed everyone else involved in enforcement, so that we can make sure that, as well as having the restrictions in place, that there is an effective enforcement regime as well.
Pam Cameron, supplementary.
First Minister for her answer. First Minister, what reports have been received in the past week on the activities in the Holy Lands in particular?
Well, I think that the police presence in the Holy Lands has helped with some of the difficulties that were there. I do regret the fact that there were a number of notices handed down to students, and indeed that some students were suspended. But it is important that we continue to try and work with our young people to get the message across to them. I note that there are some students currently self-isolating in the halls of residence, and of course we do send them our best wishes and hope that it doesn't become a wider spread. The Executive Office is meeting with the universities, both universities, tomorrow to discuss some of these issues that are before us. I know that there have been many scare stories out there about our universities and our young people, but I believe in our young people. I believe, on the whole, our young people want to do what is right, and I would appeal to them to abide by the public health guidance and the restrictions that are there.
I call William Humphrey.
Thank you very much, Mr Speaker, and thank the First Minister for her answers this afternoon. Can I ask the First Minister, what support has the Executive been providing to the economy, and in particular the aerospace industry here that is so vital to this city of Belfast, many of my constituents and people across the city, but also wider Northern Ireland in terms of the importance of our Northern Ireland PLC economy.
The Executive Office very much recognise the importance of the aerospace sector. We also recognise that it's not just an issue for us here in Northern Ireland, but for colleagues in Scotland and Wales as well. And that is why we took the opportunity to write to the Prime Minister, along with our counterparts in Scotland and Wales. This was an initiative from Unite the Union, and we were very happy to do that because we believe that there needs to be more recognition of the aerospace sector. It provides us with some very well-paid, highly skilled jobs. We are very fearful for the sector, and we want the Whitehall, Westminster to take the initiative because it is something that needs to happen on a pan-UK basis because it is a huge issue and huge amounts of money are involved in the sector.
Unfortunately, Mr Humphrey, time is now up, and could I ask members to take your ease to change the table. Okay, members, we'll now move on to questions to the Minister for Communities. And before I call Trevor Lunn to speak, just to remind members that question 7 has been withdrawn. So I call Trevor Lunn.
That's question 1, Minister.
Thank you, Trevor. So I recognise that there is an impact on waiting times for all appeal types as a result of the pandemic. My department has worked with the President of the Appeals Tribunals to offer appellants a range of hearing type options, including face-to-face oral hearings using teleconference, oral hearings using video link facilities, a paper determination based on papers before the tribunal panel. Paper determination cases only commenced on the 6th of July. Oral hearings using technology options will commence from the effect of today, the 20th of September. Face-to-face oral hearings are set to recommence from mid-October at the main hearing centre, and I've asked that alternative accommodation options be sought to facilitate hearings in local towns and villages.
Trevor Lunn, supplementary.
Yes, thank the Minister for her answer. She'll be aware of the almost 40% of PIP hearings which are actually unsuccessful at the moment. Could I ask her what's being done to improve the situation in terms of support for the Advice Centre to build skills and expertise to help people with these hearings to try and improve that figure?
Well, I concur with the member in terms of the support that the independent advice sector give people going through this process very much valued by myself and my department. I'm currently looking at funding for the independent advice sector, including some of the grassroots groups and even through the appeal service and others. And I'm sure the member will agree it is important that we make it as easy for people, because when they're appealing or they're applying for this benefit, it's because they really, really need it, and we need to make the process as easy and as simple as possible for them.
And I call Fra McCann, supplementary.
And could I ask the Minister how she intends to address the backlog in the appeal service?
Thank the member for his supplementary question. There is a big backlog, and the appeal service has commenced listings on a number of hearings and will continue to work with the President of the Appeals Tribunals and DFC to ensure that more cases are listed for hearing. The appeal service have also obtained a number of licences for technology options, so they can run a number of hearings at the same time. And they are also refreshing the hearing type options with the appellants using technology options that will hopefully result in earlier dates.
Call Pat Cadney.
Thank you, Mr. Speaker. And thank you, Minister. Has the Minister considered making any of the jobs and benefits office services that have been available by phone over the past months permanently accessible by phone? For example, allowing the claimant commitment to be completed by phone rather than in person?
Pat, I'm unaware of what the process is in terms of the long-term stuff, but it's certainly something I'm happy to look at, because we do need, in response to Trevor Lunn, we need to make this process as easy for people to access as possible.
I call Andy Allen.
What impact COVID will have on the capacity in terms of the face-to-face assessments, and also what work the department will undertake to ensure that a claimant or an appellant is offered the best suitable appeal type for them.
Well, the member will be aware that even in the last question time this was raised, I think it really is important, first of all, that the hearing takes place as close to the person as possible. So, because as he knows, they're all in Belfast, and not everybody who applies for this benefit is from Belfast, so we need to do that. We also need to ensure that the ability, should it be by telephone, by teleconferencing or in person, that the ability for someone to accompany an applicant is still there. And as other members have raised, that particularly the advice sector, the independent advice sector that supports people, is properly supported as well, to ensure that anyone, should there be an applicant or an appellant, is given the support that they need. And more often than not, it's a very, very stressful process for people applying for these benefits.
Next question, I call Paula Bradshaw.
Thank the member for her question. So the responsibility for coronavirus health protection regulations, as a member knows, lies with the Department of Health. However, my department has published guidance for the private rented sector landlords and tenants, which includes information regarding shared houses. The guidance makes it clear that everyone living in HMOs are members of a single household. I have no doubt that every member of this Assembly would join with me in appealing for all people in all types of households to adhere to the regulations and guidance. The operation of licensing of HMOs is a matter for local government, and it currently is led by Belfast City Council on behalf of all councils, as well as providing support and assistance to councils in the development of HMO licences scheme. My department has provided detailed guidance for local government in the exercise of their functions in relation to HMO licensing, and a statutory code of practice for landlords to manage their properties to the required standards. My officials will continue to participate in various cross-departmental groups, including those convened recently by the junior ministers, and continue to work with all stakeholders to address ongoing issues in the Holy Lands.
Paula Bradshaw, supplementary.
Thank you, Minister, for your response. You'll be aware that before we had the house parties, we had the house clearances where they were dumping excessively into the alleyways, and there was all sorts of vermin and just basically antisocial and very inconsiderate behaviour. It's clear to me that the HMO Act, as as stands at the minute, is not strong enough, and the enforcement powers given to council are not strong enough either. I'm just wondering, given these experiences in the last few months, what are you planning to do to make it better?
Well, certainly my officials have been part of working groups along with Belfast City Council officials, and it's quite open in terms of if Belfast City Council officials feel that the powers that they have aren't strong enough, then they need to feed that back to us. Certainly there is a big focus on landlords here, and as well as tenants, because they have to be responsible for their behaviour. But certainly in the case of strengthening powers, if it does come back from Belfast City Council, who are operating this on behalf of all councils, that there's a need for additional powers and then additional enforcement, I'm happy to look at that.
Call Jerry Kelly.
The Minister may have answered some of this. My question was around what are the present licensing standards, and we have had some comment from the previous speaker about trying to strengthen them. But surely there is an obligation on landlords and managing agents to deal with antisocial behaviour in the buildings which they own or manage.
I think yes, first of all, I do agree. There is an obligation on landlords to ensure that their tenants are behaving responsibly. There is also a focus and certainly responsibility in landlords, because in order to get their licence for HMOs, that they need to have a fitness testing. And there's also a responsibility of us all to be good neighbours. And where there are instances, and I concur with Paula Bradshaw, that even before the return to university started, there was problems in houses getting cleared and the debris that was left for local residents. And that, unfortunately left Belfast City Council picking the tab up. So there is a need to ensure that landlords fully accept the responsibility, including when tenants, before they go into the house, when they're in the house, and when they leave the house before new tenants come in.
Call Steve Egan.
Speaker, and thank you very much indeed for the Minister's remarks so far. Minister, you have already talked about the joint approach we're taking towards dealing with antisocial behaviour, and particularly COVID regulations. Could you outline the discussions you've had with the Justice Minister, who last week said that she was willing to participate fully but not lead this joint task force work, in particular in relation to the Holy Lands?
Well, the member will be aware that the junior ministers on behalf of the Executive are responsible for convening the group on behalf of the Executive. For my part, I'm not commenting on what any other ministers do. For my part, if I'm asked to look at additional powers, I'm asked to look at regulations or even additional support for councils, I'm willing to do that. Because, no one should be living in their own homes in fear or unable to get a night's sleep. Their kids are going to school absolutely exhausted, and their quality of life is completely diminished, and that's unacceptable. I do know that universities have stepped up to the challenge as well, and trying to ensure that if there are reminders needed, that they've been done, and that they've been quite public last week. But we seem to be discussing this problem every year, and we do need to fix it.
Call Matthew O'Toole.
Mr Speaker, Minister, you've said that if Belfast City Council come to you with a request for enhanced powers around HMOs, then you'll do something about it. But you also just said that this has been a problem for years. So can you take it from me and from others who are representatives for South Belfast that there's a major structural challenge around HMOs, their density and how they're managed in the Holy Land? And can you please ask your officials not to wait for Belfast City Council to come to you, but to reach out proactively and find out what we can do to sort this problem, whether it's by legislation or better enforcement or whatever else?
And the answer is absolutely yes. This problem has been, unfortunately, a perennial problem. Up until now, there has been a lot of complaints, but there has been absolutely no request that I am aware of for changes in the legislation or even asking for additional powers. Now, I'm going to go and check it out after you've raised this point today to be sure, but let me be clear again. If there are requests, then we'll certainly look at them, absolutely look at them. And indeed, I'm not going to pass the buck at all. I mean, HMOs was passed on to the council, but if the council, on behalf of all the other councils, are feeling that was passed on in April last year needs tweaked or needs to be changed, then let's have a look at it before the review kicks in next year.
Next question, I call Cara Hunter.
you, Mr. Speaker. Question 3.
Thank the member for her question. So the most recent waiting list for her constituency stood at 2,167, of which 1,241 applicants were deemed to be in housing stress. I am acutely aware that these numbers of people currently on the waiting list and those deemed to be in housing stress remains very challenging, not only for your constituency but right across the entire north, and that's why I'm focusing on seeking to deliver as many new social homes as possible with the available funding, but I'm also keen that we consider ways that we can increase the supply of new social homes to reduce the demand.
Cara Hunter, supplementary.
I thank the Minister for her answer. A number of rural communities in my constituency have voiced that they do not have enough sufficient social housing provision. I wonder if the Minister shares my concern on this issue, and can I ask what steps her department are taking to ensure that rural communities are not decimated as a result of lack of suitable housing?
The member will be, I'm sure, keen to know that I've met with the Rural Community Network on this very issue. I have a responsibility to ensure that there's rural proofing as well. But the main focus and the main responsibility I have is to ensure those in greatest housing need are housed as well, and it is a massive list that we're tackling right across the board. I also know that within rural communities that many have moved or settled in the private rented sector, and there's a lack of security of tenure. And it is a big issue, and it's something that I'll be taking forward, certainly transformational housing within the next few weeks.
Call Keith Archibald.
And I thank the Minister for her response, and I know she'll agree with me that the levels of housing stress are too high and we do need to tackle that. But in doing so and in making more social housing stock available, would the Minister also agree that it's a need to ensure accessible housing as well?
Absolutely. I mean, this issue has been raised in this Assembly a lot, about certainly homes to meet the needs of an ageing population, but certainly people with disabilities, but also accessible to where people want to live, want to raise their families and grow up in. I also think there's a big issue in terms of in the past where our own housing stock was sold under the right to buy and the stock was never replaced. And in many respects that displaced a lot of communities. And certainly they went to the private rented sector, which was okay at the time. Because of a lack of security, they've had to move elsewhere, and at times that is quite substantial miles away. So we have a big challenge, but we're certainly very, very aware of what we need to do, particularly in rural communities.
Call David Hilditch.
Thank you, Mr. Speaker, and I thank the Minister for her answers thus far. A few weeks back there, the Minister rejected a proposal on the floor of the Assembly in relation to lots living over the shops, and rightly or wrongly that happened. But you're right, this affects all constituencies right across Northern Ireland. You are aware of the situation, as you rightly say as well, but how are we going to increase housing for those in housing stress?
Well, the reason I rejected living over the scheme was, I had a lot of reports saying it wasn't value for money. So that is basically the main reason. And for grants to be put into private accommodation over the shops that needed disability access and needed proper storage and space would have meant additional public spend, so it just didn't work out value for money. In terms of ensuring that we increase supply to reduce demand, that's the big challenge. So I am going to bring proposals forward in the next lot of weeks, looking at even our NDA commitments, looking at revitalising the housing executive, looking at how we can prevent the housing executive or have them exempt from paying corporation tax, so that money will go back in, looking at historical debt, how we can deal with that so it will allow the housing executive to build. But I am acutely aware that those people who are living in housing stress is now going into 3 generations, and that is completely unacceptable.
Call Claire Bailey.
And I'm sure the Minister would agree with everyone in the House probably that the housing stress levels in Northern Ireland are just completely unacceptable. But given that that is already the situation and the financial hardship being levied with COVID, I'm also very mindful that some of the measures put in place as a response to COVID was a mortgage holiday for many. Can the Minister give us any assurances that no one in Northern Ireland will ever face eviction due to COVID financial hardship?
Well, the member will be aware that under Deirdre Harkey, she brought forward measures to prevent evictions, particularly during a global pandemic. I continued those and extended them until March next year. Unfortunately, you know, like many years ago, the mortgage relief scheme was taken away by the Tory government, and that did help a lot of people. I have spoken to people, even my own constituency, who are currently receiving mortgage holidays, but that in itself is a very stressful process, even having that. The measures that the Department, along with the Housing Executive and Housing Associations, put in to ensure, first of all, that people weren't evicted are still there. The Housing Rights Service is still there to ensure that anybody who finds himself in that situation get help as early as it possibly can. And what we need to ensure is that evictions under those circumstances are consigned to the past.
Moving on, I call Melissa McHugh.
Number 4.
I thank the member for his question. He will be aware that the Executive announced £29 million toward investment to support our culture, language and arts and heritage sectors. This is additional to the £5.5 million Creative Fund previously announced. These sectors make a substantial contribution to our local economy, to the quality of our lives, to our health and to our well-being, and in the shaping of our standing as a place to live and work and visit. They are vital to playing their role in delivering social renewal for communities and indeed the economy. My department is finalising proposals for a suite of funding schemes to maximise the impact of this very much welcome financial support in these most challenging of times.
Melissa McHugh, supplementary.
I'm sure like all members just in this Assembly are only too well aware to those that at the grassroots level that are really suffering throughout the whole of the COVID crisis, and particularly in terms of their loss of earnings and so on. And how can the Minister ensure just that support to the grassroots within arts and culture is delivered?
Well, I thank the member for his supplementary as well. I have just literally come out of a meeting with Minister Dodds on this very issue in terms of, you know, people who are involved in events and music, in sound and all that, you know, background stuff, as well as, you know, looking at some of the bigger establishments. What I want to say is this: arts and culture is an evolving thing. So people who are recipients of Arts Council funds are still getting their funds, but there are other groups who have been doing really great work, particularly from March, you know, taking the lead, who haven't got one penny of public funds, and we need to ensure that they're looked after as well.
Meg Nesbitt.
And I very much welcome the injection of funding for the sector. Minister, what scope is there for co-design to ensure that all sections of the sector have their needs addressed?
Well, I thank the member for his question, because it's really important, particularly in relation not just to NDNA, but in relation to this process going forward. The weakness is there is no arts and cultural and heritage strategy, none whatsoever. And so we're all kind of, you know, in a big queue, hoping to join that queue, put an application and get something. I mean, that is not a good way to do business. If we accept, and we do, that culture and arts and heritage not only help people but to generate the economy, then they need to be put on a proper footing. So I have met a group of musicians who are looking at a music strategy. I spoke to some freelancers who need to be supported as well, but they've all said long term they need to see an arts and cultural strategy in the same way there's one for sports. And for me, that's a big weakness.
Call Chris Little.
Thank you, Mr. Speaker. Can I ask the Minister why there is no cultural strategy, and how she will ensure that the creative and cultural funding reaches artists and organisations who have lost entire income streams as a result of COVID?
Well, the reason there was an arts and cultural strategy which is about to be produced, and then the Assembly collapsed. So there's one sitting there, it's 3 years old. And even from what some of the people who contributed to that are saying, it's not reflective of what was there 3 years ago. I can try and help as many people as possible, but I want to also ensure that those who have never received or had any recourse to public finance, public money, are serviced as well. So if we just look after the big institutions, there's nothing left for anyone else. And I'm sure the member would agree that's not a satisfactory position.
Mark Durgan.
And I thank the Minister for his answers. I, like everyone else, was delighted to hear the executive announcement last week that the arts were finally getting funded. So well done to you for your role in that. Now you've got the money in, the focus is going to be on how you get the money out, and it is vital that that's done in a fair and equitable way that gets the biggest bang for your buck, or our buck. Can or will consideration and assistance be given to those musicians and singers, I think, who have suffered throughout COVID, but were dealt maybe another blow last week with new rules on hospitality that have virtually prohibited them from earning money in that way?
That's exactly what I want to try and do as best as I possibly can. It's because of health restrictions that we have had to bring into place as a result of the global pandemic that's prevented people not just from opening their doors in terms of theatres, but certainly even those people who are performers, maybe even one or two piece bands who've just made their living, have been, as you say, faced a double whammy last week. And there's already a fund there now, so anyone it's opened until, they're still looking until the end of October in the Arts Council to help people in that situation. But we do need to ensure, until over the next few months, I imagine, that we try and help as many people as possible, particularly those who've had no recourse to public funds at all.
Call Paula Bradley.
Thank you, Mr Speaker. You've noticed me bobbing up and down there several times. Can I thank the Minister for her answers so far, and that indeed this money is very welcome. I know certainly as a committee we've been lobbied for months, it seems like now, for this money to become available. So just on that, and you'd mentioned earlier about the amount of people who have never received a penny, who have had nothing from any funding stream, just how quickly and are we likely to see this money begin to get rolled out?
Certainly I'm looking at finalising the potential schemes this week, talking to executive colleagues next week with a view going straight out into some of the ALBs, and then looking at ways in which we can try and open up applications for others who may have never went to the ALBs before. It's worth mentioning, I know the member knows this, but we've also got museums and libraries involved in this as well. And it is really, really crucial that not only do we keep those doors open, and that's right across the piece, but particularly for the groups who have emerged, who are actually doing brilliant work and keeping people mentally well, physically fit, providing enjoyment and entertainment, that they're supported as well. And a lot of these people are young people from marginalised and deprived areas, and they need our support as well.
Moving on, I call Linda Dillon.
Deborah Coog, question number 5.
Thank the member for her question. I launched the COVID-19 Recovery Revitalisation Programme along with Minister Poots on the 27th of July. Letters of offer for Tranche 1 of the programme were issued to all councils later that day, and payments totalling almost £6 million for that tranche have now been made to councils to provide much-needed support to local businesses as they recover and adapt to the impact of COVID-19. Around £5 million of this funding was provided by my department, with £1 million from DARA to extend this programme into rural towns and villages. The programme was designed to provide a maximum flexibility, enabling councils to work with local stakeholders to tailor their schemes to meet the best needs of their areas.
Linda Dillon, supplementary.
And can I thank the Minister for her answer, and just also want to thank her for the funding, because it was very, very much appreciated, I can assure you, by businesses right across Mid-Ulster, and also Minister Poots to our rural businesses. Can the Minister give us an update on whether the criteria for Tranche 2 will be changed, or whether it will be the same in relation to getting the most meaningful outcome?
Well, I just want to say to the member, and indeed to the rest of the Assembly, the criteria for this needs to be as flexible and as open as possible. There should be no impediments or barriers to prevent people getting access to much needed support. And that is working with the economic development units within each of the council areas. We are hoping that we will have additional money, not just from my department and Minister Poots, but even Minister Mullen has expressed an interest in this around green and blue environment projects, but also looking at sustainability of travel. And it is, for me, my responsibility is 5,000 over population. Minister Poots is 5,000 and under, and that does cover an awful lot. But what we know up until now, small bits of money have made a massive difference, and councils need to work with the local businesses to ensure that support's on the ground.
Well, Robbie Butler.
Mr. Speaker, I thank the Minister for her response to the question. Can the Minister advise if the Department were involved in the design of the overall recovery revitalisation scheme in order to achieve a consistent approach across the councils? And I do accept that there needs to be a level of flexibility, but consistency is also important.
Rural revitalisation is hard to say at times. I've struggled with it myself, but yes, the assurance is there. Both myself and Minister Poots want this to be accessible to people. It does need to meet their needs. They do need to go through the due diligence along with the local council. Local councils have worked with these people for a number of years, and consistency in a good way is really important. If people feel, and I'm asking any MLA to feel that there's been a negative experience in their consistencies, just let me know. I'm not promising or giving guarantees they'll fix it, but I need to know what it is.
Moving on, I call Sinead Ennis.
Question 6, Speaker, and can I apologise for not being in my place during the last section?
I thank the member for her question. To date, the Sports Hardship Fund was awarded over £1 million worth of grants to 500 grassroots sports clubs and organisations to help them cover essential costs, including maintaining their facilities during lockdown and paying critical overheads. These clubs who have not been in position to complete their sessions. So I've asked officials to explore extending the criteria for the fund to include sports clubs who are now experiencing financial hardship due to increased operating costs and costs associated with the facility hire and cleaning regimes. And as a result, I'm pleased to announce that the Sports Hardship Fund will reopen on the 1st of October.
Supplementary, Sinead Ennis.
I get to thank the Minister for her response. Can I ask the Minister how will her department work collaboratively with Sport and I to ensure there's maximum support for clubs as we continue to emerge from COVID?
Well, my department, as a member will know, will continue to work very closely with Sport and I, and certainly if their inbox is anything like mine in terms of the groups, particularly from grassroots areas, wrote in just asking for support, they will have no doubt where the needs are. But in fairness, this is an extension of a scheme on the basis of responding to the demand that's out there.
And that ends the period for a list of questions. We will now move on to 15 minutes of topical questions, and I call Mr Alex Easton.
Speaker, can I ask the Minister what discussions or plans is her department having with housing associations to try and increase the social housing build?
Well, I work with a number of housing associations, and they've been encouraged to try and identify, land that's available for them to build. We're also going through the exercise on behalf of the executive, public land that's surplus for housing. So we're going through that as well, and we're currently looking at areas in which potential housing developments can be brought forward.
Supplementary, Alex Easton.
Thank you, Mr Speaker. Thank the Minister for answers so far. Minister, in North Down I have over 1,229 applicants who are under housing stress and over 1,700 on the housing list. Has the Minister's department maybe started looking outside of the box, maybe looking at the housing executive starting to rebuild again? Because that might be a quicker process than the housing associations.
And the answer is yes. So under New Decade, New Approach, two of the aspects around corporation tax and looking at, getting rid of a historic debt, for want of a better term, was not just to put the housing executive in better footing to look after their maintenance, but also, for them to get into a position where they can borrow money to build. I owe Mark Durkin an apology, the member for Foyle. Last question time I said Foyle weren't the worst housing figures. They actually are. Next to that's North Belfast, next to that is West Belfast, and it goes down. But every constituency is dealing with unacceptable levels of housing stress.
I call Joanne Bunting.
If I could ask the Minister for Communities for an update on the review of the Common Selection Scheme for social housing, please.
Thank the member, and that's a timely question because I'm currently looking at the consultation that went out on the allocation of social housing points. I'm hoping to be bringing something very soon to my executive colleagues, to my committee colleague. Sorry, the committee. I'm not on the committee anymore, and I have attachment problems, but anyway, to the committee, and then I'll be bringing proposals to the House.
I think the Minister has detachment problems. I call Ms Joanne Bunting supplementary.
Just on the back of that, I'm grateful to the Minister that she's bringing forward something soon, but she'll be aware that hostels are sometimes the only option. So I'm keen to know what action she'll take to make sure that hostels are brought up to standard to suit those with A, mental health issues, and B, women and men who are having to flee a home as a result of domestic violence.
Well, certainly hostels are in receipt of vast sums of public money, so they need to meet the very best of standards. Your last point is something that I've been completely committed to looking at, both as an MLA. I feel it's really unfair. In fact, I think it's unacceptable that people leaving their home as a result of domestic violence are not considered intimidated. I think it's completely unacceptable that people who are fleeing their homes are also, joining a very big queue, and people who are not genuinely intimidated are effectively jumping that queue with so-called threats from groups. And that is a fact. We had a debate in this Assembly, I think Fran McCann brought it, and I think it's wrong. So I am committed to looking at not intimidation points, but looking at another way, because that is a really, really dreadful experience. But the verification of any claim of intimidation needs to be a lot stronger than what it is.
I call Liz Gibbons.
Corlin, can I apologise for not being in my place at the last section? Can I ask the Minister for an update on her plans for the redevelopment of Casement Park, please?
So I'm assuming that Sinead and Liz went out for coffee, and that's why the team is apologising for being late. The update in Casement Park is that it's currently waiting on plan permission, which the Minister for Infrastructure and her officials are carefully considering. I have met with the Ulster Council of the GAA very recently. There is absolutely no doubt whatsoever. I've also met with the MP for the area, and indeed his colleagues. I have absolutely no doubt whatsoever that everything that can be done will be done. Obviously, there will be an increase in costs. We will find out what they are fairly soon, and hopefully the planning decision is made for Casement Park, and we can get on with developing the last of the 3 stadia for Belfast.
Supplementary, Liz Gibbons.
Thank the Minister for her answer. And can I ask the Minister, can she give an assurance that her commitment to this long-delayed project will be delivered urgently?
Well, I want to give yourself the commitment, but indeed everyone in this chamber and those outside this chamber, that Casement Park is an absolute priority for me. And as soon as a decision is made one way or other, I have action plans for both. But hopefully we will get a favourable decision so we can get on with the construction of Casement Park.
I call Keith Buchanan.
Thank you, Mr Speaker, and thank the Minister so far for answers. My question relates to the Housing Executive. Is the Minister aware of any delay with the process with the Northern Ireland Housing Executive issuing awards to businesses to carry out works, for example, windows, etc.? And I appreciate there is COVID restrictions, but is any delays on the process?
I am aware of some delays. I know there have been procurement challenges that has set companies back who were awarded applications or awarded tenders for maintenance work. I am aware that the threshold is very low now, so it's easier to make a legal challenge on procurement ends, so it's slowing the programme down on top of a global pandemic. So I've asked the same questions as a member has, and I'm actually waiting on a report to see how that can be advanced much better than what it currently is.
Supplementary, Keith Buchanan.
Okay, thank you, Mr Speaker. Thank you so far, Minister, for your answer. Just in relation to that, I've got several companies within Mid-Ulster. They're getting it tight, no doubt, across Northern Ireland for business and work, and they've got contracts awarded but not fit to move on that. So I appreciate your response, and just if you could press those for a response as quick as you can. Thank you.
I absolutely will, and I will take it upon myself. As soon as I get an update, I will actually write to the member on that issue as well.
They call Harry Harvey.
Very much, Mr Speaker. Thank you, Minister. Could the Minister provide an update on the museum sector's recovery since it reopened, particularly in terms of visitor numbers? Thank you.
Well, I thank the member for his question, and I'm going to ask for an update in terms of visitors numbers because, you know, the museums did open up. There's a lot of loyalty towards museums, particularly the Ulster Museum, but certainly numbers for all open, you know, institutions like the museum and even Titanic have been, reduced as a result of COVID, but I will get an update for the member and send that to him.
Harry Harvey, supplementary.
Thank you, Speaker, and thank you, Minister. Is it likely that our museums will benefit from the Economy Department's voucher scheme?
Well, if I know the head of museums, they will ensure that every opportunity to benefit from any scheme, regardless from where a department they will. But just to give the member assurance that museums are certainly on the list for the COVID recovery programme for culture, arts and heritage as well, because they do play a vital role, and they're all struggling and they all need our support. And I'm actively looking at what support I can give the museums right across the board.
I call Claire Bailey.
Thank you. And I want to go back with the questions and answers the Minister had around HMOs earlier, and just maybe ask the Minister, could you clarify if there are legal limits to HMO densities in any particular area, for example, within wards or DEAs?
Well, I'll tell you something that you already know. I know that South Belfast and Coleraine have the highest density of HMOs right across the north. So, and that's obviously because of universities, but still not good enough. And I do think we need to look, certainly looking at planning and the issues around how many HMOs, concentration you can have in one area is the biggest issue up until recently that I've been asked to look at. But certainly, even just from other questions regarding Paula Bradshaw raised it regarding the Holy Lands in South Belfast in particular, and if there is a need to change legislation regulations, I'm going to have a look at that, because the way in which HMOs have been given licence and then the regulation and then the planning for HMOs, a plan decision when they come in, there's too many gaps and we need to bridge them.
Claire Bailey, supplementary.
Thank you, Speaker, and I do thank the Minister for that answer. But are you aware if there are currently legal limits? Is there an upper limit to what can be passed in terms of numbers of HMOs in any particular area at the minute? And if you're unsure, sorry, if you can look into it and let me know, because I'm struggling to find out.
And that's exactly what I'll do, because I'm afraid to give an answer that I'm going to be completely inaccurate. But I will. I'll find out and I'll write to you as well.
Call Colin McGrath.
Mr. Speaker, could I ask the Minister for her department's social and affordable housing targets for each of the next 3 years?
Well, the member will not be surprised to say I haven't got them on me, but I'll certainly, in terms of social housing, the targets are far too low. The targets are miserable, to be quite frank. And affordability is an issue as well. So there has been FTC money went into co-ownership to try to support people getting access to that, because there's been an underspent in FTC. But certainly in terms of the targets for social housing, in my opinion, unless we do something radical, we're going to fail every year in terms of targets.
Colin McGrath, supplementary.
Thank you very much, Mr. Speaker. Well, given the housing stress across the island and within the Minister's jurisdiction, what will you actually do to address those miserable figures?
Well, what I'll do is I'll look at implementing procedures that will target areas in most need, and actually try and look at a new policy of ensuring that the miserable experience of people who are now on the housing waiting list 5 years plus in Foyle, in North Belfast, West Belfast, just to name the top persistent 3 worst performing areas, that they're looked at as a matter of priority.
Well, from McCann.
You took me by surprise there, Cian Corley. I was busy listening to the Minister. Will the Minister give us an update on how she intends to provide more social housing, particularly in those areas of housing stress? But I think she's probably just after answering that.
Just to repeat what I said to Colin McGrath, and I can feel Fra's eyes burning into Colin McGrath's head at the back as he's told his question, but certainly will commit to look at the areas of highest demand, and we need to ensure that the supply is increased to try and reduce that demand as best as we can.
Given you have an adequate time to get your composure back again, you want to ask supplementary?
I And again, it's just a matter that's touched on just there. Will the Minister consider the reintroduction of ring fencing in areas of high demand for social housing?
I'm looking at ring fencing and other policy changes to try and increase supply to reduce demand for social housing, as well as looking at specific targets for affordability, particularly under co-ownership, and looking at how our FTC can be better spent to ensure there's more affordable homes.
David Hilditch.
Minister, as you indicated earlier, as it moves forward, Casement Park, there's a potential overspend of in around potentially £35 million at this stage. Will the sub-regional stadium programme under the football, will it also get an increase like for like, as obviously it was set out at the beginning, that each of those sports would have an equitable amount of finance and investment?
Well, I'm going to disappoint the member and say it's not automatic that that happens. There's been many big capital projects that we've dealt with that have overrun on spending. It's not good enough. I understand what he's saying. But it's not automatic that if the figure is X amount, that will automatically be transferred over to soccer. That's not my understanding at all.
David Hilditch, supplementary.
Thank you. Indeed, just to take that further, have you had any discussions with the Minister of Finance or indeed the Executive with this position at the moment?
Well, I suppose yes, I have met with the Minister for Finance over Stadia and sub-regional, and I have met with them in terms of looking at guesstimates, but until we actually bottom out what the cost is in terms of Casement Park, we are going to be dealing in speculation, and we are looking at addendums and finalising the business case for sub-regional as well, because things have changed from the first one was done. But I'm just being honest with the member, that don't assume that there's going to be an automatic translation for an overrun for Casement Park and the remainder is going to go to soccer. I haven't heard anything like that at all.
And members, the time is up, and that concludes question time. Invite members to take their ease to allow time. Point of order, Mr. Buckley.
Here today, in questions to the First and Deputy First Minister, I asked a question to Junior Minister Kearney on number 3, the question to Mr. Kelly. I did not receive a response or even an acknowledgement from the Junior Minister. I think I heard Mr. Speaker saying to the Clerk that I didn't ask a question. There was, in fact, 2 questions within my question, and I received no response. So I would ask the Speaker's ruling or judgment as to why that did not happen. Thanks.
I'll review the Hansard record of that, Mr. Buckley, and come back to you. Okay, so as I say, the time's up for the question time, and I invite members to take their ease to allow time for members to prepare for the next item of business, which will be the legislative consent motion on the immigration and social security coordination of the EU withdrawal bill. Thank you.
Members, thank you. The first item of business on the order paper is a legislative consent motion for the Immigration and Social Security Coordination EU Withdrawal Bill. Clerk, please read the motion.
That this Assembly agrees, in line with Section 87 of the Northern Ireland Act 1998, the principle of the extension to Northern Ireland of the provisions of the Immigration and Social Security Coordination EU Withdrawal Bill, dealing with social security coordination as contained in the bill, which was introduced in the House of Commons on 5th of March 2020.
Thank you. I call the Minister for Communities to move the motion. Minister Ira Liddahall.
Poor Margaret last can call you Mulliman round. I beg to move.
Thank you. The Business Committee has agreed that there should be no time limit on this debate, so please open the debate on the motion.
The primary focus of the Immigration and Social Security Coordination EU Withdrawal Bill is to end the EU's rules on free movement of persons in respect of Britain at the end of the transition period on the 31st of December 2020. These are currently retained in British law by the EU Withdrawal Act 2018. So this will mean that EEA nationals not resident in Britain at the end of the transition period and their family members will require permission to enter and remain in Britain under the Immigration Act 1971. Immigration and freedom of movement within the EEA are accepted matters under Schedule 2 of the Northern Ireland Act 1998 and are the responsibility of the Home Office. However, the bill also makes provision for the Secretary of State or Treasury or Department here acting jointly to make regulations to modify, for example, amend, revoke or repeal retained EU law relating to social security coordination. Social security coordination is part of the ongoing negotiations with the EU on future relations. The legislation in question is Regulation EC number 883/204 on the coordination of social security systems and its associated implementation, Regulation EC number 987/209. Also Regulation EEC number 1408/71 on the application of social security schemes to employed persons, to self-employed persons and to members of their family moving within the community and its associated implementing regulation, Regulation EEC number 574/72 and Regulation EEC number 859/2003, extending Regulation EEC number 1408/71 to nationals of non-EU member countries. Any changes to the coordination rules would only apply to people moving between the EU and Britain after the end of the transition period. The British Government signed an agreement with the Irish Government in February 2019, which protects the social security rights of all Irish and British citizens moving within the common travel area. Freedom of movement is an accepted matter, and the current social security coordination regulations operate in the context of freedom of movement within the EU. The regulations are a somewhat complex web of accepted and evolved issues, including the determination of the state to which contributions should be paid, competency for the awards of benefits, aggregation of contributions and the periods of residence for benefit entitlement, and provisions for some benefits such as child benefit, which are the responsibility of HMRC. I understand that the aim of the British Government remains to seek a new agreement with the EU, and in the event of a negotiated deal, it now seems that the British Government process to replace the retained social security coordination regulations with a new reciprocal agreement. Reciprocal agreements are international treaties and fall within the ambit of international relations. As members are aware, international relations are accepted matters. In the event of a deal, it seems therefore that the British Government proposes to revoke the retained social security coordination regulations, and the revocation would also apply across Britain under the ambit of accepted matters, including international relations. However, the negotiations are ongoing, and until the negotiations are complete and a deal is agreed, we will not know the precise scope and content of the new agreement. If a deal is not agreed and there are no reciprocal there is no reciprocal agreement with the EU, retaining the power in Clause 5 for a department tier to amend the coordination regulations may give us some flexibility over the limited devolve issues within the coordination regulations. Furthermore, Clause 5 provides a power to make consequential amendments, for example, to address inoperabilities or inconsistencies which may arise from the modification of the retained Social Security coordination regulations. This provides a power to ensure the continued operation of domestic social security legislation that refers to or is related to the Social Security coordination regulations. If this motion were not to pass today, it is therefore anticipated that the British Government would move to amendments to remove the power of the department tier to make regulations under Clause 5 of the bill. So this means that we would have no power to modify the retained Social Security coordination regulations in the event of no agreement on Social Security coordination being reached between Britain and the EU, or to make consequential amendments to our Social Security law. The only option to obtain such a power would be to bring a separate bill to the Assembly. There would be no power for the Assembly to amend the EU Social Security coordination regulations until such a bill completed its passage. I am also aware that it is anticipated that there will be very significant demands across departments for bills to be progressed through the Assembly before the end of the current mandate, so retaining these provisions in the Westminster Bill would help relieve some of the expected pressure on the legislative programme. I know that members will have seen the briefing provided by the Human Rights Commission in relation to the Westminster Bill. The Commission has made a number of recommendations which, in my opinion, are well outside of my remit, but I have written to the British Home Office urging the Westminster Government to give the Human Rights Commission recommendations serious consideration. I have weighed up carefully the arguments for and against these proposals, and on balance I have decided to move these today. I beg to move.
I call Paula Bradley, Chair of the Community for Committee.
Thank you, Mr Deputy Speaker, and the committee thanks the Minister for bringing this motion today. I'm sure that all members here in the Chamber will have read the committee's report, published on the 8th of July 2020 on the Legislative Consent Memorandum on the Immigration and Social Security Coordination EU Withdrawal Bill, but just in case, I will also provide some background and update members. The committee was briefed by the Department on the main purposes of the bill and on the Legislative Consent Memorandum on the 11th of June 2020. The primary purpose of the bill is to end the EU's rules on free movement of persons in respect of the UK at the end of the transition period, thereby bringing EEA nationals and their family members under UK immigration control. Members will undoubtedly have their own views on this specific issue, but it is important to emphasise that immigration and freedom of movement are expected matters under Schedule 2 of the Northern Ireland Act 1998. As such, this Assembly has no powers to amend those laws that pertain to immigration and freedom of movement. However, the bill will protect the status of Irish citizens in UK immigration law once free movement rights end. As Social Security is a devolved matter, the NI Assembly does have a role in considering the Social Security coordination regulations, and this is really the focus of the memorandum. In particular, Clause 5 of the bill will introduce powers to enable Westminster and the Assembly to amend retained EU law governing Social Security coordination post-EU exit. Clause 5 and consequently Schedules 2 and 3 of the bill was therefore the key clause for committee consideration. At its briefing on the 11th of June, the committee was advised that the Executive had agreed to proceed with the legislative consent motion on this issue. Notwithstanding what I have just said regarding immigration and free movement of persons, the committee recognised that the retained regulations are a complex mix of accepted and devolved matters, and a joint approach to amending these regulations, i.e. between a Minister of the Crown and the NI Assembly, therefore offers the potential to amend the law in a coherent way. That is what the bill will allow should the motion be supported today. Members were assured that the devolved competence of the Assembly would be respected and future subordinate legislation would require the approval of the Assembly. This is, of course, to be welcomed. There was some concern initially that giving Westminster the power to legislate on our behalf might somehow constrain the ability of the Assembly to legislate on social security matters. Therefore, during consideration of Clause 5, members asked the Department about the viability or advantage of taking forward an Assembly bill on these matters, rather than agree to a bill being taken forward by Westminster. However, the Department assured the Committee that the bill does not deal with the specifics of social security benefit, but rather gives the Assembly the powers to make regulations in respect of social security coordination following a future agreement between the UK and the EU. However, some members did note their general uneasiness with the use of LCMs in principle rather than bespoke Assembly legislation. It is not the way we would prefer to deal with legislation, but we recognise that it is necessary in this instance. I would mention that I welcome the inquiry by the Committee on Procedures on the use of LCMs, and I am sure the Committee for Communities will offer its view in due course. The Committee then noted a draft legislation consent motion at its meeting of the 1st of July 2020, but recognised as a result of the bill being amended at third reading, this motion would also likely change. The Committee was also briefed on these amendments to the bill, which were carried in the House of Commons on the 30th of June. These did not reflect changes in policy, but were required to omit references to the Scottish Parliament from the bill to reflect the decision of the Scottish Government not to proceed with the LCM. At its meeting on the 8th of July, the Committee then agreed in principle to the extension to Northern Ireland of the provisions of the Immigration and Social Security Coordination EU Withdrawal Bill as contained in the amended Clause 5 of and Schedules 2 and 3 to the Bill through an appropriate legislative consent motion. The Committee was therefore expecting the amended motion and was briefed on it by departmental officials at its meeting on the 16th of September. At that meeting, the Committee agreed to support the amended motion. Therefore, Mr Deputy Speaker, on behalf of the Committee, I support the motion.
Sir Mark Durkin on Cancha.
I would ask Cion Corlia and thank the Minister for bringing this to the House today. This has been discussed at the committee a couple of times, as the Chair has outlined here today, and I think it is fair to say that I'm not the only member who's been a bit cautious, maybe even a bit confused about committing to supporting this. That has been compounded, I suppose, by the arrival of correspondence from the Northern Ireland Human Rights Commission last week that the Minister has referred to, and the commenter on her action stemming from that. But I'm just going to ask and seek some clarification and assurances from the Minister today, which I'm sure she's well able to provide. My colleagues, the MP for Fawell and the MP for South Belfast, voted against this bill in Westminster, and we have a number of concerns about it, and therefore by extension concerns about this Assembly giving our consent to it. Although this LCM deals only with the social security provisions of the bill, I should take this opportunity to reiterate our opposition to the swathe of delegated powers it hands to the Tory government, the party of the hostile environment, to establish a new immigration system after the transition period. On the social security provisions, however, I do have a number of questions that I would appreciate a clear response on from the Minister. Could the Minister confirm, and I think she already has, that if the Northern Ireland provisions were omitted from the original bill, a further Assembly bill would be needed to ensure that her department has the necessary powers to amend retained EU law on social security coordination? This would be preferable, I'm sure, and the Minister has alluded to this, as is the Chair of the Committee, as it would give this House the time to scrutinise those provisions and to set out our opposition to the immigration clauses. The SDLP wants this system to work, and we are conscious of the time pressures with the pending exit from the EU, but to be frank, handing any powers over to a Tory government should be a last resort. I must say that this LCM is kind of difficult to square with the Minister's recent confirmation, welcome confirmation, that social security powers would be returned here from Westminster, having been handed over by some parties here to the British Government at the time the Welfare Reform Act was approved. The Ministers confirmed that the regulatory powers will be coming to the Assembly, but that begs the question, then why not the primary legislative powers? If there's a reasonable explanation for these to be made in London rather than in this Assembly, now is the time for us to hear it. The SDLP supports social security coordination with the EU and retaining EU provisions given our border situation. I do note the concerns raised by the Northern Ireland Human Rights Commission about the impact that Schedule 1, paragraph 6 may have on the payment of childcare within universal credit for working tax credit for cross-border workers who rely on childcare providers based over the border. And I can think of some families in my own constituency this would apply to. The childcare has to be provided in the UK in order to access these elements, and it is EU law that has addressed this discrepancy, not the common travel area. It's another example of the creeping borderism that Brexit has instigated for those who can least afford it. And the Minister in this Assembly must be alert to it, and I'm sure many of us are. I will listen carefully to the Minister's response on this particular issue, on how she will ensure that decisions will be made here and not in London about protecting practical childcare options for our cross-border workers. I urge the Minister to outline what the implications of all of these issues are and to explain why this LCM is absolutely necessary now, as opposed to a bill coming through the Assembly going forward.
Now call Kelly Armstrong.
Thank you, Deputy Speaker. As others have said, the primary purpose of this bill is to end the EU rules on free movement of persons in respect of the UK at the end of the transition period, which is not too far away. We know that this means that EU nationals who are not resident in the UK before the end of the transition period will be required to obtain permission for themselves and their family members to enter and remain in the UK under the UK Immigration Act 1971. It will not come as any surprise to say that this is one of the areas that Alliance is least comfortable with. It's not something that we support. We do support the four freedoms within Europe, but we're realists, and we absolutely recognise and realise that what is contained within this bill, Part 2, Clause 5, is vitally important if we're to move forward with social security payments for those people. As the Minister has outlined, if we had to bring a bill to this Assembly, it would take time, and we're probably heading into one of the busiest periods in this Assembly that we will see for some years with the transition periods that are with the end of the transition period. I absolutely, others have mentioned, stealing my thunder, Mark Durkin, the Human Rights Commission and the issue that has been raised, and of course with the chair of the committee about childcare issues, and that is something that we need to consider going forward. But for this time, even though we are extremely concerned about the implications for freedom of movement, Alliance Party is content that the social security coordination with the EU is passed and progresses as necessary. Thank you.
Next year, Sir Matthew O'Toole. On can't call Matthew O'Toole.
Thank you, Mr Deputy Speaker. Grateful to the Minister for bringing this motion today. Mr Deputy Speaker, as my colleague Mark Durkin has just said, we have both specific and general concerns with the provisions in this bill to which we are being asked to give legislative consent today. Though the provisions in the bill which touch on devolved competence and therefore require our consent don't relate directly to immigration, as has been said, that is an accepted matter. It is still worth putting on the record, and I intend to do so strongly, that this bill is the legislative device which puts to an end many of the rights associated with freedom of movement, representing a proudly pro-European party and constituency, a constituency that includes a world-class university with students and academics from across the EU and indeed many EU nationals in general. I want to put on the record my own profound sadness and frustration that freedom of movement into Northern Ireland is ending. This is a profound loss to our society, our economy and our culture. though people in Northern Ireland, the people here are the people we represent, can still avail of freedom of movement across the EU through exercising their Irish and EU citizenship, it is a tragedy that we, as a society here, are losing the contribution of inward freedom of movement that so many EU citizens have made to our society. That is in part why, as Mark Durkan has said, my predecessor Claire Hanna and our party leader Colin Eastwood voted against this bill at Westminster. On the specific provisions of the bill, specifically Clause 5, which Kelly Armstrong just mentioned, on social security coordination, clearly there are legal reasons why much of this has to happen. But what we are being asked to give legislative consent for, it requires the Minister to give us a little more detail, I think, on exactly why she has chosen to bring forward an LCM rather than discrete legislation. Firstly, though we appreciate this is a complex area of law, given the clear statement from the Minister's Department that they would prefer to properly exercise social security powers at a devolved level, why was the decision made to agree to Westminster taking the power to legislate rather than introduce legislation here at Stormont? I should say it would also be helpful if the Minister could give us a little more detail on how this legislation interacts with the Common Travel Area. It does, not the parts we're being asked to give legislative consent to, but earlier provisions in the legislation set out the rights of Irish citizens. That's welcome. But clearly there are issues that need to be explained in terms of how it interacts with the Common Travel Area. If the Minister could say a little bit more, that would be welcome. But just in relation to why the Department chose not to introduce primary legislation here rather than accept an LCM, it would be helpful if she could give a clear statement on behalf of her department as to why they chose not to bring a clearer statement. I know she's alluded to it in her remarks at the beginning as to why they chose not to bring primary legislation, given what she has said is their preference in terms of exercising social security powers at the devolved level. We have heard specifically from the Northern Ireland Human Rights Commission about gaps in terms of cross-border childcare provision around universal credit. If she could say something about how that's going to be addressed. I know she's already writing to the Northern Ireland Human Rights Commission. But more broadly, I think in conclusion, Mr Deputy Speaker, we're going to do lots of this over the months to come. And it's really concerning that we're doing it at such a fast pace. We seem to be getting into a vicious cycle of not having enough time to scrutinise, of having to do things quickly because there's not enough time to scrutinise, and then we don't have enough time to scrutinise because there's loads that we have to get through. It reinforces itself, and it's not helpful. I accept this is something that's going to happen across the executive in multiple different departments. I think that's why it's important that the First and Deputy First Minister give a clear statement to the Assembly about the volume of primary and secondary legislation that committees and plenary are going to have to get through in the months to come, because it won't be good enough in the new year whenever we have to explain not just hopefully we'll have a deal, hopefully we won't have complete chaos on the 1st of January, but even if we do have a deal and we have specific bits of difficulty and disruption that come from substandard scrutiny in this Assembly, we will have to explain to our constituents why we rush through legislative consent motions, why we rush through secondary legislation without giving it proper scrutiny. So in that spirit, I'd like to hear a little bit more from the Minister on some of the subjects that I've touched on today.
I call Claire Bailey.
Thank you, Deputy Speaker. And I can't support this LCM because this bill repeals the main retained EU law relating to free movement and brings EEA nationals and their family members under UK immigration control. Controls, as has already been pointed out, have deliberately created a hostile environment by the UK government. And it's another reason why Brexit is not good for Northern Ireland. And let's not forget that we are meeting today in the midst of a public health crisis that has pulled the veil back on the deep inequalities and unfairness in our society, that has shown the extraordinary value of what so many workers do for our families and for our communities. They give excuses that we're just too busy or that we cannot foot the bill as reasons to allow this to pass without taking responsibility. It's just pretty shameful. This bill today will send a very powerful message to people that they are not considered by the UK government to be welcome here. Our shop workers, not welcome. Our refuge collectors, our local government workers, our NHS staff, our care workers. But of course they are. So for those who were out clapping for the thousands of EU nationals in the NHS and the care sector are now sending the message today that they're no longer welcome, that is not fair, and I, for one, cannot support it. I believe this bill will destroy opportunities for future generations and will split even more families apart. It will result in many thousands of EU nationals losing their right in the UK. It will copper fasten a hostile environment even further. This bill brings to an end the one part of the UK migration system that works well, the free movement of people. Pushing ahead with this bill in the midst of a public health crisis is badly misjudged and shows that the UK government is completely out of touch. The primary purpose of the bill is to end for the UK the EU's role in the free movement of people at the end of the transition period. Those rules are currently retained in UK law by the European Union Withdrawal Act. The ending of the rules on the free movement will mean that EEA nationals who are not resident in the UK at the end of the transition period, New Year's Eve this year, and their family members will require permissions to enter and remain in the UK under the Immigration Act of 1971. What we should have had is a bill that makes it simpler instead of harder to recruit the NHS, the social care and other staff that we need, and not one that uses financial thresholds such as a poor substitute for skills, experience or contribution. We should have a bill setting out a comprehensive system of visa extensions for those frontline workers and their families. We need a bill that scraps the minimum income requirements for family visas and suspends other financial thresholds, acknowledges that migrant families and workers have had their incomes reduced, just like so many other workers. That is not this bill, and therefore I cannot, in good conscience, support it. We have witnessed time and again that this Tory government care none for the principle of consent, and today everyone in this House should refuse it.
I call Jim Allister.
Thank you, Deputy Speaker. This, I think, is the first debate touching upon Brexit issues that I've sensed any reality coming upon this House. You know, it's very well to have all the bravado of opposing a bill such as this in Westminster and the SDLP and the Alliance Party preening themselves as great Europeans defending the principles of free movement and all of that, and berating the idea of the United Kingdom controlling its own immigration and its own borders. But here they are today, and courtesy of a Sinn Féin minister, no less, this Assembly is about to, quite correctly, is about to endorse fundamental principles of Brexit, that the United Kingdom should control its own immigration, that the United Kingdom, in that sense, should control its own borders. And how luxurious is the irony that it is a Sinn Féin minister that is bringing to this House that very proposition, that this House should consent to legislation in Westminster that does that very thing. That's progress. That's good. It's the first dose of reality, and it won't be the last touching upon Brexit. Some say, vote down this bill. Oh, you vote down this bill, you vote down the survival of the rights of Irish citizens to social security. Is that what you want? I don't know. But let's be very clear. Brexit always was a national issue. It always meant that this nation of the United Kingdom was going to have to take some unitary decisions. And those unitary decisions touching upon immigration and borders are central to this bill. And all those who paraded themselves as those who would never accept those implications of Brexit are amongst those who today will go through the lobby if a vote is called to vote for it. That's good. And I look forward to further reality in this House.
Sir Jerry Carroll on Council Call. Jerry Carroll.
Thank you, Mr. Speaker. I want to start by saying that People Before Profit and my party unequivocally oppose the Tories' Immigration and Social Security Coordination Bill. And more widely, we oppose Boris Johnson and the Tories' nefarious plans for restricting the freedom of movement for people into Britain and indeed the north of Ireland. British immigration policy has always been based upon exploitation and indeed structural racism. And it is deeply worrying that the Tories wish to repeal current laws in a way that inevitably harks back to even more racist immigration policies of the 1970s, or perhaps even worse, and aims to implement a points-based system that mirrors the racist practices of many other countries across the world. And in particular, we oppose Clause 1 of this bill, which will end freedom of movement from other EU countries, replacing it with nothing and opening the door to an even more restrictive immigration system. Mr. Speaker, to be frank, I'm no big fan of the EU as an institution regarding the question of immigration. It does have a terrible record in some regards, as thousands of dead migrants in the Mediterranean Sea illustrate in a tragic and painful way. That said, while the EU does have a shocking record in treatment of refugees outside of its borders, the freedom of movement between EU states is one principle that should be robustly defended. And as a socialist, I am opposed to borders and division generally, whether they are erected across states or inside people's heads. And I support the freedom of movement of people across the world, not just in Ireland or in Europe, but everywhere. If the rich man can move freely across the globe, so too should the poor and marginalised avail of such a right. The main thrust of this bill, however, is to ensure that legislation for free movement across the EU will be repealed, and afterward EEA citizens and their families who come to Britain will be subject to immigration laws and require permission to enter and remain. And the Tories already set out their stall, as others have indicated, toward a future immigration points-based system, which in my opinion will be inherently racist. For example, one piece of government commission advice states that only the, and I quote, brightest and best talent from around the world will be allowed entry. This is Tory speak for shutting the doors on those people who are fleeing from war, poverty and climate destruction, all of which were a great responsibility on British imperialism, actually, in particular. Thus, while the long-standing question mark over the Irish community living in Britain may have been partially addressed in this bill, it jeopardises the lives of thousands and thousands of other migrants living in and entering Britain in the period ahead. So we oppose this bill because it represents a dark day for immigrants and refugees who are in search of a better life. This bill is being pushed through Westminster, and this LCM relates to the provisions obviously devolved to here. And I recognise that some in this chamber, the Minister may have indicated this already, who oppose the Tories' immigration bill will probably and sort of have in effect made an argument for passing the LCM that it may allow the Assembly to make the most of a bad situation that's been forced upon us and allows us to influence social security payments. And I respectfully disagree with this argument and believe it is a mistaken approach to take and regards or represents endorsing a dangerous piece of legislation in this way. And I would urge members to look closely at the recent report from the Northern Ireland Human Rights Commission, which does state that there is no secure protection for those who will have settled status prior to the closing date of the scheme in June 2021, nor is there any provision for safeguarding the rights of those EU citizens or migrants who arrive before January 2021. In addition, clarification is needed as to how these changes of rules will apply to Irish citizens in Britain as well. In my view, Mr Deputy Speaker, we should have no truck with this Tory bill, and every method of resisting it should be utilised, including rejecting the use of a legislative consent motion. The parties in this chamber should unite to obstruct the Tories' plans as much as they can, and I note that the Scottish Assembly has until now refused to implement an LCM on these provisions, and I would suggest that the Executive could also follow this path as well. And instead introduce, as others have indicated, introduce its own bill that addresses social security payments for immigrants. This, in my opinion, should include a rapid expansion of social security payments for all those in need. And it is unclear to me still why the Executive could not have done this, because we're all the talk of needing to implement a racial equality strategy. The truth is, this executive has presided over a shocking treatment of refugees and asylum seekers for many, many years. So I would say, in conclusion, open the borders now, céad míle fáilte to refugees, asylum seekers and immigrants, and reject the Tories' approach to the issue of immigration, and this Assembly should step up to defend migrants, refugees in a way that offers a positive and equal future for all. Thank you.
Thank you. Agus neisirim Sarah and Ira on conclude Shakar Leishan Gisbracht. I call on the Minister to conclude on the debate. Thank you.
Gormagat last Concolia, and I suppose it was inevitable, really, that once this LCM is brought forward, people will use it as an opportunity to talk about their opposition to Brexit, so I have no issue with that. But what just all need to be clear about is that this LCM is on the basis of a no deal to ensure the benefits get paid. And I know you know that, and you are making politics, and that's fine, that's what this chamber is for. But at least be honest. At least be honest. And in relation to giving powers to Westminster in the first place, it was done so you could bring £500 million protections to mitigate against the worst impacts of the Tory government. So let's be honest about that too. So we're bringing powers back, and if I had an opportunity, I wouldn't be doing this. But I'm not about to cut people off at the knees over rhetoric, folks, frankly. It's all very well and good to get up and say what you would and wouldn't do, most of which I agree. But at least I'm honest, and be honest and do it with integrity about why you want this not to happen. I understand it's anti-Brexit, so I'm with you on that. But see the rest, it's guff, and you know it's guff. If there was an opportunity, and there should be an opportunity to bring bespoke legislation, but see, because of COVID and everything else, it's slipped. But I do agree with you on this. There does need to be better social security legislation here, where we have the ability to scrutinise it ourselves, to protect people who are worse off. That's a raison d'etre for us all. That's where we all agree. So I'm not getting into the whole issue of who said and what said. This is simply about the power to make regulations on the basis of a no deal, so people aren't left with no child benefit or benefits. Shanae. So the rest of it is about free movement. It's nothing to do with me. It's nothing to do with this either, although I agree with your whole issue. In relation to everything else that's been said, any queries that have been raised, I will faithfully, as I think I've done up until now, try and get a proper response, because I want to be on the record and challenging some of the things that were said, as well as giving you the information. And with that, I commend this to the House.
Thank you. The question is that the motion standing on the order paper be agreed. All those in favour say aye. Contrary, no. I think the ayes have it. The ayes have it. Okay, so the motion passes. Next item is private members' business on the order paper, and that's a motion on children with hearing difficulties and deafness. I will ask the clerk to read the motion, please.
That this Assembly recognises the importance of early detection, intervention and support for children with hearing difficulties and deafness, acknowledges the negative impact that delay can have on their future educational attainment, and calls on the Minister of Health to take immediate steps to identify and address urgently the backlog of postponed audio appointments and cancelled cochlear implant procedures that have arisen as a result of the COVID-19 crisis.
Okay, thank you. Agus neisirim Sir Catherine Kelly leishin rún a chorhantasa. I now call Catherine Kelly to move the motion.
To move.
Thank you. The Business Committee has agreed to allow up to 1 hour and 30 minutes for this debate. The proposer of the motion will have 10 minutes to propose and 10 minutes to wind. All other speakers will have 5 minutes. Please open the debate on the motion. Thank you.
Romeo Goodless, Ken Corlia, and good afternoon, everyone. As we have just come through International Week of the Deaf, I thought I would attempt some sign language in support of children, young people and adults who may be watching the debate. Recently, the Minister for Communities has committed to bringing forward to the Assembly sign language legislation once co-design and co-production work has completed. She has informed me by written answer that the legislation will be built on the principles of equality and social inclusion and ensuring that the deaf and hard of hearing community have the same rights and opportunities as those in the hearing community, and they are able to access services in their own language. Hearing is one of the most important senses we have. The onset of the COVID-19 pandemic has seen the number of people waiting for diagnostic testing soar. The latest figures published by the Department of Health's Information and Analysis Directorate in June reveal an almost 150,000 long waiting list for diagnostic tests. Faced with such a backlog and knowing that for many people these are life-saving tests, it is easy to see why almost 8,000 people waiting for hearing tests might not be at the top of anyone's list. But I want to argue that they should be. Diagnostic tests to identify hearing impairments may not be life-saving, but they are profoundly life-affirming. And for young children, late diagnosis and delayed intervention is likely to have a lifelong adverse impact. The evidence is clear. Early detection and intervention leads to better outcomes in terms of language acquisition, whether spoken or sign, young children's emotional and cognitive development, and closes any educational attainment gap between hearing and non-hearing pupils. Late diagnosis amongst the young can result in a level of disadvantage they may carry for the rest of their lives, leading to poorer educational outcomes, worse employment opportunities, more ill health, and including mental ill health. Right now, the new school day could prove detrimental to the education of young children not yet diagnosed. The need to juggle learning and follow new school safety measures is very worrying in an already stressful situation. As it is now imperative that we wear face coverings as we go about our daily lives, this in itself is another added barrier to children and adults awaiting a diagnostic test. Where once they may have been reliant on lip reading to engage in conversation, now they are unable to. This new added barrier and complication must be taken into consideration to alleviate the anxiety that this must cause. It is now vital that the Department of Health and the Department of Education work together, as required by the Children's Services Cooperation Act, to urgently oversee development of an action plan to address any backlog of children with delayed diagnosis of deafness. It's essential that parents and children have a role in building this plan. This invisible condition requires regular screening to ensure the problem is detected sooner and in the hope of a better outcome. Therefore, it is of prime importance that the Department of Health ensures continued vigilance regarding children's hearing. Diagnostic testing or the fitting or adjusting of aids cannot be carried out remotely. I would like to mention some real-life experiences of children and their parents during the past 7 months. Parents not being able to reach trust support services when hearing aids break. Parents and carers having to pay for microsuction for their child when appointments are cancelled. A parent recently from the Western Trust area informed the National Deaf Children's Society about having contacted audiology as her son's moulds did not fit. They were able to send out new moulds, adapted from the previous pattern, which worked out very well. However, the lady knew other children who were not so lucky. One child had loose vents causing infection, and the only action taken was to prescribe antibiotics unseen, which led to recurring infections because the problem with the vents was not addressed. These are only some of the issues which have been highlighted by parents and carers with the National Deaf Children's Society. Remote audiology does not work for children who have hearing difficulties or who are deaf. It has serious implications on the early intervention that is needed. I believe that currently there is no framework for paediatric audiology in the North. From what I have read, in 2018, the Regional Audiology Forum agreed that it would develop a set of quality standards for paediatric audiology services to be applicable from birth to 18 years. Department of Health were then to sign off on it. Will the Minister take this forward in light of the increasingly lengthy waiting lists? It could go some way in ensuring measurable and continuous improvements of services, whilst improving access for our children and young people. In supporting this motion, members will be adding their voices to calls to the Minister of Health to take a moment amongst the clamour of tackling the impact of COVID-19 and help around 8,000 people, young and not so young, to get their hearing tests and take action to address postponed cochlear implant surgery. We need seamless access to hearing health services without interruption or restrictions. I call upon the Assembly to support this motion. Thank you.
Call Pam Cameron.
Thank you, Mr Deputy Speaker, and can I first of all just thank the members opposite for bringing this very important issue to the fore and for securing this motion today. If we were to make a list of impacts of COVID-19, we would be here well into the night. But when it comes to prioritising and rectifying those impacts, difficult decisions have to be made. Certainly within our health service, faced with such wide-ranging disruptions, it's not an easy task. Last week, the Executive announced the intention to redress the crisis in cancer care, and that is right. It is life or death, and I very much welcome that focus. But we must also recognise the quality of life impacts too, the life opportunities impacted upon, and that's why I believe today's motion is so important. Across Northern Ireland today, there will be parents sick with anxiety about health and welfare of their children, who need intervention to address deafness. As each day goes by, the despair grows greater for some. We simply cannot allow this to continue. For the health, education and employment outcomes of those affected by deafness, we must focus on getting appointments back and meeting that need. The figures show that education outcomes are not as high for children who are deaf. None of us should accept that. Rather, we should be asking why, and then setting about addressing that inequality. The reality is that early intervention is proven to help deal with this imbalance. That is why this motion and the call to action is so important. We need audiology appointments ramped up, Mr Deputy Speaker. We need the testing back on track, and we need our health service at large to get back to face-to-face appointments where virtual simply does not work in this case. We also need to be aware of the new challenges of our deaf community face. The prevalence of face masks in society now poses a real challenge in communication with those who lip read. I commend my colleague, the Education Minister, for factoring this into his decision-making around masks in schools. Society at large needs to take a similar cognizance. Mr Deputy Speaker, like so many areas of the health service, we need a speedy return to service in this particular field. Early intervention is proven to help these children and young people. We need to make sure that intervention is indeed early and that intervention allows that potential to be fulfilled socially, educationally and in terms of employment. Mr Deputy Speaker, we support the motion. Thank you.
Colin McGrath, one can't call Colin McGrath.
Thank you very much, Mr Deputy Speaker, and my thanks to the proposers of this motion today, and I rise to support the motion before us. Mr Deputy Speaker, here we are 6 months later and coronavirus has altered just about every facet of our daily lives. We have all had to evolve and adapt and change the way we go about our lives in order to flatten the curve and to save lives. We have all had to make sacrifices. But what are those who have had to have additional health needs, and how have they had to adapt in the current crisis? I'm speaking today specifically of the case of children with hearing difficulties, deafness, and the implications of coronavirus on early detection, on intervention, and about support for them. Over the last 6 months, we have seen appointments having to be postponed or at worst cancelled altogether for those early detection and intervention appointments. Most of the cochlear implant surgery has been cancelled altogether, and there are now more delays in the diagnosis of children with hearing difficulties. Mr Deputy Speaker, we all know that language issues can be particularly contentious here in the North, but we can all at least agree that language development for our children is key and critical. For children with hearing difficulties, it is even more important. I welcome that newborn screening is considered as a red flag and has been taking place throughout in the past 6 months. However, the overall consequence of coronavirus has been that a number of people will have missed appointments during these last months and had them cancelled or not been able to access them at all. There will be people who have fallen through the cracks, and it is essential that we identify who they are so that we can remedy this. This could involve carrying out the necessary screening for children who were not born in a hospital, to have diagnostics done and have fitting and adjusting of hearing aids carried out in remote or in safe clinical settings. Effectively, what we could do is we could use the local community care setting where these procedures could be carried out. Mr Deputy Speaker, while we are here today to bring this motion to the attention of our Health Minister, as seems to be so often the case this weather, there are elements of this motion that I believe are of particular importance to other executive ministers, and I have no doubt that the Health Minister will relay these on to those ministers. In these days of remote and virtual experiences, this will be more important than ever. For instance, we are seeing steps forward through the Health and Social Care Board for video relay service that allow those with hearing difficulties to make telephone calls through British Sign Language or the Irish Sign Language to our health services. That's an important step forward. However, we know those in England and Scotland have had access to this for some time, so it is good that we are finally catching up. But at present, this service is strictly limited to health services, and it has only been in place from May, so it's good to see that developing. This is something for our Communities Minister maybe to give consideration to how those with deafness or hearing difficulties to make phone calls to the VRS for the Benefits Office. And the Education Minister could consider how they could make telephone calls to the Education Authority for their children's school. I know that's more for adults, but there are lots of different ways that we could be intervening to help. I welcome news that the Infrastructure Minister, Nicola Mallon, has approved a new dynamic PPE purchasing system which services the entire public service and includes transparent face coverings on the list, which is something that people have asked for as well. Mr Deputy Speaker, the time of coronavirus has also opened up a shift to home working, and those with hearing difficulty need to be supported as much as possible through this. That could be one of the impacts of coronavirus, which our new head of civil service, whomever and whenever they are appointed, could be taken on board when they are appointed. The most important thing, Mr Speaker, is that those in our community with deafness or hearing loss need to feel that their dignity is acknowledged and that we as legislators smooth the way as much as possible and remove every obstacle that we can to allow them to live their lives as fully as possible. This begins at childhood with early detection, early intervention and early support, and I support the motion.
I call Alan Chambers.
Thank you, Mr Deputy Speaker. I welcome this motion being brought to the House today to enable us to register our acknowledgement of the importance of early detection, intervention and support for children with hearing difficulties or deafness. As the motion points out, there can be a negative impact on a child's education presented by deafness or hearing difficulties. The various delays that the motion identify are hugely regrettable, but like many aspects of our health provision, we need look no further than the impact of COVID-19 to understand the problems this gives our health service in trying to cope with waiting lists right across the spectrum of medical conditions. There are no easy solutions nor magic wand cures for the reality of the disruption COVID is causing to many aspects of our life, especially in connection with routine and planned medical care. It is reassuring, as seen in a personal family situation recently, that newborn babies are still receiving all the tests that newborn babies normally receive, and these include audiology tests that can pick up hearing problems at a very early stage. This early detection is vital. Hearing is one of the most important faculties we have. Living in a silent world cannot be a pleasant place to be. Many of us may have seen the videos circulating on social media of young children and babies being fitted with advanced technology hearing aids that take them out of a previous silent world. The amazement and the sheer delight on the faces of these children would touch the coldest heart when their mothers speak to them for the first occasion in which they can actually hear their voice. I am confident that the Minister will support this motion and will be taking every step open to him to address the delays in appointments. It will not be an easy road for him to travel as he grapples with delays across all the medical disciplines. It must be acknowledged that he inherited a health service that was operating on the pure goodwill of everyone employed in it. Nurses were forced to stand on picket lines in the middle of winter to highlight their issues. Morale throughout the system was low, and waiting lists were at an all-time high. None of those issues could be nailed to Minister Swan's door, and he did give a pledge when he came into office to address all outstanding issues as quickly as he could. COVID-19 put paid to the fullness of those plans. If progress is to be made, it will require the cooperation of everyone in this House, and not least his executive colleagues. We must accept that it will be a case of baby steps as we go forward into a winter that may bring more major disruption to all health services. Hopefully, aspirations such as expressed in this motion can be progressed. The public have a role to play, and those in this House also have a role to play and have an obligation to provide leadership as our public health services try to reduce the transmission of the coronavirus. If a major and disruptive second wave can be avoided, it will be because of the continued and admirable adherence to guidance and advice by the public. To those who would demonstrate outside this building and speak about this pandemic as being some sort of hoax or overreaction of government, and who point to the reduction of medical interventions across the board, I would say, wise up. And I know I've stolen those words from previous speakers. Follow the guidance and help speed up the return to normal service that we all crave for, especially in the field of children's health. My party fully supports this motion, Mr. Deputy Speaker. Thank you.
Call Paula Bradshaw.
Deputy Speaker, I rise, of course, to support the motion. Children with learning difficulties are, of course, all different, but one thing which unites them is a desire to live as independent a life as possible. They want to be able to, just like everyone else, to influence the world around them and develop healthy and stable relationships. Sometimes it can be the smallest detection or intervention which enables this. This will, of course, usually mean interventions which affect the whole family, particularly when they have been born to hearing parents. Empowering parents to make informed choices, for example, on treatment or communication options, is one of these small but vital interventions which is necessary early on. Another, as we have heard, are the relatively minor implant procedures which can have such a major impact. Still another are the audio appointments referenced in the motion, which enable those informed choices to be most effectively made. This is, of course, about future educational attainment, as the motion says, but it is also about so much more than that. One area of particular concern to me is the impact the absence of some of these small detections or interventions will have on mental health, immediately and in the future. Data on this area is not good, but it is estimated that 40% of children with hearing difficulties develop mental health problems, nearly double the incidence in the general population. The main reason for this, research suggests, is communication deprivation. This is exactly why, as the motion states, audio appointments and implant procedures are so important. These delays are adding significantly to overall stress and strain, and ultimately to the prospects of falling behind peers and subsequent poor mental ill health. The four-tier spectrum of mental health provision, from early advice at primary level through specialist assessments and services, then multidisciplinary teams, and finally specialist outpatient or inpatient units, is established and vital for all children, and therefore even more so for the children with hearing difficulty. If even Tier 1 is not happening, the impact can be long-lasting. This means that child and adolescent mental health services specialised for children with hearing difficulties had never been more important before the pandemic, and the pandemic makes them even more so. The particular issue, it seems to me, is that if the early interventions do not occur and the referrals to specialist services, be they directly to do with hearing or even in areas such as counselling, therefore do not happen, the impact can be long-lasting. Again, a small intervention missed means a significant problem can develop. In broad terms, this is the concern when we hear lines like urgent procedures are being prioritised. A minor implant may not seem like an urgent procedure. An early assessment of communication may not seem like an urgent procedure. An audio appointment of outcome of which will help the family unit make empowered decisions may not seem like an urgent procedure. But any of these steps taken now may well avoid the need for urgent procedures later. They will also enhance a child's sense that they can influence the world around them and live as independently as possible, with all the positive effects that that has on their mental well-being and that of those around them. So in closing, Mr Deputy Speaker, I just would like to place on record my appreciation of the work of the audiology staff and the speech and language therapists who are trying their best in an environment of COVID, staff vacancies and these waiting lists we've discussed today. I look forward to hearing from the Minister what steps will be taken urgently to ensure that children with learning difficulties do not miss out on basic interventions and procedures which would ensure that they do not suffer from communication deprivation with the inevitable consequence on mental health and also education. Thank you.
I call Alex Easton.
Thank you, Mr Deputy Speaker. I rise to support the motion as well. Communication is fundamental to the development of every child. Learning good communication skills early in life is key to positive relationships with family and friends, for good mental health and happiness, and to educational and employment opportunities in the future. It is particularly key for those children who are deaf or have hearing impairments. Early detection, intervention and support for children with hearing difficulties has been shown to improve their mental health and avoid behavioural problems known to develop in those children who do not receive adequate help. A lack of support to communicate can also result in poor cognitive development and negatively impact upon the relationship between the child and their parent. The backlog of postponed and cancelled appointments due to COVID-19 therefore has the potential to have a knock-on effect to both the short and long term for children with hearing difficulties. That is why this issue must be urgently addressed, and I welcome the opportunity to discuss this matter today. Before the pandemic, the Health Service was already experiencing some issues with paediatric audiology services. When an assessment was carried out just last year, it became clear that some health trusts were struggling to meet the standards of access to the services, including on waiting times that they have been set. The South Eastern Trust, for example, which covers the constituency that I represent, scored just 58% towards the service accessibility target, and the report highlighted the need to improve waiting times at this point. Recent figures have shown that this situation is likely to get worse rather than better. ENT has shown one of the largest increase on its waiting list of any speciality between August of 2019 and this year. With shops, cafes and restaurants yet to open for business properly, it is time that the Health Service starts to follow suit, particularly in this case where early detection and intervention are crucial to ensure the best care plan and outcomes for these children. On cochlear implants, this early detection and intervention is especially important. Research has shown that children with implants inserted before they are 6 months old possess a vocabulary and power of better than that of their hearing peers by the age of 5. Conversely, when an implant is inserted later than this, the equivalent with their hearing peers is lost. Naturally, this can have a significant impact upon a child's first experience at school, their learning outcomes and the development of their social skills. It's therefore vital that these procedures go ahead as soon as it's safe to do so, and I would encourage the Minister to look at this issue with urgency. Most parents of deaf children have no experience with deafness. An early diagnosis allows parents to make informed choices about treatment plans. It allows parents to educate themselves on how they can best learn to communicate with their child, how they can support their child to learn the social skills that they will need when they enter school, and how they can expand their child's vocabulary. The disadvantaged deaf and hearing impaired children face in education already is obvious. Only one needs to look at the statistics. Only half of deaf children make the expected progress in maths and English at Key Stage 2, compared to over 90% of their hearing peers. Just over 1/3 of deaf children obtain 5 GCSEs, compared to nearly 70% of their hearing peers, while just over 1.5 of all 16 to 30-year-olds have a form of hearing loss. Less than 0.4 of those in higher education declare having such a condition. Evidence has shown the gap widening in recent years and not improving. Whilst all children have lost out on vital schooling due to the pandemic, Mr Deputy Speaker, it will have an even greater impact upon deaf and hearing impaired children, and my worry is that the gap will only continue to grow. There are around about 1,500 deaf children in Northern Ireland, and 90% are born to hearing parents, many of whom struggle to communicate with their child and will not be able to educate them adequately at home without support. Speech therapy, sometimes is available through school, has also been missed. Staff members and classroom assistants that help these children on a day-to-day basis at school have not been able to do so. COVID-19 has already seriously impacted the learning of these children, who are often left behind. The least we can do, Mr Deputy Speaker, is ensure that those who have access to health care that they need to help them. For deaf and hearing impaired children, the pandemic causes ongoing problems. Face masks causes issues for those that rely on lip reading and facial expressions to communicate in their schools. The restrictions due to COVID-19 have created an isolating and lonely time for many. For a child with hearing difficulties starting a new school...
Ask the member to draw his remarks to a close, please.
In conclusion, Mr Speaker, given the ongoing challenges these children are going to face in the oncoming months, it's only right that we do everything that we can, and I would call on the Minister of Health to urgently address the backlog of appointments and surgical procedures. Thank you.
Agus na siarm Sir Colm Gildany on Cancha, a call Colm Gildany.
And I just would like to welcome the tone and the interest in relation to this subject here today in the Assembly. And I would welcome any reassurance that the Minister can give the Assembly that the deaf community and wider public that any backlog in diagnostic audio testing, which is fundamental in gaining access to interventions such as sign, cochlear implants or other social or medical support, will be identified and addressed as quickly as possible. For young people, the earlier the intervention, the better the outcome, and I think that's widely recognised across education, health, community, all sorts of areas. The earlier we can get in there, the more impact and the more difference can be made. There is evidence that shows that many children with hearing impairments do less well in education than their hearing peers. This isn't inevitable. It's something that we can and we should try to do something about. And I recognise that the Minister has, in committee and in other places, flagged up his interest in dealing with health inequalities. And I also recognise that COVID-19 has certainly impacted on our ability to deal with health inequalities in a way that we maybe would have liked. But I suppose what I would be asking in relation to this is that we try to guard against people slipping further back, as Alex has mentioned earlier, and that we try to protect those who are more vulnerable at this time. The development of language and communication skills are vital to children. And during my training as a social worker, we had the benefit of a kind of a sensory impairment training. And I think I had started out from a point of view of believing that deaf and hearing difficulties were an absence of sound, but actually they can also be confused sounds, intermittent sounds, and which are very disorientating. And I think could easily, as has been mentioned previously, have an impact on mental health. So that's a concern as well. Studies show that early access to language, whether through sign or interventions that improve hearing, allows a child to develop an understanding of how language works. This means that they are hearing or reading ready when they begin school and are able to map their understanding of how language works onto the written page. If we give children, any child, the right tools and support, they will close the gap between non-hearing and hearing pupils and, as a consequence, improve their own future economic chances. Improving economic prospects lifts more people out of poverty. And it is, and we have mentioned in this Assembly before, inequality harms the individual, obviously and primarily, but also it harms our community and it also harms our economy in terms of developing that. So it's something that is useful and relevant right across the sphere. Poverty is a costly alternative to early intervention, both in terms of life changes, future health profile and the public health. And I'm aware that there has been significant research evidence in the United States and elsewhere that for every pound you invest in early years, you can, over the course of a lifetime, save potentially up to £17. So that is a really crucial area for intervention. I do note that the National Deaf Children's Society have noted their disappointment in relation to a lack of detail in the Trust's Phase 2 plans around audiology and implant services. They have identified there's a lack of detail in respect of that. This motion rightly focuses on the urgent need for early diagnosis for the young, But I'm sure, John Corley, you won't mind me mentioning that it's also important that older people get access to timely audio diagnosis as well. Just last week, we debated a motion on dementia, and the Assembly was supportive around the need to develop dementia-friendly communities. But there is growing evidence to show that late diagnosis and intervention for older people experiencing loss of hearing can be a factor in the onset of dementia. I hope and I know the Minister will keep that in mind also, so I just would like to welcome the support from all sides of the House in relation to this matter and urge everyone to support the motion.
Nice to hear him, Sir. Sinead Bradley, hon can't call Sinead Bradley.
Mr Deputy Speaker, I too wish to rise to support this motion and put my name on the record as doing so, along with my colleague Colin McGrath. The motion rightly refers to what the negative impact a delay can have on that child, and it refers to their educational attainment. But I would like to go further. Any delay on a child during those formative years really does have the power to create a downward spiral that can very, very quickly lose control. The child, in trying to keep up with their peers and those around them, can move into what is a very lonely place. They may not know or fully understand that they do have a hearing impairment, and the family and the parents around them or caregivers will be in deep distress to know that they have their child on the right track, to find the tools to equip them to deal with the deafness or the hearing loss that they may be living with. That can follow on when that confidence is knocked. That can follow on in the classroom setting or in a formal caregiving setting, as a child then starting to present with what is noted as disruptive behaviour. And it is a very, very unfortunate and unfair track to put such a young child to such a disadvantage at such an early stage in their life. I would then look at, when we look at a delay in action versus the action itself, it is not all doom and gloom. There is much to be said for the positive outcome that can come into play whenever a child is supported and identified through that early intervention and seeking help. They can empower themselves with many of the tools, and I do set apart here for mention the audiologists who support these children during difficult times and give them all the tools that they need to make their way through life. I also acknowledge that the Minister did in May introduce the VRS system within the health service, and I have to say many of us will know that the deaf community in Northern Ireland were very appreciative of that. However, it was 6 years late, and we won't go there in terms of why that was the case. But I also acknowledge and I reference comments made by my colleague Colin McGrath in terms of every minister at the table has a role to play in supporting the deaf community here in Northern Ireland. On the 27th of August, I wrote to the Minister for Communities, seeking an assurance that she would look into the VRS system that is being used elsewhere, that is VRS for all, and it does allow for those calls to be made to all the public bodies and beyond, private sector bodies, to support the deaf community, because it is a very sad reflection of our times when the deaf community are lobbying members of this House to say that they feel left out. And a large bulk of that was not to do with COVID, but I appreciate that the task put in front of the Minister is very much in catching up post-COVID on where we need to be. And I recognise that the Minister will have a great amount of pressure on him, that he will have to prioritise what piece of work comes first. But I would urge him, based on the fact that these are young children during very, very influential formative years, I would urge him to bring this to the top of his work priorities. Thank you, Mr Deputy Speaker.
Call Robbie Butler.
Mr Deputy Speaker, and I thank the author of the motion for bringing the motion today, and I, along with the party, will be supported. I also welcome the tone of the debate so far with regard to it. When I was on the Health Committee, Mr Deputy Speaker, the National Deaf Children's Society was one of those organisations who lobbied heavily and brought to the fore very much something that many of us would be ignorant to, and that is the pressures faced by the deaf and hard of hearing community with regard to access to just about everything. And I know that many members have touched on some of those difficulties, but those are the very things that we need to bear in mind when we speak of the motion, because the motion does point directly to that early diagnosis, identification, and then that much-needed support for not just the children, but perhaps crucially, the families. Because one of the things that I learned previously was that children who are diagnosed as deaf or hard of hearing, in 90% of occasions they come from a family where there are no hearing difficulties. So those families don't come equipped with the skills, the knowledge and the resources to deal with the challenges that is faced by those young people. And you'll know the Minister has made a very early commitment, even during COVID, to make mental health and well-being a significant priority of his. And when you look at the impact on those with a hearing difficulty or who are deaf, they're 4 times more likely to suffer from poor mental health, anxiety, and indeed loneliness specifically. I know Sinead Bradley will testify to this, that it is one of those societal hurts that we're facing, and it's one of those pressures, and the deaf community in particular will understand what that means. Because that isolation isn't just in terms of that family or in terms of work, but it's a societally wide felt issue. The pressures in education have been well addressed, but also there are barriers if we don't address these issues early on with regards to employment prospects. And there should be no barrier to anybody to do what they want to do if we can get the help in early enough. And we need to give these young people as much of a vision and aspiration as we can. I think it was Colin McGrath earlier on, he talked about the need for cross-departmental work. And I think on this, it's absolutely evident, and I don't think anybody will say that that's not the case. He picked out the need, for instance, within communities and the access to benefits, for instance, that there's no barrier. It is easy. He even gives some work, I think, or some credit to his own minister with regard to infrastructure and transport. But these things should not be seen as barriers. And until you speak to some of the advocates for children or for adults with hearing difficulties and deafness, sometimes it just goes, it's missed. So I just want to pay tribute to those that work in that department, whether it's in health, whether it's in the trusts, to provide that help and assistance to those in the community and voluntary sector, and to the National Deaf Children's Society for giving us some information on this today. But I think it is key to remember it's early identification, early diagnosis, early remedial action, and most importantly, early support to give these children the best chance and the best start in life. Thank you.
Thank you. I now call on the Health Minister, Robin Swan, to respond, and the Minister is up to 15 minutes. Thank you.
Thank you, Mr Deputy Speaker. First of all, can I thank the members for proposing this motion, which provides us with the valuable opportunity to consider the importance of early detection, intervention and support for children with hearing difficulties and deafness across Northern Ireland. And I echo many members' comments in regards to the tone that this debate has been brought forward and the contributions. I've listened closely to those members who have spoken in support of this motion, and I too support the motion. As Minister of Health, I understand fully the unprecedented impact that the COVID-19 pandemic has had on our health service as our collective and immediate focus. Quite reasonably centred our response on coronavirus, but as members have indicated, our tremendous health service and the people who work in it have remained steadfast in their work and ongoing efforts to maintain services where possible, while still taking steps to fight the virus. For those children with hearing difficulties and deafness, I fully acknowledge the continued need for early detection, intervention and support. And I can advise members that the newborn hearing screening programme has continued to operate right throughout the pandemic. All those babies who failed their newborn hearing screening have had their diagnostic auditory brainstem response testing completed within the 4-week target. Mr Deputy Speaker, this is a specialist test to provide a more detailed assessment of a baby's ability to hear, and the service has completed 134 such tests since the 1st of April. Within paediatric audiology, those children classed as clinically urgent are still being assessed within the 10 weeks of referral. There have been around 200 hearing tests undertaken for children classed as urgent, alongside 100 virtual assessments and reviews of children who regularly use hearing aids. Routine appointments within paediatric audiology, like many other specialities at this time, have experienced delays. However, every effort continues to be made to address this matter through the use of remote appointments or face-to-face appointments where a remote appointment is not appropriate. The COVID-19 pandemic has unfortunately resulted in some appointments being postponed due to the need to ensure the safety of patients and staff alike in these most challenging of times. The Belfast Health and Social Care Trust Paediatric Audiology Service and the Paediatric Auditory Implant Service, which is responsible for cochlear implants, have continued to deliver services to children classed as clinically urgent since the start of the COVID-19 pandemic. The services provided are delivered in line with national professional guidance and public health guidance on the safe and appropriate delivery of services during the pandemic. As has been indicated, many of these consultations have been completed virtually where possible, with safe processes put in place to maintain social distancing, including the appropriate use of PPE for any child who requires a face-to-face assessment. An extended working day and 6-day working are examples of the service being flexible and open to change to address the backlog that is developing. Those children with auditory implants are able to avail of technology, so their devices should be programmed remotely to help ensure their continuing development and hearing potential is maximised. For anyone whose child has issues or problems with their auditory implants, they are able to contact the service directly and they will be managed appropriately without delay. So if the mover of the motion has specific examples or wants to make my office or my department aware of any specific cases, I'd be more than happy to follow those up. Because I can advise members that I am informed, there are no children awaiting a fitting of a hearing aid. Any child using a hearing aid who has an issue or problem is also assessed and managed appropriately without delay. It is the case that there have been some cancellations and rebooking of patients as the service reacts to the impact of staffing levels, risk assessments and bed and clinical availability during the pandemic. This is likely to continue, but our health service will continue to deliver services to those children who require urgent assessment and treatment. The service is delivered by a small cohort of specialist audiologists and clinical scientists. Therefore, any staff absence impacts directly on the ability of the service to provide assurance in respect of an indicative time frame for managing clinical routine patients, as well as the case before the onset of the pandemic. Mr Deputy Speaker, while the Health Service is doing its level best to maintain paediatric audiology services during the pandemic, I am clear that more needs to be done in tackling waiting lists. I have already referred to the use of virtual assessments where patients can be seen in triage. These new ways of working will have to be with us going forward as we continue to deal with the COVID-19 pandemic. I am committed to reducing waiting times for these specialist services and providing the virtual early intervention to ensure that children with hearing difficulties can benefit from the excellent support our health professionals can provide. Services will require non-recurrent investment to bring waiting lists back to an acceptable level. This, however, will be in the medium term rather than the short term, as the main difficulties are due to staffing and the capacity of facilities during the pandemic, which is not expected to change over the next 6 months. Mr Speaker, Deputy Speaker will also be aware that my department, the Health and Social Care Board and the National Deaf Children's Society have worked collaboratively to draft quality standards for paediatric audiology services for Northern Ireland, and we expect these to be adopted and published later this year. The Regional Audiology Forum, acting as the steering group and working with stakeholders and user representatives, has now completed this work and produced the draft paediatric audiology quality standards. The standards currently are going through the final approval process. These standards will enable the quality of the service to be evaluated and benchmarked to identify target areas for service improvement focus. This will be particularly welcome in these very challenging times. Mr Deputy Speaker, in supporting this motion, I thank all members who have made contributions. It remains vital that we address the needs of those children with hearing difficulties and deafness in a timely way. And I would like to thank all of the professionals working in our paediatric audiology service, paediatric auditory implant service and our health and social care trusts who continue to work tirelessly in these unprecedented times.
Agus na siarm Sir Pat Sheehan on conclude a correlation G-Spracht, and I call Pat Sheehan to conclude on the debate.
Gurma, I've got a last count, Corla. Could you confirm if I have 5 or 10 minutes? 10 minutes. Gurma, good. Agus tá hasarm bheith glórt an sa G-Spracht seo aniu agus bhhailm mhuigas a ggóil a handana a bheith glórt an seo aniu. I welcome the opportunity to speak in this debate today, and I thank everyone who contributed. I'd like especially to thank the Minister for his response and for coming along here today to listen to the debate. And I want to welcome his acknowledgement that more needs to be done to tackle the waiting list, and particularly in these specialist areas. As has been noted, there's agreement and consensus right across this chamber today in relation to this debate and the issue involved. And unfortunately, that won't get a lot of column inches tomorrow, and there won't be any sensationalist radio shows on, congratulating us on agreement in the chamber. But that's life, I suppose, and we just have to deal with this. And I suppose I was on a Zoom meeting this morning, and I suppose most of us experienced difficulties in this building with the Wi-Fi. I was using my laptop, and the signal kept dropping in and out, and you're picking up bits, and there's background noise and everything. And it was sort of half preparing for this debate, and I was thinking, that's the experience of people with hearing difficulties. They don't hear everything. Background noise interferes, and they experience those difficulties on a daily basis. And I was away a few years ago with a crowd of lads. We're away a weekend at a match or something, and as usual on those occasions, there was a bit too much alcohol consumed, and the company was loud and a bit raucous at times. And I noticed one of the lads, who's usually the life and soul of the party, was sitting in the background. And he seemed down in the mouth for some reason. And I went to speak to him, and he explained to me that he had been having hearing difficulties and was waiting on a new hearing aid. But with all the noise, he couldn't engage, he couldn't communicate, he couldn't hear what was going on. And I just thought, for a lad who's always so happy-go-lucky, he was so demoralised. And imagine that situation for people who have hearing loss and don't get treated. And Colin made the point earlier about making sure that people with hearing difficulties are treated with dignity. And the way to do that is to ensure that there is early intervention. And practically everyone involved in this debate talked about early intervention, because the earlier you intervene, the better the outcomes. And of course, we in the overall scheme of things, some people may not think this debate very important. When we're in here debating big-ticket issues like Brexit and global pandemics and so on, this may seem, very small beer in comparison. But we have to think of the implications of this, and it has already been mentioned about educational underattainment among young people with hearing difficulties. And what's the upshot of that? And I mean, I know, and any of you who have ever been involved in the Education Committee will know, that when children fall behind in school for whatever reason, it's often very difficult for them to catch up again. And what happens then? They continue to fall behind. they end up leaving school with no educational qualifications. What's the upshot of that? People end up more likely to become involved in the criminal justice system, more likely to have chronic ill health, more likely to suffer from mental ill health. And that was one of the points that Robbie made about the isolation and loneliness. And I think of my friend and a crowd of 10 or 15 other fellas, you know, sitting outside the company, not able to participate, not able to communicate, that sense of isolation and loneliness. And in a sense, that's like a microcosm of this whole issue of hearing difficulty and deafness that we have to deal with. So the ramifications of hearing difficulties and deafness are much more profound than just a few kids. You know, tough luck, they couldn't get it, they couldn't get their hearing test, they couldn't get their implant. It's much more profound like that. And I think when we're dealing with issues like this, all of us should be thinking about not somebody else's kids, but our own kids. How would we feel if our own children had hearing difficulties and couldn't get the early intervention and treatment that they need, deserve, and are entitled to? And I take on board the point that Alan made. The Minister came into his job with all the good intentions of the world, and COVID-19 has put paid to a lot of those issues. And I don't want to raise a discordant note, and I know the Minister mentioned it when he was speaking, that the reason why a lot of these consultations and treatments can't take place is to ensure safety of patients and staff and so on. But for the ordinary layperson, will wonder why a particular service such as this, which is carried out by audiologists who are technicians essentially, and that's my understanding. If I'm wrong, I stand corrected on that. There's no aerosol generating procedures involved as far as I'm aware. I mean, I'm old enough to remember back when I was at primary school, we used to get hearing tests on a regular basis. You put on a set of headphones and a noise came through and you tapped the table with a pencil. Apparently now it's advanced. You press a button instead of tapping the table. But, you know, I make light-hearted comment about that, but the serious point is ordinary people don't understand why some of these tests have been cancelled, because it's not as if the audiologists are being dragged into the front line to deal with COVID. And I'm sorry I didn't get the chance to ask the Minister that before he spoke, but it's a question I'm putting out there. So, I know I haven't mentioned a lot of people. Everybody who spoke, I think, mentioned the underachievement in education and mentioned the issues about mental ill health. I think it was Colm who mentioned the fact that last week was Dementia Week, and also in older people there is a suggestion that dementia or loss of hearing is a factor in dementia as well. So all of these issues make this a much more serious issue than it would appear on the face of it. So again, I want to thank everybody for contributing to this debate and thank the Minister for coming along.
The question is that the motion standing on the order paper be agreed. All those in favour say aye. Contrary, no. The ayes have it and the motion is passed. Thank you. And if members just take their ease now while the Speaker resumes his place here.
Okay, members, the next item on the order paper is a motion. Point of order, Ms Long.
Thank you, Mr Speaker. I wanted to take this opportunity to correct the record in relation to the discussion that we had this morning. It has come to my attention that in response to a question from Jim Allister earlier this afternoon, I inadvertently referred to the Public Prosecution Service raising a question in 2012 on the removal of Section 52 from Schedule 2 of the Magistrates Court Northern Ireland Order 1981. I should have said it was Northern Ireland Court Service in September 2011 and that the Departmental Solicitor responded in March 2012. The PPS was not involved in that correspondence, and I want to apologise to members and to Mr Allister and the PPS for the error.
Can I thank the Minister for that very speedy correction of the record from earlier on. That served the courtesies of the House. Thank you very much, Minister. And we're now moving on. As I say, the next item on the order paper is a motion on the introduction of legislation equivalent to Helen's Law. I will ask the Clerk to read the motion. Please read the motion.
That this Assembly recognises the ongoing pain and trauma experienced by families in Northern Ireland whose loved ones have been murdered and who continue to have no knowledge of the whereabouts of their remains, welcomes the progression in the UK Houses of Parliament of the Prisoners' Disclosure of Information about Victims Bill, otherwise known as Helen's Law, placing a statutory obligation on the Parole Board to take into account an offender's non-disclosure of such information when making a decision about their release from prison, notes that these obligations apply to prisoners serving a sentence for murder or manslaughter, or for taking or making an indecent photograph of a child, and calls on the Minister of Justice to introduce urgently equivalent legislation in Northern Ireland to ensure that prisoners convicted of murder and child sex offences are not eligible for release until they disclose the location of their victims' remains or the identity of their victims.
Thank you. And I call Alex Eason to move the motion.
Moved.
Thank you. And the Business Committee has agreed to allow up to 1.5 hours for this debate. The proposer of the motion will have 10 minutes to propose and 10 minutes to wind. One amendment has been selected and is published on the Marshall list. Please open the debate on the motion.
Mr Speaker, this is a very important motion before this Assembly today. It is both important but vital for families who have had a family member or a loved one murdered but have never had a body returned to the family to have a Christian burial. It is why I state from the start of this debate that this motion was not put down and it is not political in nature. There are no hidden agendas and there must be no politics in this debate because of the families. I ask this Assembly to back this motion wholeheartedly as we seek to support those families and send a message out to those who have killed someone and refuse to give up the body. You will stay in jail. What is Helen's Law or Charlotte's Law? It is killers who have concealed victims' remains, who have been sentenced for the crime of murder and do their time, but then face parole refusal. Murderers who refuse to reveal the location of their victims' bodies could be denied parole under a new law. Helen's Law follows a campaign named after Helen McCourt, who was murdered in 1988. Her killer, Ian Sims, has not revealed the location of her remains. Miss McCourt, aged 22, disappeared in 1988 on her way home from work. Sims was convicted of murder but never revealed the location of her remains, so he can continue to have a hold over the family. He was jailed for life in 1989 and told he would have to serve at least 16 years before he would be considered for parole. Nearly 600,000 people signed a petition launched in 2015 calling for the introduction of Helen's Law to block parole for killers who concealed the whereabouts of their victims' bodies. Mrs McCourt, who is still involved in searches for her daughter, said, "It has been a terrible stress on me since I started the petition in 2015. This law will help so many other families." I wrote to him, begging him, "Please, please, just tell me, and you will not hear from me again." I still hope he will remain in prison until he tells me. I hope one day I will know. Unfortunately, it has come too late for the family, as the process through Westminster for this law has not passed all hurdles, and Sims is now out on licence. Here in Northern Ireland, we have a separate justice system, and much of what we ask for and support today will require our Justice Minister to support and introduce. I hope you will not be found wanting, as my hopes and the hopes of the victims' families rest on your shoulders today. In Northern Ireland, we have our own examples of Helen McCourt. We have the Murray family. Johnny Miller was found guilty of murdering Charlotte Murray, his former fiancée. He must serve a minimum of 16 years of his life sentence. Charlotte's body was never found. Miss Murray's family said Miller had put a cruel suffering upon their family by not revealing where her body is. I have met the Murray family with the First Minister, and the family have called on all local politicians to bring in a law to prevent killers who conceal their victim's body from receiving parole, and it is currently working its way through Westminster. Charlotte's identical twin sister Denise said, "John Miller murdered our sister and he knows what he has done. We ask of him to tell us where Charlotte's body is and let us bring Charlotte home. We want to say our goodbyes in peace." Another family in Northern Ireland is Lisa Dorian's family. Lisa Dorian, a 25-year-old shop assistant from Bangor, went missing in 2005 in my own constituency. Murdered and secretly buried, her remains have never been recovered. The 25-year-old was at a party in Ballyhalbert Caravan Park, which was deserted because it was off-season. Mark Levette, the last man to see her alive, was also there drinking and taking drugs. Detectives believe that Lisa was strangled in the Ballyhalbert Caravan and her body was secretly buried. The family of missing murder victim Lisa has come out to support of a proposed law that would keep convicted killers behind bars until they reveal the location of the victim's body. We are sending a direct message, they say, to the man who hid Lisa's body. We just want to find her. We have asked you, begged you through the media for 15 years to tell us where you have hidden her body. When we get a guilty verdict from the jury, we'll make sure this law is in place that you are never released from prison until you tell us where Lisa is. The determination and dignity of local families of those who have been murdered and whose remains are unknown is what is driving this debate. And we in this chamber must give them real hope that their genuine concerns will be met, not just through our words, but through actions in this assembly. This debate is ultimately about how we support the victims of serious crime and value their grief and trauma. The Minister should not lose sight of what is at stake here. This isn't a time for deflection or sidestepping. Non-disclosure of victims' information should always be taken into consideration. It is vital that any decision to release a prisoner serving time for these serious offences takes statutory consideration of a failure to disclose their victim's whereabouts or identity. The Minister is correct that these matters are routinely considered, but if that is the case, why should we hesitate to put this into law? A routine statutory consideration alone cannot change our outcomes and decisions. There also needs to be binding obligations on parole commissioners to give non-disclosure and the added trauma to victims' families greater weighting when assessing risk to the public. Someone who fails to disclose this information is a greater risk to the public than somebody who has done so. But this... Yes, go ahead.
For giving way. Would the member agree with me that not only is it a hideous crime to prevent the families to lay to rest their loved one, but the fact that they're denied the knowledge of the final hours of the life of their loved one, and that in itself should be disclosure enough to put at least at rest that aspect of the heinous crime of murder?
I thank the member for his intervention, and those who are involved in murder and can't give up the body after being sentenced shows to me that they are not genuinely sorry for their actions, and it's important that these disclosures do take place. It seems victims' health and well-being are not prioritised compared to the risk to the wider community. That is wrong. Helen's law may act as a driver for offenders to cooperate and disclose information early. We believe that it's an opportunity for offenders to provide accurate information on the location of their victims' remains or the identity of their child victims earlier, if decisions on parole are seen to differ based on disclosure versus non-disclosure. The problem we have is that such a distinction is not readily made in current decisions. It's vital that offenders have an understanding that non-disclosure at each stage of the criminal justice procedure will lead to stricter penalties than if they did. There needs to be an overhaul of the current process in place to ensure a victim-centred approach at every stage. However, the delay in processing the sentencing review continues to be of deep concern to victims and indeed many workings in our courts. We can't kick the can down the road any longer. Parole decisions are more sensitive than sentencing because if officials get it wrong, the release of the uncooperative perpetrator can cause new and ongoing trauma to a victim's family. We welcome the focus of Helen's law on serious sexual offences where the victim is not identified. The number of record sexual offences against children in Northern Ireland have reached an all-time high, according to statistics procured in 2019. 2,036 sexual offences against children were recorded in that 12-month period, a significant rise of 34%. That's just unacceptable. Finally, in regards to the Alliance Party amendment, I have to say I am frustrated and disappointed by this amendment, and it is clear that the victims of the families were not listened to, and I would appeal for the Alliance Party to withdraw that amendment. The Alliance amendment to the motion to state that this issue is already routinely considered by the Parole Commissioner for Northern Ireland when assessing prisoner suitability for release and licence. But if that is the case, why should we hesitate to put this into law? But this is not in every case, so why has Sims been allowed out on licence? The amendment deflects focus on the current limited Department of Justice consultation with stakeholders and sentencing review and are less committed to bringing forward dedicated legislation. The Minister of Justice has already commissioned a focused consultation with key stakeholders on Helen's law. A consultation makes no guarantees or commits the Minister to bring this into law. The amendment uses words such as including legislation where appropriate. Where appropriate, what type of language is that to be used in the case of murder? And loved ones having no body returned to them. There's nothing more appropriate than this Assembly listening to the victim's family and making this law. In conclusion, Mr. Speaker, I urge this Assembly to reject the amendment, and I urge this Assembly to support the motion today, and also urge this Assembly to show that this Assembly is serious about being tough on crime. Thank you, Mr. Speaker.
Thank you, and I call Kelly Armstrong to move the amendment.
So moved.
Thank you, and you will have 10 minutes to propose and 5 minutes to wind. All other speakers will have 5 minutes. Please open the debate on the amendment.
Thank you, Mr. Speaker. Before I speak on the amendment today, I'd like to start off by acknowledging the pain and trauma felt by the families of Charlotte Murray and Lisa Dorian, and all families who are still waiting for their loved one to be returned to them. To deny a family the opportunity to say goodbye is cruel. I say directly to all those families, I will not pretend to understand your ongoing pain. All I can say is, I'm sorry. I wish to thank both Mr. Easton and Mr. Given for bringing forward the motion before us today. There is much I can agree with in the original motion. I welcome, and the Alliance Party welcomes, the progress of the Prisoners' Disclosure of Information about Victims Bill in the UK Houses of Parliament. That law, known as Helen's Law, is vitally important. However, the amendment here, the motion today put forward in front of us goes far beyond what the bill in Westminster actually includes. By preventing a prisoner from being eligible for release because they have not disclosed the location of their victim's remains, that could mean that there are those who are genuinely innocent who will be in effect imprisoned in perpetuity. It also doesn't allow for those prisoners who may genuinely cooperate but who are unable to locate the remains because of due to passage of time, loss of memory, or difficulties finding distinguishing features and landmarks in the area. You would also potentially find those people trapped in prison forever. And whilst we may believe a long prison sentence is commensurate with their brutal and cruel crimes, this wouldn't reflect their sentence as handed down by the judge and would almost certainly be open to challenge on human rights grounds. I believe we can improve on the content and intent of Helen's Law. I know the Minister for Justice is already committed not to equivalent legislation for Northern Ireland, but more than that. My amendment confirms that there is a consultation underway. There is a sentencing review. The legislation will be brought forward where appropriate. The amendment I put forward today acknowledges the Parole Commission already takes matters into consideration when considering release. However, I don't think anyone in this House wants the Parole Commissioner to just take into account or consider an offender's non-disclosure of remains or identification of a victim from illegal images. Surely we should be seeking to have a weighting added to that consideration. Would it not be better to take into account when a prisoner has made no attempt and given no explanation for that lack of cooperation when weighing up the risk they pose to the public on release? While some in Westminster certainly did call for no disclosure means no release, this has not been included in Helen's Law. If we bring Helen's Law into Northern Ireland, it will not include that clause. It only states the Parole Board take into account non-disclosure. The resistance for doing so was to allow the Parole Board there to continue to be able to take its own decisions. To deny parole, even on those grounds, would mean a fundamental change to the basis on which the Parole Commission make release decisions, and indeed would potentially impact on the framework for public protection sentences. I think we all agree the Parole Commission should be able to take and make decisions based on its independent consideration. Politicians should not be able to interfere in sentencing. As outlined in my amendment, the Minister and the Department of Justice has already commissioned a focused consultation with key stakeholders on Helen's Law to run in parallel with finalising the outcome and the next steps flowing from the sentencing review, including legislation where appropriate. Indeed, I will ask the Minister today, in her response later, to confirm if there is an opportunity to enable the Parole Commission to do more than it does today, which is to consider an offender's non-disclosure when making their decision about release. And can she confirm if we can add a weighting to their decision? No one in this room wants families to wait any longer for their loved ones to be returned to them. I don't believe any of us in this chamber want non-disclosure to simply be taken into account. This is why the amendment goes further than the original motion and asks the Minister to take forward her consultation, her sentencing review and legislation, not just to replicate Helen's Law. As I said earlier, I do thank the members of the DUP for bringing forward this motion. It is a private member's motion, and this discussion today, no matter what happens, will not bind the Minister for Justice or indeed any minister to have to take action. I would suggest that if we are going to take this forward, that we need to have meetings with the Minister, and perhaps the Justice Committee could take it under their remit as part of their work. Perhaps then, by working together, we can have an outcome that enables the Parole Commission to continue to do its work and families to contribute to the outcome. I have proposed an amendment that reflects the ongoing work of the Department of Justice. I'll say again, they have a consultation, there is a sentencing review, and it seeks for legislation to be taken forward where appropriate, because I believe Helen's Law will not deliver what families want. Families do not need any further pain or distress. Helen's Law will not keep offenders in prison for non-disclosure. I ask all if you would consider voting for this amendment.
And I call Linda Dillon.
Elgit, Can Corlia, and I just want to begin by saying I don't think there'll be very much between what any of us say in this chamber here today, regardless of whether we're supporting the amendment or not, because we all support the spirit of the motion, and I think that's fair to say. And there's probably very little in the motion that we couldn't support, but there is a little bit that we couldn't support, and we will be supporting the amendment. However, we won't be pushing this to a vote. So just to make members aware, that is our position. I want to begin my contribution today, obviously, by thanking the families of both Charlotte Murray and Lisa Dorian for coming up and meeting with ourselves, myself and my party colleagues, and I'm sure met with many other parties as well here in this chamber, and our deepest thoughts and sympathies are with those families and the many others like them who don't know the whereabouts of their loved ones' remains. We can't even begin to imagine the compounded pain of not having the remains to lay at a place to rest and to have somewhere to go and visit them, and everyone should have that right. And I would call on anyone with any information that can give any family any peace of mind to please bring forward that information in terms of allowing them to establish the whereabouts of the remains of their loved ones. The motion that's before us today, whilst it's asking for the equivalent legislation to Helen's Law, appears to go further than Helen's Law, and in doing so potentially strain into the realms of indeterminate sentences. which contravenes human rights laws. And Kelly Armstrong has already outlined the issues around that, so I don't intend to repeat it. I fully support the spirit of the motion, and as I've already said, there are only a few words within the motion that we can't support. I've spoken at length with the families over the weekend, as I also accept that the amendment does not go far enough and gives no firm commitment on next steps that will address the issue and meet the needs of the families. I believe that the amendment may allow the Department to put this on the long finger, when what we actually need is the beginning of a process to produce effective and robust legislation that will deliver for the victims of these crimes and their loved ones. The debate in this chamber today is only the beginning of the process, regardless of what the outcome is. The motion is non-binding, as has already been alluded to. And if we as members in this House don't pursue the Minister and the Department to deliver on this issue and insist that she begin to scope out what legislation would look like, then all we're doing is making politics and raising the expectation of families that are campaigning and who are the voices of their loved ones. And that's just not acceptable for any of us. As I've said, I've met with the families and spoken to them at great length over the weekend, and they are determined, articulate and intelligent people who are fighting a very dignified campaign, and they will not have the wool pulled over their eyes, either by members or by the Minister. So we owe it to them to work together to deliver legislation to deal with this. This issue cannot simply be lumped in with the sentencing review, as there are elements to this that are not addressed by the sentencing review, particularly around the continued offending in relation to child sex offences. I would call on the Minister to commit to carrying out a bespoke piece of work outside of the sentencing review as a matter of urgency. I am aware that it is the intention of the Minister to meet with the families, and I believe that it would be imperative that the Minister progress this in a positive and proactive manner. Charlotte Murray's killer was sentenced to a minimum of 16 years, and if the Minister and the Justice Department do not bring forward legislation to address this, what is outlined in this motion, the reality is that although the Parole Board will consider the non-disclosure of her remains, there is nothing in statute to send a signal both to the perpetrator of this horrific killing and to the Parole Board to give it significant weight. We will be supporting the amendment and we will not be opposing the motion.
Thank you. I call Sinead Bradley.
Thank you, Mr. Speaker. As the SDLP spokesperson on justice, I rise in support of this motion. The motion very appropriately opens with reference to the trauma experienced by families and loved ones who have been murdered and no knowledge of the whereabouts of their remains. At this point, I want to acknowledge the ongoing pain being experienced by the families of Lisa Dorian and Charlotte Murray, alongside the families of the disappeared, but in particular all those families who continue to live with the unimaginable pain of not being able to lay the remains of their loved one to rest. Non-disclosure of the identity of children who have been used to take or make indecent images also provides an insight to the level of remorse a prisoner feels when they make no effort to help those who simply want to safeguard that child. Our legal system requires a method of marking out those prisoners who choose to continue with the dehumanisation of their victim and who choose to inflict pain on loved ones by not disclosing critical information about the victims. Helen's law does just that. It is a carefully crafted piece of legislation that includes a level of subjectivity, allowing the Parole Board to make a determination on when a prisoner is making a deliberate decision not to disclose information. The explanatory notice provided ahead of the legislative change to law acknowledged that it was the Parole Board practice to consider non-disclosure or relevant information on living victims. The Prisoner's Disclosure of Information about Victims Bill established that practice into statute. Prisoners in England and Wales are now clearly aware that continued non-disclosure must, by statute, be considered during any deliberations for parole. prisoners who may never act out of anything other than self-interest will be forced to contemplate the consequences of continuing with their decision to withhold information. The SDLP has no hesitation in supporting this motion, even if it does suggest contemplating the legislative process to go further than Helen's Law. And I would even add to that, we could consider the possibility of reflecting any delay in the prisoner's chosen time of disclosure to be reflected in the timing of their parole. The right thing to do here is to push ahead and legislate with these deliberations. To those who have expressed a concern that the removal of eligibility for people may not be human rights compliant, I remind them of 2 points. Firstly, the parole board would be charged with making the determination as to whether this is a deliberate decision not to disclose. The subjectivity rests firmly with them. Secondly, those murderers or paedophiles who deliberately choose to continue to perpetrate the crime through non-disclosure, at all times, it is them, nobody else, who holds the power to make themselves eligible for parole. Helen's Law, or Charlotte's Law, as it is lobbied here in Northern Ireland, is the tool that forces the hands of those into doing the right thing. Victims and their loved ones depend on our support to make this happen. The SDLP welcomes the fact that the Minister has already commissioned a focused consultation with key stakeholders on Helen's Law. The level of deliberations and considerations that formed the legislation in Westminster will inevitably assist in injecting speed into any Northern Ireland deliberations. For this reason, the SDLP believe it would be wrong to subject this mature legislative piece to sit alongside the timeline of a much wider sentencing review. The urgent need to deliver on this legislation cannot be emphasised enough. It is a relatively short bill with a huge impact. For this reason, we cannot support the amendment. In supporting the motion, we send a clear message to all those commissioned to sit on a parole board that the direction of this House is to legislate on this matter, and the weight of non-disclosure during their deliberation should be used with absolute confidence. The SDLP today will support victims via this motion. Thank you, Mr. Speaker.
And I call Doug Beattie.
Thank you, Mr. Speaker. And first of all, can I thank Mr. Easton for bringing this before the Assembly. I know you have put a lot of time into this and into supporting the family. I met with the family of Charlotte Murray and Lisa Dorian for the first time last week. I sat in front of the twin sister of Charlotte Murray and I saw in their faces the absolute devastation that they are going through day after day, not knowing where their sister is. Mr. Dorian, the father of Lisa, sat with the family in support, knowing he hasn't even reached the first step to getting any form of closure and justice. But he sat there and he gave support, all out of hope. And hope is a word that I'm going to use a lot, because they sat with hope that we as an Assembly, as legislators, could do something to address this great injustice. Hope. They gripped onto hope that we would do something. Their concern is that any murderer who refuses to divulge the whereabouts of the victim can receive parole and be walking our streets still knowing where that victim's body is and not being held to account. Of course, the Parole Board and the Parole Commission for Northern Ireland can, when the parole comes before them, say that not divulging the whereabouts of the victim is a reason for parole to be denied, an aggravating factor. Of course they can. Of course they can. But there's no guarantee, because that was not the guarantee for Helen McCourt. Because after delay after delay after delay, the murder of her was allowed out. and is walking the streets now. Not only that, but the mother of Helen had to pay him £40,000 because she took a legal case to try and keep him in prison. I think it is absolutely disgraceful. It is shocking. We do not want to be down that road. And it didn't work for Vanessa George, released after 10 years, having abused children and took pictures and then refused to divulge who the children were that she abused, who in later life may well recall what went on. But she's out walking the streets knowing who those children are. The purpose of sentencing is punishment, protection of the public, deterrence, rehabilitation and reparations. Sometimes we forget about deterrence. And I've said it time and time again. What is wrong with an all-life sentence? It's in the sentencing review. It can be considered. We can't do it. And this is one of those reasons where I think we should. Because here is the reality for the family of Charlotte Murray. They will suffer a living death every single day now for the next 16 years. And they will not know until the murderer of Charlotte goes before the parole board whether or not he will get parole. They won't know. So they have to suffer that for 16 years. And if he's denied parole, then they have to wait for another 2 years suffering before he's up again to see if he gets parole. It's inhumane. Absolutely inhumane. We should be absolutely clear and telling him, if you do not divulge where the body of your victim is, you will not be getting parole. I said this before, that the family live in hope. And we all know the limitations of any legislation. Of course we do. But let's not snuff out the hope that the family have, because it's all they have and other people have. Of course, I will be supporting this motion. I cannot support the amendment because the amendment snuffs out hope and there's no requirement for it. A previous Justice Minister only this morning, Claire Sugden, asked a simple question this morning: why can we not approve a legislative consent motion to adopt the legislation that is bound for England and Wales? Why not? Why not show purpose? Why not show strong justice? Why not put something in place? And if it means a whole life sentence, then do you know what? It has to be a whole life sentence. It's not happened very often, but it can happen. And I believe everybody in this assembly, when they think about it, think it's right that if you kill somebody and bury their body and do not divulge it, you should not be allowed out of prison. Thank you, Mr. Speaker.
Thank you, and I call Paul Frew.
Speaker, and can I first of all commend my colleague Alex Easton for his opening remarks, and also the spirit of which this debate has continued, with some very, very powerful speakers coming forward to voice their opinion. And I value that. I really do value the parliamentary spirit of which this debate is taking place. And it's at times like this where you feel proud to be an MLA, because I believe that most of us, if not all of us, are wanting exactly the same thing. We may well have a different route of travel, but we all want exactly the same thing. Having said that, I think it was Lord Castlereagh who made the saying that he despised the parade of parliamentary spirit which leads to nothing. So it is on all of us to make sure that something happens here after this debate. So we can all argue and debate around the motion or the amendment, but I think we need to make sure that we come together and send a message out there to those victims and loved ones that we're with you, we hear you, and we want to try and make a difference to your life, because that would be a very powerful message to send to those loved ones. But when someone commits the heinous crime of murder or unlawful killing, or is involved in sexual violence and abuse towards young people, it is a heinous crime, and in the act of murder, it may well be just a one-off action that commits murder, that brings misery onto loved ones forever and a day of their life. But there is a certain power with a perpetrator who commits murder. It's a power that they may well have inside them, that they may well, in some hideous way, enjoy. And if they do, the actual power over information becomes much more sinister and much more powerful. And I think it was Sinead Bradley who said earlier on that it is a prisoner's non-disclosure is a deliberate decision. It is a deliberate act. And that act heaps more power onto the perpetrator. But not only that, it impacts on the family every second of their lives. It rocks them to their core for every second of their lives. And some of these people are elderly, and they have to live with this and face this every waking second of their lives. How could any of us ever manage to even fathom what that means for loved ones facing this cruelty? For these loved ones, it is a sentence that they will never, ever overcome. They will never, ever get over. Yet the perpetrator will sit in there and decide a deliberate action not to disclose. And what would that disclosure bring? It won't bring their loved ones back, absolutely not. But it will allow the family to lay to rest the remains of their loved ones. But not only that, as I've already alluded to earlier, it may well help to piece together the final hours and minutes of their loved ones. Horrendous as that may seem, they will be able to piece together that story and maybe even some of the experiences of their loved one as they went through their final hours. Now, that's a horrendous thought and story, but that would bring so much closure to the loved ones of the murdered. And I can't for the life of me understand why it isn't a natural place to place on a duty onto the parole board to take this into statute, to take this into place. It isn't good enough to place this in a sentencing review. It's much more than that. It has to be much more than that. It is the essence of power that a perpetrator wields on a family, not just their murdered victim, but their murdered victim's family. We cannot abide by that. This House should not abide by that. This House can do something about it. This Minister of Justice can do something about it. And
Members,
I beg
time's up.
and I plead that that would be the case.
Members, time's up.
And that we would move on and produce something here for the loved ones here today. Thank you.
And I call Gemma Dolan.
Firstly, I want to send my condolences to the families of Charlotte Murray and Lisa Dorian, whose courage and persistence has seen this issue being brought here today. I am totally sympathetic to the need for additional protections to safeguard the rights of victims and their families, and I fully support the families in their search for truth and justice. Whilst taking another person's life is one of the most serious and horrific crimes, I consider one wilfully holding back information regarding the whereabouts of their victims' remains as another offence and a continued offence, and therefore there is a serious need for additional protections to prevent such an offence continuing. When we're dealing with the issue of child sex offences, there are a number of additional concerns which warrant immediate attention. In relation to indecent photographs of children, unless the identity of that child or children is known to the authorities, then there is a real risk that this child may still be suffering abuse at the hands of child sex offenders, and everything in our power must be done to avoid this abuse happening. Further still, for as long as the photograph is in existence and the identity of the child is unknown, then this is continued abuse, which may continue to have a serious and long-lasting impact on the child, including further in their later life. All must be done to track down the victims of these crimes, to ensure that appropriate support can be provided to them, but also to ensure that this abuse is not continuing. Innocent families who are suffering immensely already should not have their grief compounded as a result of offenders continuing to torture them by not disclosing information on their victims. We need to find a legislation which has the result of both compelling offenders to disclose information about their victims, but one which also has a dual functionality of being a proper, effective deterrent to prevent offences like this being carried out in the future. All victims are entitled to truth and closure. We are determined to find legislation which makes it much harder for offenders to be released if they have not disclosed information about their victims, and we are determined to find legislation which is effective and robust. Our test in setting out what would be an acceptable piece of legislation will be threefold: that it effectively compels offenders to disclose information around the whereabouts and identities of their victims, that it acts as an effective deterrent to any future offenders carrying out such heinous and horrific crimes, that it is robust, human rights compliant legislation which will not be open to legal challenge in the future. Legislation which effectively considers and mitigates against any potential unintended consequences. I don't believe that the original motion does this. However, I do commit to working with the Justice Minister to move this work forward urgently. I would like to see the consultation committed to in the amendment carried out urgently, and we would like to see the outcome of this consultation before committing to a way forward. Any legislation must satisfy the key tests that I have just outlined if it is to be effective and suitable. Thank you.
Okay, members, before I bring the next speaker, as the business on the order paper is not expected to be disposed of by 6 p.m, in accordance with Standing Order 10.3, I will allow business to continue until 7 p.m. or until the business is completed. And I call Dolores Kelly.
Thank you, Mr Speaker, and I welcome the opportunity to speak in this debate and was grateful to the family of Charlotte Murray and Elisa Dorian taking time to speak with myself and my party colleagues. I think their physical pain is clearly seen. I can't even begin to imagine the emotional and psychological torment that they're experiencing. And I also think this evening of the family of Arlene Arkinson, who also signed, I understand, the petition and supports this bill. Her killer went to his grave keeping that secret. And, you know, the act of disappearing a victim's remains is such a heinous crime, I think, that is still deemed to be a war crime under the Geneva Convention. And some speakers, Mr Speaker, have already alluded to the coercive control nature, particularly in relation to the murder of Charlotte Murray. And this is a continuation of that coercive control and power. And we're all being better educated, I think, thanks to the work around domestic abuse and violence, of getting a better understanding of the other forms other than physical assault that many victims of domestic abuse have to suffer. We're pleased to be able to support the motion. I believe it is the right thing to do. I think it gives the right message, particularly to those who have been convicted. But in speaking to the two families, it was very clear, particularly from Mr Dorian, if he had to, and this is a common that I found in many interactions I've had with many victims' families, if they had to choose between truth and justice, they want to go for the truth in terms of getting the victims' remains returned, and that says a lot. So whilst the family of Charlotte Murray has got some level of justice, they still have not, very clearly not, got closure. And in her contribution in relation to the amendment, Kelly Armstrong said about how landscape changes and how difficult it would be, and about the indeterminate nature. Others have said about not being human rights compliant in relation to any sentence if that were to be a condition of parole. So, you know, the earlier the perpetrator speaks up before there are those landscape changes, you know, the sooner then that not only could the victims' families remains be returned to the families, but also the sooner that person will have done the right thing and then can go to a parole hearing having done the right thing in relation to that. And on the second part of the motion, and I don't want to forget about the child pornography and child identity, we are hearing, any of us who are members of the policing board, hear on a constant basis about the dark web and how it is being used, not only in relation to sharing information about domestic violence, but also about child pornography. And the police are always, unfortunately, a step ahead, although recently they have had some successes alongside their colleagues in the NCA and internationally. But such is the increase in child pornography online in particular. I think it's something like over 60% increase, and there are more and more children going on to the register across my own trust area, Child Protection Register, in relation to a number of concerns. So I think it is right and proper that we try to get help to those who need it, to those children who are at risk, and that the onus is on the offender. The sooner that people get the message that their outcomes in relation to their sentencing will depend upon their cooperation with the investigators, the better. And I think that's a message that we need to give out, not only to support those families who are tormented on a day and daily basis, but those... I will, yes.
This is a very important point. It's not, I think it was Sinead who said it earlier, that it's not only the disclosure, it's the timing of the disclosure. With regards to when they disclose to the families. And that's a very important point that should be taken into consideration too, because the perpetrator might just disclose to get a more lenient sentence in that regard.
But Member has an extra minute.
Thank you for that intervention. And in fact, that was a point that was made very forcibly by the two families, that they would be very concerned that on the first parole that the perpetrator then gives up the remains. And I think that that should be a graduated consideration by the parole commissioners in relation to any parole hearing. So I think there has to be a strong message from the Chamber here this evening.
Thank you. And I call Alan Chambers.
Thank you, Mr. Speaker. To lose a loved one to the heinous crime of murder is a huge burden for any family to bear. To not know the location of the remains of your loved one is a pain I find impossible to comprehend. It is a pain that many families have to live with. I have known the Dorian family for many long years. They were a happy family unit living in the seaside village where my family has a retail business. I recall a lovely, well-mannered young child buying her 10p mixes on pocket money day. That pretty little girl was Lisa Dorian. Lisa had her life in front of her. She would go on to have dreams and aspirations and a determination to succeed in life. Fast forward to a dark day in February 2005. 25-year-old Lisa was attending a party in a caravan at a park in Ballyhalbert. This was the last sighting of Lisa alive. Someone was responsible for her death, and some people were responsible for disappearing her remains. The people who carried this out were people that Lisa may have considered to be her friends. Despite the best endeavours of the PSNI, no one has been charged with her killing, and no information has been forthcoming that would help return Lisa's remains to her family. I know that her family appreciate the sterling efforts and the resources that the PSNI have committed to trying to find Lisa. I watched the devastating effect all this had on her loving family, her mum, her dad, her sisters and the extended family circle. They supported each other and to this day continue to do so. Lisa's mum, Pat, never recovered from the tragic loss of her daughter and died of a broken heart without being able to lay her daughter to rest. Pat was another victim of this crime. I don't believe that the Dorian family care if someone gets 10 years or 20 years in prison if anyone is ever convicted of this cruel, heartless murder. Their only prayer is that they can finally give Lisa a Christian burial and know that then she can rest in peace. I don't know how anyone involved in this crime can sleep easy in their bed. Maybe they will wake up one morning and do the right thing. Unless they do, the demons of what they did will haunt them to their grave. I only know the Murray family through the media and haven't met them recently in a meeting. They have seen the killer of their loved ones convicted and sentenced, but still crave the return of Charlotte's remains. Charlotte was a twin with her sister Denise. I have twin daughters and I have twin granddaughters. You have to live with twins to even start to appreciate the bond enjoyed by them, and I know that the loss of a sister will be especially and deeply felt by Denise. These families just want one outcome. It is not revenge. It is the return of their loved one's remains. The implementation of Helen's law would offer them hope of such a conclusion. Without this law, their hope will continue to be hollow. Helen's law may not provide what they seek, but it will concentrate the minds of those convicted of a killing where no body is available. I cannot support the amendment from the Alliance Party because I don't believe it will help families like the Murrays and Dorians and others find the closure that they seek. Mrs Armstrong raises issues around the motion, but there will be future opportunities to fine-tune any legislation that eventually comes forward to this House. I find it disappointing today that this House cannot feel able to rally around this motion in unity. Thank you, Mr Speaker.
I'm going to call Paula Bradshaw.
Thank you, Mr Speaker. I rise to support the amendment. Clearly the motion has considerable merit and I commend the proposers for bringing it forward. It is a very important topic. We cannot fail to be touched by the anguish felt by the families of Lisa Dorian and Charlotte Murray, and we are also filled with admiration for the families' campaigns in theirs and others' memory. No one should be in any doubt that we are all fully in favour of a process which requires cooperation in locating victims' remains to be considered as a fundamental part of parole, and work is ongoing to strengthen that. To be clear, therefore, our amendment is designed to strengthen the motion further by outlining the steps necessary to achieving a legally watertight route to ensuring cooperation in finding remains and identifying victims that forms a statutory part of the parole process, and thus maximising the chance of locating the remains or at least knowing what happened to them. To rob someone of their life and then to rob their loved ones even of the knowledge of their remains is despicable beyond words. That is why we welcome the bill passing through the UK Parliament currently, known as Helen's Law, and the support for it expressed by this chamber today. And we want to see similar steps taken here in Northern Ireland, but we also feel it is essential to outline how these steps will be taken. We recognise also that we must move carefully, but also quickly. We've seen too many other instances of trauma being exacerbated by political action in this House, and I think Paul Free referred to that earlier, and this must not become another. The amendment is also important because it emphasises that we already have the benefit of seeing the route forward adopted in England so as to ensure it is legally watertight. A lot of work went into Helen's Law, and it does need to be emphasised that what is required is cooperation in locating remains or in identification before release. However, that is not quite what the original motion goes on to say. It does not reflect exactly what Helen's Law delivers. To try to do something which is in effect what Helen's Law delivers, as implied by the final part of the original motion, would inevitably mean greater complexity and more time taken up. It is in no one's interest, and it is again why the amendment is important, so as to make what we are pursuing legally watertight and deliverable as quickly as possible. We need to be clear that any Charlotte's Law would deliver the same as Helen's Law, namely that, quite correctly, significant weight would be given by the Parole Board to non-disclosure. We do also need to be very aware, given that we do not know when a similar case might occur, that even a swift legislative intervention to deliver a Charlotte's Law would be unlikely to fit into the legislative programme during the current mandate. This means years could pass with no change. This is not something the Minister, I nor my party colleagues are prepared to wait for. That is again why the amendment is important. We will consider all means of ensuring the Parole Board gives significant weight to non-disclosure so that the family's objectives can be met. And if we can get there by any means in the next few months rather than the next few years, that is what we will do. Mr Speaker, with that in mind, it is highly unfortunate that the COVID situation has impeded a formal meeting between the Justice Minister and the families. I am assured that one will take place urgently as soon as it is feasible.
That will be the best way for the families to outline just how important our campaign is for a sense of truth and justice, and also for the Minister to outline the many steps she has already taken towards achieving this and ensuring that disclosure forms a part not just of the parole, but also of enhancing the prospect of finding out what happened to their loved ones. Having a debate such as this helps the process of detailed consideration of the most appropriate and most efficient way towards the interests of families who have suffered such appalling grief and trauma. That is why the motion in itself a useful step, as it prioritises the issue and helps clarify many of the issues around it, and why we hope the amendment enhancing the motion will make it legally secure. In closing, Mr Speaker, what we want to see is support given to the Minister today so she can move as quickly as possible on this issue. We would like unanimous support for our amendment. Thank you.
And I call Rachel Woods.
Thank you, Mr Speaker, and I welcome the opportunity to speak on this very important issue today. Many members have already spoken about the horrendous pain and anguish suffered by the families of Lisa Dorian, Charlotte Murray and others who have been denied the right and dignity of laying their loved ones' remains to rest. And I would also like to send out my heartfelt thoughts and sympathy to those families today and express support for the continuing campaigns of justice and reform for the law to put specific parole guidance relating to non-disclosure on a statutory footing. Lisa Dorian, has been said, a young woman from Bangor in my constituency, went missing in 2005 and her body has never been recovered. So far, the PSNI have arrested 10 people, but no one has been charged in relation to her disappearance because her remains have not been recovered and evidence is limited. According to media reports, the police have pursued more than 3,500 lines of inquiry and conducted roughly 400 land, air and sea searches. Throughout all this, her family continue to suffer and bear the burden of severe emotional strain, not knowing what happened to her. On the 15th anniversary of Lisa's disappearance, the PSNI stated clearly that they've always believed that a small number of people hold the key to finding out what happened, and I would urge any of them to come forward to the PSNI. Charlotte Murray's family have also suffered terribly since her disappearance in 2012. After a jury convicted the man who murdered her last year, police drained a local quarry to search for her body, but nothing was found. In his sentencing remarks, Judge Stephen Fowler QC recognised the devastating impact of not being able to lay Charlotte to rest had on her family. He noted that the non-disclosure of remains has caused and will continue to cause the family considerable pain, distress and hurt. Judge Fowler also stated that he regarded non-disclosure as the most serious aggravating feature of the case. Therefore, there is clear need to reflect this in law, and I would welcome the Minister's comments, not just around the introduction of a bill equivalent to Helen's law in England and Wales, but also her thoughts on how the sentencing review will address the small number of cases where non-disclosure is an issue. I would like to pay tribute to Charlotte's family for their campaign and introduce legislation equivalent to Helen's law in Northern Ireland, and I hope that the Minister will be able to bring forward changes that will also reassure and support the family of Lisa Dorian in their continuing battle for justice. The Prisoners' Disclosure of Information About Victims Bill, otherwise known as Helen's Law in England and Wales, places a legal duty on the Parole Board to consider non-disclosure of the location of a victim's body when considering release. And it will also apply to offenders who refuse to reveal the identity of victims where they have been convicted of taking indecent images of children. Parole Board guidance states that offenders who withhold information can be denied parole if they are deemed to still pose a risk to the public, but guidance is guidance. Helen's law makes it a legal requirement for the Parole Board to consider the withholding of information when making a decision on early release. Human rights legislation protects against indefinite detention, and the sentence handed down in a court continues to apply, so the proposed new law in England and Wales strikes a balance between the need to further protect the public while guarding against disrupting the independence of the judiciary. We must, as an Assembly, and I'd also put it to my Justice Committee colleagues, why can't we take on this work as Justice Committee? Perhaps the Chair of the committee could address this in his remarks, which will be coming later on. But we must, as an Assembly, do all we can to improve confidence in the criminal justice system. And legislating for this change would provide a more consistent approach for victims and families. So for Lisa, Charlotte, their families and many others, this is the very least that we can do.
Thank you, and I call Jerry Carroll, and the member has about 3 minutes.
Yep. Thank you, Mr Speaker. I want to begin by expressing my deepest sympathies with the families who live today without the knowledge of the location of their loved one's body. The families of Lisa Dorian and Catherine Murray as well. Those who are stripped of the ability to bury their dead and who must face unimaginable anguish at the person who knows that information will not offer it up. This places an impossible block on their ability to come to terms with the untimely passing of their loved ones, and it's right that we acknowledge their reality today, as many and most speakers, all speakers have. Mr. Speaker, Helen's law, which today's motion refers to, would legally ensure that parole officers must consider the withholding of a victim's location in mind when they're making a judgment about their release. It is backed obviously by Marie McCourt, who does not to this day know the location of her daughter Helen's body and has lived with that pain for many, many years. From what I am aware, Mr. Speaker, and like others have mentioned it, parole officers already take this information into account. Though, as the amendment suggests, the Minister will consider legislating for this when stakeholders have been engaged, and we will support the amendment as such for those reasons. We cannot, Mr. Speaker, however, support the motion in its original form. The imposition of a sentence without the option of parole has been questioned in multiple courts internationally and has been as being incompatible with human rights, and a blanket ban on parole like this potentially, Mr. Speaker, removes any semblance of, in specific cases, of context or any attempted rehabilitation. And undoubtedly there are a lot of painful cases in relation to the issues we are talking today, and we have seen many families speaking bravely in the last number of weeks. But to impose a law which denies parole for a subset of people, regardless of context or extenuating circumstances, I believe is not the appropriate solution, and it's easy to envisage how that kind of law could have undesirable consequences. And Mr. Speaker, it's not for us here to determine, I'm certainly not in a position to determine whether or not any individual is ready for parole, but it is the job of the Assembly, when laying down a law which will be used to determine parole, to guarantee that there is room for extenuating circumstances, context, and the foundation of laws relating to the justice system should be rooted in rehabilitation. And this motion, Mr. Speaker, if adopted, were the Justice Minister to adhere to it, we would run horse and cart through those important principles. And I'm concerned generally, Mr. Speaker, when there's debates about crime and criminal activity in this House, there seems to be an approach primarily to automatically push for harsher penalties, to ignore or curtail the benefits and the possibilities of rehabilitation. I just want to say that point generally. So I think my time is up, Mr. Speaker, so I'll just leave my comments there. Thank you.
Okay, thank you. And I call the Justice Minister Naomi Long, who has 15 minutes to respond.
Thank you, Mr. Speaker. And I first of all want to welcome the Assembly's interest in what is a very important issue. Firstly, I want to echo the words of other members in paying tribute to the family of Charlotte Murray for their courage and commitment in pursuing their campaign for change. Charlotte was a loved daughter and sister who was cruelly taken away from her family. Her killer has been convicted, but he has refused to say how she died or where her body is. We all share that pain of Charlotte's family, the pain of not being able to lay her to rest, the pain of not having somewhere to mark her life and her death, the pain of not having the opportunity to lay flowers or to feel close to her. And I know that from speaking with them briefly last week, that this adds terribly to their anguish and their suffering. I would also like to pay tribute to the family of Lisa Dorian. For over 15 years, and despite numerous searches, they have suffered the anguish and despair of not knowing what happened to Lisa or where her body is. Bravely, they are supporting Charlotte's family in their campaign. And I would take this opportunity, Mr. Speaker, to call again on those who could help to bring an end to their anguish to do so now and without further delay. We must not forget, as we discuss this motion, that these tragic losses are a personal tragedy for them and will affect their lives forever. The bill, which is the subject of the motion and is currently before Parliament, makes changes to prisoner release provisions in England and Wales. It places a statutory obligation on the Parole Board in England and Wales to consider non-disclosure of information on where or how an offender disposed of the victim's remains or about the identity of children in indecent images as part of their assessment as to whether or not such an offender should be released on licence. These release provisions will apply to those who have been convicted of murder or manslaughter, those serving a life sentence or an extended determinate sentence, and where the Board believes a prisoner seeking parole has information about those matters. The Board must also take into account what, in its view, are the reasons for the non-disclosure. For example, it must weigh up whether, due to the passage of years or illness during their time in prison, the prisoner is uncertain of the details or where they are making a deliberate decision not to disclose that information. It is then for the Parole Board to decide what bearing this has on the risk that the prisoner poses and whether that risk can be managed in the community. It does not and is not no disclosure, no parole, which members have repeatedly suggested throughout this debate. Under Parole Board guidance, these are matters which are already taken into account as part of the Board's risk assessment of a prisoner's suitability for release. The main effect of the bill, therefore, is to place existing Parole Board guidance on a statutory footing. It does not place any obligation on the Board to withhold release where the prisoner withholds information. The assessment of future risk is the determining factor in release decisions for the Parole Board, as it is for the Parole Commissioners in Northern Ireland. Article 46 in Schedule 2 of the Criminal Justice Northern Ireland Order 2008 set out the powers of the Parole Commissioners. This legislation confirms that the Parole Commissioners must be satisfied that it is no longer necessary for the protection of the public from serious harm to detain an individual in prison to reach such a decision that a prisoner should be released on licence. I should clarify here that the Parole Commissioners are involved in release decisions where an offender has been sentenced to a life sentence or an indeterminate or extended custodial sentence. These public protection sentences were introduced in the Criminal Justice Northern Ireland Order 2008. It is important to note that offenders convicted for taking or making indecent photographs of children under the Protection of Children Northern Ireland Order 1978 will only have Parole Commissioner involvement in their release decisions where they have been assessed as dangerous and have been sentenced to one of those public protection sentences. These sentences were also introduced in the 2008 order to replace the earlier arrangements where prisoners were released on remission at the halfway point of their sentence with no ongoing responsibilities for supervision. The Parole Commissioners have no role in the release of prisoners serving normal determinate sentences, which consist of a custodial period and a period spent on licence. The length of both periods is set by the court at the time of sentencing. For these sentences, the Commissioners only become involved in the re-release of offenders who have been recalled to custody for the breach of licence conditions. Before making a release decision, the Commissioners assess all information relating to the offence for which the prisoner was sentenced and all information relating to the offender during his or her time in prison, including any progress towards rehabilitation and their acceptance of guilt. I understand that there have been no cases as yet where the Parole Commissioners have had to consider the non-disclosure of victims' remains or the identity of children in indecent photographs as part of the parole process. But if such a case arose, it would be an important factor in consideration of release. It would be for the parole panel to decide what bearing non-disclosure and the reasons for it had on the risk that the prisoner poses and whether that risk can be safely managed in the community. A lack of acceptance of guilt, non-disclosure of the location of remains, or non-disclosure of the identity of children in indecent photographs could be considered as an indication that the prisoner has not addressed their offending behaviour, that it shows lack of insight, remorse or empathy, and that it could lead to a conclusion that the prisoner still poses too high a level of risk to be released. The Parole Commissioner Rules 2009 underpin the parole review process. These provide significant discretion to the Commissioners to direct information from any party to inform the parole review and consider applications from any person to be a witness in the parole review process. The Commissioners are not constrained in what they can consider in their assessment of risk, including the views of victims and their families. Currently, victims who register with any of the 3 victim information schemes the Prisoner Release Victim Information Scheme, the Mentally Disordered Offenders Victim Information Scheme and the Probation Board for Northern Ireland Victim Information Scheme are notified of parole reviews and can apply through my department to the Commissioners to be considered as an interested party to those proceedings. Where this is approved and agreed, victims and their families may provide written or oral statements on the impact of the offence and, if applicable, provide views on the potential release and licence conditions of the offender. As you will be aware, Mr Speaker, it is my intention to look in the autumn at the potential of a Victims of Crime Commissioner, which I would be minded to introduce. I see one of those roles as to increase the uptake of those existing rights, because currently there is very low engagement with families beyond the point of sentencing. That needs to be looked at carefully as to why that is the case. Victims registered with the schemes are also notified about parole review decisions, but currently this is limited solely to whether the decision is to release the prisoner on licence or for them to remain in custody. I think we can do more in recognition of the importance to victims and their families of the parole process and its outcome. Where offenders are released, I appreciate that victims and their families can feel powerless and frustrated when they do not know the factors underpinning such a release decision. This autumn, I will be tabling an amendment to the Parole Commissioner's rules to provide that registered victims, instead of receiving notifications solely of the outcome, will be notified of the factors that have been relied upon to inform the Parole Commissioner's decisions. This will be an automatic right for registered victims, regardless of whether or not they have submitted a statement to the parole review. It will also provide a platform for legal challenge if victims or their families consider the decision was unreasonable, unfair or unlawful. This is an important change that will, if accepted by the Assembly, significantly enhance the transparency of the parole review process. However, and most importantly in my mind, I hope that it will help victims and their families feel that their role in that process is fully recognised and acknowledged. I will appreciate that the pain and anguish they feel does not end when an offender is sentenced. Those offences have changed their lives irrevocably and have changed their future. What must it be like to have a dearly loved member of your family murdered but never know how they died or where their body is? To wonder but never know whether your child had been abused? Those thoughts haunt victims and families daily. I realise that to be told the offender will be released into the community must be distressing for victims of all serious offences involving life sentences or public protection sentences. The least victims deserve is to be told the rationale for those decisions. I believe that this will be a positive step which will help victims have confidence in the parole process and the decisions of the Commissioners, who I know are very aware of the weight of their responsibilities. However, I appreciate that such a change does not address the specific concerns of the families of Charlotte Murray or Lisa Dorian, or members who have spoken so passionately on this matter in the Chamber today. I appreciate, having listened very carefully to all of the contributions today, that some members believe that a refusal to disclose information should mean that parole is automatically denied, or that Helen's law indeed will make this the case in England and Wales. That is incorrect. While I can understand such views, I think it is important that the discretion of the Independent Parole Commissioners is maintained. They already have the onerous task, when considering such cases, of weighing the account to be taken of non-disclosure and any reasons for it in consideration of release. I will.
Thank you, Minister, for taking the intervention. Just in relation to Helen's law and Mr Beattie's suggestion that there could be an LCM, I think we discussed here in the Chamber this morning that we are much better to make our own legislation, and that's not to take away from the work that has been done. And in relation to the Domestic Abuse Bill, we have looked at Scotland, we've looked at the Westminster Bill. We do consider them, but I think it is important that we make our own legislation here in this Assembly. I
thank the member for her intervention. I'm actually going to come on to that specific point. It isn't an easy task, and I'm very conscious that should release be conditional on disclosure. It is possible that with the passage of time, such disclosure may be highly fallible and inconclusive. It could also potentially have the unintended consequence of encouraging disclosure of inaccurate information in order to become eligible for consideration, and it should be remembered that some offenders may be particularly manipulative and wish to inflict more pain on the families, and that should not be forgotten. Incorrect information would be particularly harmful in the case of the identity of victims, in the case of indecent images of children. In the case such as that of Vanessa George, to which another member referred, it is also possible the prisoner either may not have or be sure of the identities of the children and could incorrectly name individuals who are not those children who were in the images, and that could cause additional anguish to parents and children alike. Punishment is one of the purposes of sentencing, and it is for the independent judiciary to determine the appropriate sentence. The parole process, however, is not designed to be punitive, but is about managing risk. The issue of non-disclosure is already considered by the judge in determining the appropriate tariff or sentence. For example, in Charlotte's case, this was considered to be the most serious aggravating factor when the sentence was determined, as members have reflected. That is directly accounted for in the calculation of sentence, or in the case of life or indeterminate sentences, in calculation of the tariff. Where a sentence is imposed that requires release decisions to be made by the parole commissioners, that forms part of the sentence. This aspect is made clear to the offender at the time of sentencing. It is at point of sentence that punishment is applied, Mr. Speaker. We have a long legal tradition that the latter parole stage is focused on assessing the risk to the public in any release, and it would be a significant departure from this to use non-disclosure for punitive reasons. As I have said, the legislative test for the parole commissioners is that it is no longer necessary to protect the public from serious harm for the prisoner to remain in custody. The parole commissioner's role is to implement the release provisions of the sentence and decide release on the basis of risk. To do otherwise would be a fundamental change to the basis on which release decisions are made and could have unintended consequences. The motion calls for introduction of legislation similar to the bill in England and Wales. As I've already highlighted, the bill does not, as some seem to think, equal no disclosure, no release. It simply puts current parole review processes on a statutory footing. So it will be considered, but it is not determinative. It's also important to note that what is legislated for in England and Wales is not necessarily appropriate for Northern Ireland. Before considering any change along such lines in Northern Ireland, I want to give very careful consideration to the need for change, if change is appropriate, and how that can be best tailored to ensure that it is right for Northern Ireland. Our sentencing structures, the structure of our parole commission, are all quite distinct and different to those in England and Wales, and an LCM would not be appropriate in this case. I would caution members today, of all days, to be wary of the allure of speedy changes to the law. The potential for unintended consequences, as well as intended ones, are significant and far-reaching. It is right that we consider very carefully any proposed change in the law before embarking on that process. That is why I have already asked officials to initiate a focused engagement with relevant key stakeholders, including, but not limited to, members of Charlotte and Lisa's families, with whom I will also have a further meeting soon, the parole commissioners, the probation board and prison service. I also want to give careful consideration to the points raised by members of this Assembly today and review the debates in England and Wales on Helen's Law. This will enable me to determine how we address families and members' concerns in the most effective and most appropriate way possible in Northern Ireland. I intend this exercise to be completed in as short as possible period of time, and I'm glad to say that work has already begun. The work is being carried out alongside the work currently being undertaken to complete the sentencing review, recognising, of course, that the role of the parole commissioner sits apart from the sentencing process. I will advise members and Charlotte and Lisa's families of my conclusions on a way forward later this year. Thank you, Mr. Speaker.
Thank you very much. And I now call John Blair to wind on the amend, and the member has 5 minutes.
Thank you, Mr. Speaker. Winding on the amendment, I firstly want to echo the sentiments of other members in applauding the family of Charlotte Murray for their courage and commitment in pursuing their campaign and to see change. Charlotte was a loved daughter and sister who was callously taken from her family, a family who have endured unimaginable suffering, the pain of not being able to lay their sister to rest, the pain of not having a place to mark a daughter's life and death, pain for most of us which would of course be inconceivable. I would also like to pay tribute to the family of Lisa Dorian, who through their own grief have bravely supported Charlotte's family in their campaign. For over 15 years, Lisa's family have suffered anguish and despair of not knowing what happened to Lisa and have never been able to lay her to rest. As we move to vote on the proposed motion and the amendment, we consider that these malicious acts are a personal tragedy for the families and the friends of Charlotte and Lisa, and these tragic losses will, of course, affect their lives forever. As I wind up the debate, I want to re-emphasise the comments of my colleagues earlier, Kelly Armstrong and Paula Bradshaw, when they reflected there is not sufficient recognition of the importance to victims and their families of the parole process and its outcomes. And in situations where offenders are released, victims and their families can understandably feel powerless and frustrated when they do not know the factors underpinning a decision. But I appreciate, having listened very carefully to all of the contributions today, Mr Speaker, that some members believe that a refusal to disclose information should mean that parole is automatically denied. While I can understand such views, I think it's important that the discretion of the independent parole commissioners is maintained. They have the onerous task when considering such cases of weighing the account to be taken of non-disclosure and any reasons for this in consideration for release. Mr Speaker, this is not an easy task, and I am conscious that should disclosure be conditional on release, it is possible that with the passage of time, such disclosure might be highly fallible and inconclusive. Time, however, does pass, and there might be uncertainty about identities and locations. These are practical and legislative challenges, and they're real. They are matters that can be addressed in the sentence review process initiated by the Minister and currently underway. I now want to, Mr Speaker, time permitting, reflect as best I can on the contributions of members. I will not, I don't think, have time to do that individually, but I will try to reflect on contributions in a cross-party way. Alex Easton, opening on the motion, stressed the non-political background of the motion, the background to Helen's law. He also spoke eloquently of the grief and trauma for families. Kelly Armstrong, proposing the amendment, pointed out that she believed the motion went beyond Westminster legislation and cautioned on potential disparity between the sentence handed down and that served. Linda Dillon spoke in support of the amendment. She said it could be a beginning of a process to deal properly with these crimes. Sinead Bradley for the SDLP spoke in support of the motion and spoke of unimaginable pain for families and then turned to whether or not disclosure is deliberate. Doug Beattie spoke then of the existing role of the parole board, uncertainty of a family not knowing when a killer will get parole. Rachel Woods spoke on the detail of the sentencing review and that she would like to see some information on that, and also referred to hope for change. Jerry Carroll referred to quite some extent to the current parole process. We've since heard from the Minister, who spoke of the bills in question, detail of current processes and, of course, the time frames involved in those as well. I would, Mr Speaker, before I close, want again to express my sympathy to the families of Charlotte and Lisa for the pain and anguish they have suffered. I would urge that we follow processes already in place to achieve a good outcome, and I would encourage members to support the amendment.
And I call Paul Given to conclude and wind up the debate on the motion, and the member has 10 minutes.
Thank you, Mr Speaker, and can I thank all members for taking part in this debate this afternoon. I think, given the breadth of contributions that we've heard from around the House and all of the different parties that have taken part, is a demonstration of how this issue does touch upon all of our constituents and is an issue that we all care passionately about. And I don't for one moment call into question the sincerity of anybody's motives in terms of what they have said, and nor should anybody call into our motives. And some members did talk about politicking, and I don't think that that's appropriate, and I wouldn't say that about those that have tabled the amendment, even though I disagree with the contents of the amendment. I want to pay tribute to my colleague Alex Easton for bringing forward this motion. This is something that he has spoken to me extensively about. He has pursued for a long period of time and has engaged with the First Minister, who supports these endeavours, and has engaged with the families. And I want to pay tribute to Alex for the work that he has done in respect of this. I want to thank the Dorian and the Murray families for the way in which they have given voice to this issue. We can often debate legalistic points, but whenever families speak, they speak powerfully, and that often resonates with the public in a way that often politicians are unable to do. So I want to pay tribute to them. I thought Alan Chambers brought that personal connection to members very well when he spoke about Lisa coming in as a little child and buying the 10p mix-up from the shop, and that, I think, hit home to members about the real personal aspect of what it is that we're talking about, and the absolute tragedy for that family who still haven't been able to get justice in any shape or form. And I would join with members that have called for that information to come forward so that the families can get some justice in respect of that issue. Whenever members spoke about this, they spoke about the coercive nature of the perpetrators, the continued desire to inflict further pain upon the families. Dolores Kelly, Sinead Bradley, Paul Frew mentioned these different aspects, as did other members, and how true that is and how appalling it is that not just enough to carry out the murder or to engage in the sexual abuse of children that paedophiles engage in, but to then withhold information that could lead to the identification of the remains or to those victims, speaks to the kind of evil that exists for the people that carry that out. And that's why we need to have a system in place that can address that and undermine the kind of power that those perpetrators seek to inflict. And so I'm concerned whenever I heard members speak about the rights of the perpetrator in that context, and that human rights compliance when it would come to what we're seeking to do. I think that does a disservice to those that believe in true human rights whenever it's used in that way. I do disagree with the arguments that were being put forward in respect of those concerns that members articulated. Kelly Armstrong made reference to not being human rights compliant, outlined reasons why we shouldn't be supporting the motion, spoke of concerns about accidental, indefinite detention, which of course Sinead Bradley addressed when she spoke about the deliberate withholding of this information and the safeguards that would be there to address those things. And Kelly Armstrong went on to say that politicians should not be able to interfere in sentencing. My, politicians shouldn't be allowed to interfere in sentencing. The judiciary set the sentence based upon a sentencing framework that politicians set. I don't believe for one minute we should be involved in saying X deserves this sentence, but we set the framework that the judiciary operate in. And so it's important that politicians do engage in this issue and don't dispel their responsibility to others. She made reference to the Minister's consultation. That's good. She made reference to the review around sentencing framework. Again, that's good. We would like to see it commissioned back in 2016. We still haven't seen progress in respect of that coming forward. And so this motion, I think, sends out that very clear message and signal that we want to have action. We want to see the Minister for Justice lead on that. That will not absolve the Justice Committee of stepping up in the absence of the Justice Minister stepping up. We will have a miscellaneous provisions bill hopefully come in due course, and that will give opportunity for not just this issue but other issues members have raised in this House to be taken forward through that bill. But it shouldn't be for backbenchers at a committee to lead on this. The Justice Minister needs to lead on this, and that's why this motion calls upon the Justice Minister to lead on it. And so I was concerned when Kelly Armstrong again made reference to this will just be a non-binding motion if it's passed. Members shouldn't lightly dismiss a motion passed by this Assembly because it mandates and calls upon action by those that are named in it. And this motion calls the Minister to take action. And I'm confident that the Alliance amendment isn't going to be successful. And therefore, I hope that the attitude that was displayed by Ms Armstrong is not one that is taken into account by this Minister, and that we're going to see actions brought forward. The Minister mentioned in response that the sentence takes into account this as an aggravating factor. Just to remind members, the murderer of Charlotte Murray got 16 years. That's all. 16 years.
Sentence and a tariff of 16 years. There is a distinct difference The tariff is the first point in the sentence where a person can apply for parole. The sentence is life, and it is life because even when he is released, he will continue to be a life sentence prisoner.
He got 16 years to serve in prison. So we minimum, but this is the point that we're making. 16 years to serve in prison, and then the conditions for release. We're talking about those conditions for release, that he shouldn't be released if there is not disclosure. And so the Minister's response to this gives me even further concern that she's not listening to what members are saying. So this is why the motion needs to be passed. Is it a point of order?
It is a point of order.
Sorry, let's both. Sorry, take a seat. Are you making a point of order?
Order. I am listening carefully to what members say, and I do not appreciate my position being misrepresented by others in the chamber. It is unhelpful to do so. But what I am doing is conveying accurately how sentencing works, and that is my duty as the Minister of Justice. So that has to be clarified for the record, Mr. Speaker.
Thank you for putting on the record, but that has been made in your own remarks earlier. So continue, Mr. Gibbon.
Thank you, Mr. Speaker. I would just say to the Minister not to be so defensive when members raise issues. We're doing it in a spirit of wanting to see progress being made, and the Minister doesn't always need to be so defensive when it comes to members raising these points. So, in seeking to wind on this, Mr. Speaker, I do believe that we need to send out a very clear message. I'm on the side of the victims. I believe everyone in this House is on that side of the victims. I believe we need a very clear process to get them the kind of justice that they need. And I believe we need to send a very clear message to murderers and to paedophiles in this society that if you don't disclose information, you shouldn't be released. And so I am wanting to go further than Helen's law. The motion makes that clear. It says it for members to see that we want to see, just to get the precise wording of it, to ensure that prisoners convicted of murder and child sex offences are not eligible for release until they disclose the location of their victims' remains or identity. That's what I want. And so, be in no doubt what it is that this motion is speaking to. And I would just say on the amendment that the Alliance Party have put forward, the families can say this better than I can, and maybe the Alliance Party will reflect on it. And I would appeal to them to listen to the families and not to move their amendment and try and come with where the majority of people are. But they said in respect of this amendment that we received through correspondence that the Alliance amendment has caused considerable upset for both families. We would strongly urge you to reject this proposed amendment as the content weakens the original motion and diminishes the level of justice that we seek. So I would appeal to members to reject the amendment and to support the motion. Thank you, Mr. Speaker.
Okay, thank you. And the question is that the amendment standing in the names of Kelly Armstrong and Paula Bradshaw be made. All those in favour say aye. Contrary, no. No. I think the ayes have it, but whilst we have social distancing in operation. Sorry, the noes. Sorry, the noes, and therefore then the amendment would fall. But given the issue around social distancing, I just want to remind members it's not always entirely simple to declare a vote passed or failed. So I'm going to ask it again, and if there are any dissensions, I will divide the House. So all those in favour of the amendment say aye. Contrary, no. No. I think the noes have it. The noes have it. Okay. On that basis, then the question is that the motion, as amended, be agreed. All those in favour. Sorry. The question is that the motion standing on the order paper be agreed. All those in favour say aye. Aye. The contrary, no. The ayes have it. The ayes have it. Thank you, members. Moving on. Item 5 on the order paper, the adjournment. The question is that the Assembly do now adjourn. The Assembly is adjourned. Thank you.